Hello, everyone, and welcome to Uncivil Law. And for today's story, we have a new bombshell that's been dropped by Turtleboy relating to his case that has potential implications with respect to Karen Read's case. So we're going to read this article, which I believe is from Turtleboy's website. It is called Turtleboy Daily News. So I believe it's Turtleboy himself who posted this. And we're going to read this article for its own value, try to discuss what he's talking about, and see what potential impacts it might have relating to the Karen Read case. But some pretty big allegations being dropped relating to corruption. Corruption in my Massachusetts case, it's more likely than you think. What are the potential odds? Given what we've seen so far with solo cups and leaf blowers and evidence logs and mysterious appearing pieces of taillight fragment and so forth and so on, and just, go through the list. Anyways, we'll cover this article from Turtleboy Daily News. This was entitled Canton Cover-Up, Part 508. I'm curious what the other 507 parts are, but we don't have time for that right now. Sworn affidavit alleges the Commonwealth agent, Katie Peter, was paid $1,500 a month, was bribed with a couch, got to get that couch, by Jennifer McCabe to spread disinformation about Karen Read while working directly with Hank Brennan and Michael Morrissey, otherwise known as the prosecutors. So the allegation is we have a paid person paid by the government, which therefore would make them an agent of the government, incidentally, regardless of whether they're a private person or not, as long as we want to learn something of legal value. So once the line between where someone becomes a private person, someone becomes a public agent, can be a little bit tricky sometimes. But long story short, if you're officially, let's say, if you're commanded or you are ordered by the government to do something and you do something on their behalf, then you're probably a government agent. This rule, by the way, exists at least in part to prevent the government from doing stupid things such as, you know what? I can't get that search warrant. I really would like to get that search warrant. The search warrant would make me happy, but I just can't get it. I don't have it. So what I'm going to do is I'm going to go all film noir and go to my friendly 1930s hard-boiled private eye, be like, Mr. Valentine, I've always needed the kindness of strangers, right? Employ this guy and he's going to do it for me because he's not a cop, right? He's just a private investigator. Yeah, no, we're not that dumb. Thankfully, we are not, in fact, that stupid. So if the government does that kind of thing, yeah, they become a private agent. Or apologize, they become a public agent. And where that can happen, and that also incidentally has implications with respect to the First Amendment, for example. Although it's a little off point, again, as long as we're trying to learn something of legal value, you may recall there was a time in the not too distant past when there was allegations that companies like Facebook and other social media were, let's say, making decisions on what kind of content to take down or what kind of content to favor, particularly as it related to certain viruses that were in the news a couple years ago and might have been working at the government's direction. And so there was a non-trivial argument that the companies such as Facebook, for example, became the government. And some people were trying to sue them under 42 USC 1983, which you can only sue the government under 42 USC 1983. And they were saying, well, Facebook is the government because of this coordination and so forth and so on. So you get into fun territory relating to that, which is a little bit beyond our scope. For the purposes of today's exercise, we'll simply note that if they're being paid by the government to do things on behalf of the government at the government's direction, they're probably the government, private citizen or no. Congratulations, you might be the government now. Exciting. So let's read a little bit more so we can understand what the factual predicate of this is and see what we think about what's going on here. Last October, this is Turtleboy writing, my attorney, Mark Bedrow, filed a letter with the court sent to the special prosecutor, Robert Cosgrove, detailing how Lindsay Ganetti's phone extraction revealed text messages showing that Ganetti, Katie Peter, disgraced State Trooper Leah Gensodo, Special Prosecutor Ken Mello, and Detective Lieutenant Brian Tully conspired to set me up for witness intimidation charges that led to 60 days of incarceration. We requested that Cosgrove respond to the bombshell allegations by providing us with discovery relating to Peter's communications with the DA's office, since he claimed under oath in court to be an agent of the Commonwealth. Since she claimed, rather. It's been 6 months and we received nothing. So today we filed a motion to compel the discovery. This included a sworn affidavit from a woman who's been friends with Peter for the last year and provide evidence that Peter, also known as Mafia Masshole, you're going to have to narrow that down. Masshole? Yeah, so you're going to have to narrow that one down. Which person do you mean? So many people it could mean. Anyways, has been paid off by the Norfolk County DA's office to spread misinformation. All right, so basically, long story short, we have evidence that we have obtained relating to a person who's providing a sworn affidavit relating to things they might have heard, also relating to some cell phone extraction stuff, also relating to some other things, and we have enough evidence, we believe, to ask the government to provide us any information they might have, and so far it appears the government has not responded, right? That's weird. The government could respond by saying, no, none of that stuff is true. Those are all lies. You know, that we don't know what you're talking about. Or they could say, well, it's kind of true, but it's been wildly distorted. Or they could say, no, it is true. But the no response at all is odd, right? I mean, you know, it might not be true, but the government apparently hasn't given any response. And that's kind of weird. So let's read this motion to compel. This is defendant's third motion to compel required discovery, so apparently not even our first time. Now comes Mr. Aidan Kearney, otherwise known as Turtleboy, and respectfully moves this honorable court, and again, it's worth noting, of course, this motion is in Turtleboy's case. So before we proceed, I want to clarify this point. At the moment, this motion only exists within the confines of Aidan's case, that is to say, Turtleboy's case. So at the moment, this has zero chance of impacting Karen Read because it is not filed in the Karen Read case. Now, maybe Karen Read will file something in her own case in short order, but of course, that doesn't appear to have happened yet. So at the moment, if your question is, what impact does this have on Karen Read? The answer to the question is zero. It has zero impact on Karen Read. But of course, that may not continue to be true, even including into tomorrow. But as of today, the answer is zero. As of tomorrow, who knows? But let's press on with what it is in its own terms. So anyways, we're moving for compelling of discovery, which has been requested from the prosecution multiple times since October 2024, and which disclosures required by prior orders of this court and imposed by the relevant rules. Yeah, I mean, duh. If they're a government agent, you're responsible for them. You can conscript a person into becoming a government agent, at which point you're responsible for them. So please tell us about whether or not they're a government agent and what you did or not, as the case may be. Specifically, defense has made 3 letter demands for ordered and or required discovery concerning quote unquote civilian, and I'm adding the quote unquote civilian part, Catherine Peter, who on information belief is working as an agent, which would make them not a civilian. Legally, right? I mean, the police aren't always necessarily the police. Just because you're a police officer and wear a cop uniform doesn't necessarily mean you're always the police in every possible context. Sometimes you're just a guy. Sometimes you're just a guy. The uniform, in fact, does not control your life every single waking moment of the day. And just because you're wearing a civilian uniform, as it were, does not necessarily mean you're a civilian every waking moment of the day. Maybe you became a government agent. Exciting and fun. I don't know whether or not that means that you can get a pension or retirement benefits. That'd be hilarious. It's like, yes, I'm a government agent. Also, I want my pension now. That'd be fun. But that's another issue for another day. In any event, Catherine Peter, who might be a civilian, might also be an agent. Although our first demand was made more than 6 months ago, the prosecution has neither provided the defense with any of the requested discovery, nor indicated that none of the requested items or information are within their possession, custody, or control as the prosecutor, which would be a perfectly valid response. That would be a valid response. We don't know what you're talking about. We have no clue. We don't know who's making up these stories. You know, people can say all kinds of bullshit. We've searched our records. We don't know anything. We don't have any records. We've got nothing. No response. No response is kind of sus. Why no response? That's a little sus. What's going on? Indeed, the prosecutors haven't responded at all to any of the demands made in October, twice, and March, all of which describe in great detail the good faith basis for our belief the prosecutors and evidence. You have to have a reason for asking. You have to have a reason to ask. Our reason for asking, well, we had some evidence logs, or we had some cell phone information that was obtained that appears to provide our basis to ask the question. So, seems like we've got enough to at least ask the question. Would you like to potentially answer us? Apparently not. Not even a we're not going to answer you, go away. Not even a go to hell response. Just silence. In addition to outstanding discovery demands referenced above, Mr. Kearney's defense has since received further confirmation that such evidence exists. So we have additional basis to ask the question. Significantly, this evidence is described in a sworn affidavit of an acquaintance of Miss Peter, a copy of which is attached. As detailed in the sworn statement of the witness, Miss Peter apparently has admitted to the witness that she has a long-standing relationship in which she assisted the Commonwealth in their efforts to prosecute Kearney and Reed. Miss Peter's relationship with the Commonwealth and its key witness against Kearney and Reed includes evidence that, among other things, and again, this is all hearsay, but hearsay is acceptable at this stage of proceedings. We're not in the middle of a court trial. Hearsay rules apply when we're at trial with respect to what witnesses can testify to from the stand. Hearsay rules aren't necessarily the same at other stages of proceedings. So is it hearsay? Yes. Is it reliable? You know, I suppose you could question that, but it's not categorically prohibited. But we've got some hearsay. So what we have is a person who says they heard some things. And this person says that with respect to Miss Peter, she apparently regularly speaks to and meets the Reed prosecutors, receives monthly payments from the Commonwealth in exchange for assistance. Have you received any money? Should be a pretty easy question to answer. Received items of value from a key witness, Jennifer McCabe, was granted de facto immunity from the prosecutor in exchange for assistance. Okay, that's a little sus. Again, you know, you just have to be, at the risk of stating the obvious, you just have to be honest. And the cover-up is sometimes worse than the crime. So can the prosecutor offer immunity? Sure, but they have to tell the defense that, because it might potentially, to a fact finder, be relevant information that could potentially cause the fact finder to potentially question the witness. Maybe, maybe not. Like, how much do you care about this person being given immunity? How much does it influence you? Maybe it doesn't influence you at all. But they have the right to know, and the jury has the right to know, so they can assess it and weigh it. Maybe they choose not to care. Like, it's fine. Maybe they choose to care a lot. She's a dirty government agent. You know, but either way, you gotta tell them these things. And you didn't tell them the things, and that's a problem. Also, apparently altered, destroyed, and or disposed of material evidence, including contents of her cell phone that would be favorable. No, you don't say. This is something completely we have never heard of before in the context of Karen Reed or Turtleboy. What witness might destroy cell phone records or delete a search or get rid of their cell phone or their SIM card, especially once they had knowledge that that information might be pertinent to investigation? What person would do that? We've never heard anything like that before. They must be making that up. There's no way any of that occurred, right? Right? Okay. Admitted her intent to start rumors about Mr. Kearney, purportable harassment of jurors to further the Commonwealth's unsuccessful effort to ban Mr. Kearney from covering the Karen Reed case, used her social media platforms to help the Commonwealth circumvent a gag order. Yeah, that could be a problem. Stalked, harassed, and spied on Mr. Kearney, Miss Reed, and one of Miss Reed's attorneys and supporters For what it's worth, by the way, the legal difference between stalking and like surveilling can get a little tricky in terms of what the difference on that is. Because, for example, a private investigator, which after all is just a person, and some states don't even require private investigators to be licensed. Some states do. But a private investigator is just a person. They're just a guy who does, police kind of stuff, but, privately. So, the ability to surveil someone without it being stalking can sometimes be a fun distinction. But we'll press on for that fun distinction for the moment and say that they might have been doing things, whether it's legal or not, is another day. And of course, even if it were legal, if they're doing it on behalf of the government, we still might want to know those things. So is it legally stalking? Maybe not. Is it something that if it's being done by the government, you might have a basis to know it? Maybe so. Please tell us more things. Admitted to Lindsay Gattinetti lied about a material fact relevant to her criminal allegations against Mr. Kearney. Specifically, according to the witness sworn statement, Ms. Peter admitted to her that Jennifer McCabe issued an ultimatum directly to District Attorney Morrissey in exchange for her favorable testimony against Ms. Reed. She wouldn't testify unless Turtleboy is in jail. Dun, dun, dun. Ms. Peter further told witnesses when Ms. McCabe was told the Commonwealth, so there's a couple levels of hearsay in there, but again, hearsay isn't necessarily a problem at this particular stage, but noted that it's a couple levels of hearsay. Ms. Peter further told a witness when Ms. McCabe was told that the Commonwealth can simply subpoena her, which is true. She implied that if her demands were not met, we would alter her testimony in a manner designed to harm the Commonwealth against Ms. Reed. And apparently, according to the footnote, according to information belief, Ms. McCabe used the term we means in addition to herself, other key prosecution to whom she's close would also not testify favorably to the prosecution. So apparently, if you believe that, she said that if you subpoena me, which of course the Commonwealth has every right to do, she's a witness, and she would be required to tell the truth, as one does, that she said that she would color her testimony or perhaps out and out lie about her testimony unless her demands were met, which incidentally would be illegal for her to do that, and illegal incidentally for the prosecution to offer them that incentive. So illegal by a lot of potential people. But I digress. Ms. Peter further admitted to the witness that on March 16th, 2025, she met with McCabe. Okay, thank you for randomly just scrolling to a different part of the page while I was trying to read nice website. That's probably my fault. Probably wasn't the website's fault, but we're going to blame the website because, blaming other people is always more exciting than taking responsibility. Anyways, where we were. Ms. Peter further admitted to the witness that on March 16, 2025, she met with McCabe and DEA Morrissey in Braintree. And when the witness saw Ms. Peter shortly after the meeting, Ms. Peter had a manila envelope with her. Exciting. Random manila envelopes. None of the foregoing items or information has been provided to the defense team by the Commonwealth, despite several prior requests, in addition to pre-existing obligations, which, of course, the prosecution has all kinds of ethical obligations just for them because they're the government. Based on the information provided by the witness's sworn statement and contents of our 3 previous letter demands, there's strong reason to believe there exists discoverable information and material in the Commonwealth's possession, custody, or control. Whether the Kearney or Reed prosecution team relating to Ms. Peters' involvement with the Commonwealth and or witnesses who will testify against Ms. Kearney. The prosecution also has a duty to inform each member of the prosecution team who they reasonably have believed to have possession, custody, or control of any item or information, then inquire as each person as to the existence. That is 100% true, and of course also extends to the police and also would extend to their private agents made government agents because they're now your agents. You made them your agents. So the prosecution would have a responsibility to inquire of their own team, to inquire of the police, and such private persons as they decide to conscript into their little effort. So that is 100% correct. You are not wrong. Thus, at a minimum, the prosecutor must address the issues raised in the affidavit and letter demands with Morrissey, Hank Brennan, Lally, McLaughlin, Miss Peter, Miss McCabe, Mello, Tully, and John Fanning. Also true. Just if it's not true, just say it's not true. Just respond. We have no idea what you're saying. None of this is true. We have no information and records. We have no clue what you're talking about. Just tell us it's not true. That would be a response. And then, if I want to fight you about that response, I can then fight you about it. But, you still have to give me an answer because you're the government. We have no clue what you're talking about. We have no records. We've never. Okay. And then maybe I can fight you on it. But can you tell me what you think? Apparently not. Any discoverable evidence then must be immediately collected and promptly disclosed to defense. This, of course, includes prompt disclosure of any evidence that the Reed prosecution team has in their possession, custody, or control, which adversely impacts the credibility of any witness against Kearney, otherwise favor him or cast doubts. And then we, of course, cite Giglio because, of course, that is the Supreme Court case that basically says exactly that. The Commonwealth's disclosure obligation to Kearney remains irrespective of any purported view of the evidence reliability, credibility, or admissibility, and without regard to whether the information has been documented in any manner. In other words, when subject matter is discoverable, prosecution must promptly disclose any information derived from conversations or interviews between or among Miss Peter, the relevant witnesses against Mr. Kearney, any members of Kearney and Reed prosecution teams, even if not memorialized in any way. Therefore, we want an order of production for the requested and the other outstanding discovery within 14 days, promptly schedule a hearing, issue an order to show cause, and other relief as may be warranted. Sincerely yours, the attorneys for Mr. Turtleboy himself. Exciting. And then we have the affidavit, the much alluded to affidavit of an unknown person, which, supposedly backs this up. So let us read this affidavit of whoever this is who would like to provide some information that might be potentially relevant to this. Again, this is an affidavit filed in the context of the Turtleboy case, so at the moment has no potential impact on Karen Reed, but that, of course, could change with respect to that. So what does it have to say? Now comes undersigned, some person, on oath and hereby states the following to the best of her knowledge, recollection, and belief. Under the penalties of perjury, the following. My name is somebody. My name is nobody. I reside in Massachusetts. I'm of age and competent to make this affidavit. I've been friendly with Catherine Peter, here and after Peter, for close to a year. I've had multiple conversations and face-to-face interactions with Peter. Peter volunteered information to me about Karen Reed case multiple times throughout our friendship. All factual representations below are from what Peter told me about her involvement in Karen Reed and Aidan Kearney cases. Also, of course, it is hypothetically possible that she could be an agent for the purposes of the Turtleboy case, but not be an agent for the purposes of Karen Reed, because they are, of course, two legally distinct cases. Now, there is some overlap there, and some of the witnesses do overlap, so that would be challenging in some situations. But at least it's hypothetically possible that she could be an agent for the purposes of Turtleboy, but not be an agent for the purposes of Karen Reed. So that's also notable in our legal analysis. There are slightly different issues. During Karen Reed's first trial, she's in regular communications with Adam Lally. At one point prior to jury deliberations, Peter met with Adam Lally for lunch. During this lunch meeting, Adam Lally told Peter he knows the foreperson who is a retired police officer, and he, the juror, is guaranteeing a mistrial. That's like 3 levels of hearsay, by the way. The witness heard from Lally, who heard from the police officer who knows it's like, that's like 3 levels of hearsay. So how reliable that is, we'll question, but that's okay. But we might know might know the jury foreperson who might have guaranteed a mistrial. Carrying on. She told me that she has paid $1,500 each month via Cash App for his assistance. Well, that's fair enough. Can we get the Cash App records? That would, distill that. Peter believes that Karen Read is innocent. Also, by the way, they used Cash App. That's just sloppy, man. Just give him unmarked bills in an envelope like a normal person at a dead drop. We're not trying very hard. I'm just saying. Peter believes that Karen Read is innocent, but she has to play the game. Okay. I interpret this to mean Peter's role is to publicly promote and advocate on social media that Miss Read is guilty. Well, that's a lot of inference. So that's conclusory. So not of particular value because all she said is play the game, whatever the hell that means. Peter opined to me that if anyone killed John, it was somebody who was an asshole, which, is just a random opinion. So of not particularly important value there. Peter is very close with Hank Brannon and has had multiple conversations and meeting with him. I personally heard Peter on the phone with Hank Brannon. Like it was on speakerphone? How do you know who she was talking to? Maybe she said Hank or something and you inferred it, but not quite sure about that one. During a phone conversation between Peter and Hank Brannon that I was present for and personally recognized Hank Brannon's voice. Okay, thank you for telling me. Peter told him that the people leaked it to the media, referring to the federal investigation being over. Okay. As of April the 15th, 2025, Peter's not directly talking to Hank anymore. We're using a third party to communicate now. Ooh, intrigue, fun. Peter states that she's untouchable because of everything she's doing to assist the prosecution, no matter what violations I'm charged with. Morrissey is keeping me out of jail. You hope. You hope. Get that in writing, man. Get that in writing. Peter asked me to go stalk Karen Read in the seaport. Peter asked you to go stalk Karen Read with her and stated that Karen Read stays at the Omni Hotel. She stated to me that we can take photos to sell to the Daily Mail, and she's done it before. Peter informed me that Jennifer McCabe bought her a brand new sectional as compensation for her assistance. We're getting paid in couches, man. Where are the couches coming from? Are they nice couches? Are they coming from Wayfair? Are they coming from where from the couches come? What kind of couch? I'd like to know about the couch more. I'd like to know the couch, and I'd like to have a picture of the couch so I can critique the couch as I previously critiqued the homes of 34 Fairview and 1 Meadows Lane on a prior stream. Also, apparently I do home improvement tips in my spare time. I want a picture of the couch so I can critique whether or not we're getting a good deal for our testimony. Did we at least get paid well for our testimony? I want a picture of the couch. Peter was told by Jennifer McCabe that Jennifer McCabe informed Michael Morrissey that she's not testifying unless Turtleboy's in jail. Michael Morrissey informed Jennifer McCabe that he would have to subpoena her, and Jennifer McCabe then told Morrissey that we won't say what you want us to say. If she actually heard them say this herself, and so she's a first person reporting witness, then, okay. If she actually overheard that, which seems to be what's implied, then that would be something. Peter then got rid of her phone the day after Aidan Kearney announced on his live show that he's looking to get personal communications of Michael Morrissey. Peter said to me that they'll never get the communications between me and Morrissey. Okay? The day that Peter showed up to protest at the Karen Read trial, Peter informed me that Jennifer McCabe paid me to show support. On March the 16th in 2025, Peter told me that she went to meet with Michael Morrissey and Jen McCabe in an undisclosed location in Braintree. When Peter returned home, she had a manila envelope in her hands. See, maybe we're getting paid in cash now instead of Cash App. Thinking ahead. Big brain, baby. Big brain. Manila envelope is the way to go. Peter has informed me that she's seen emails They're subject to a protective order between the Karen Read team and Jennifer McCabe. Peter reported to me that upon the request of Hank Brennan, she provided the spreadsheet of all the free Karen Read Facebook supporters to the Commonwealth for this upcoming trial. Okay. Peter told me that Hank Brennan is providing information to federal authorities regarding Karen Read and Aidan Kearney because he wants them in jail for the trial. I don't know how the feds would get involved in that, but all right. Peter told me that she's going to start rumors about jurors being afraid to serve because Turtleboy will go after them. And everyone is working overtime to make sure Turtleboy can't be in the courtroom for the trial. Peter admitted to me that she created the image of Karen Read and Alan Jackson embracing that was given to them by the Daily Mail. In early January, Peter and I were discussing the Lindsay Janetti case against Aidan Kearney. I mentioned something about Janetti being pregnant at the time, and Peter interrupted me saying Lindsay was never pregnant. I'm aware that Peter and Janetti were close friends in the past and working together against Mr. Kearney. I understand that I'm not represented by any attorneys connected to Aidan Kearney or the Karen Read defense teams. I'm turning over this information because it's important to know the truth of what's going on. I'm not being coerced or compensated. I'm doing this of my own free will. Signed, somebody who is unknown. So, okay, I mean, that affidavit has as much value as you think it has. But apparently she overheard conversations herself. She overheard and recognized the voice and heard apparently the prosecutor saying things herself, which would be firsthand information and would get you past a lot levels of hearsay. So now basically we only have one level of hearsay because now it's just her saying what they said, which would be an admission at that point because it would be a party opponent because the Commonwealth is a party opponent in this context. So now you just have one level of hearsay. So that's a lot more reliable. So we've gone from like 3 levels of hearsay to 1, which is a stark improvement. And then your only question is, well, how credible is this person? Which we don't know who it is, and we don't know other information relating to them or how they have been not credible or not. $5 from Dookie Stan. 616 says, you're killing on your diet, you're looking thinner, keep it up. Thank you for the encouragement. I really appreciate that. That's extremely nice of you. I'll also read some other super chats, by the way, to CHF, which I believe is Swiss, from Nina saying, can they make a FOIA? They could, but they don't need to. They have better tools than FOIA because they're entitled to discovery under other rules. So FOIA would be a waste of their time. The FOIA request would probably be denied because it relates to ongoing investigations and stuff. So FOIA is not your best tool. They have better tools than FOIA. But thank you for your super chat. I can't remember gifted 20 gift memberships. Lori Joe Woods became an uncivilian. And those were the super chats that came in today. Thank you for your contribution. All right. So let's continue to read on relating to this and specifically what they have to say. So Turtleboy now writing. Okay, then they quote that. And now we have a photograph of whatever. I'm not quite sure what that's a photograph of. Presumably some of the people relevant to this case, but it's not labeled, so I don't know who that is. Then we have another photograph. The identity of the woman who signed the affidavit was impounded to ensure her safety. She's been friends with Peter for the last year, having several face-to-face interactions and speaking on the phone about Karen Read and Turtleboy cases. Peter trusted this woman who she barely knows and volunteered information proving she's heavily involved. Well, I don't know about proving, but providing information that might be relevant there too. According to the source, Miss Peter met with Karen Read prosecutors for lunch, and Lally told her she knew the jury foreperson, Ryan Petrowski, was a former police officer who guaranteed a mistrial. Okay. And there apparently is the jury foreperson from the previous trial. I can't speak to the validity of that, but whatever. Miss Peter told the source. Come on. Miss Peter told the source that she sent $1,500 via Cash App every month for assistance in the Karen Read and Turtleboy prosecutions. Peter also confessed she believes Karen Read is innocent, but she has to play the game. Incidentally, why does she have to play the game is not clear. By publicly promoting and advocating on social media that Read is guilty. She told the sources she believes John O'Keefe was killed by someone inside 34 Fairview, whose name is redacted. The source was also present for a phone in which she heard Hank Brennan's voice while he was speaking with Peter. Miss Peter allegedly told Brennan that people leaked information to the media. The federal investigation was over, something that was reported by anti-Karen Reed Twitter trolls prior to Ted Daniel reporting the same thing. Peter told the source that due to her assistance of the Commonwealth's prosecution, no matter what violations I'm charged with, Morrissey's keeping me out of jail. It should be noted that Miss Peter is currently being charged with violating a restraining order against a victim she stalked and terrorized for a year. Again, what is legally stalking can get sometimes a little bit legally tricky. So we'll just note the characterization and say that, there is a line between like merely surveilling and stalking. But we'll let that pass for the moment. Not one, but two Norfolk County courts, Dedham and Stoughton, in addition to two felony witness intimidation charges. The source claims that Miss Peter asked a source to join her and go stalk Karen Reed. By the way, if you're interested a little bit more about like the difference between stalking and surveilling, I can note that by comparison that Aidan Kearney has been accused, for example, of witness intimidation. And just merely talking to a witness is not necessarily witness intimidation, right? Witness intimidation essentially boils down to force, compulsion, threats, bribes, or other corruption of a witness. But merely trying to interview a witness, it does not witness intimidation make. So again, that line between trying to talk to a witness, trying to interview a witness, is not intimidation necessarily. Now, of course, reporter or no, you could then step into intimidation. So just because Turtleboy is a reporter doesn't necessarily mean he can't intimidate a witness, but there is a line. So in a comparable way to how there's a distinction between talking to a witness, interviewing a witness, even potentially asking, let's say, aggressive questions, does not necessarily intimidation make. In a comparable way, merely surveilling a witness or surveilling somebody does not necessarily stalking make. And then we get into fun borderlines between those concepts, but we can press on for the moment. In any event, the source then claimed Miss Peter asked the source to join her and go stalk, which doesn't necessarily mean it was stalking, incidentally, because stalk here could be a colloquial term as opposed to a legal term, right? If I say I stalked someone, is that necessarily legally stalking? No, not necessarily. Maybe I'm just speaking with a bit of imprecision. Borders and legal concepts can be fun. That's where the lawyers have fun, is in trying to figure out where is the edge. Where is the edge? And then, of course, the smart lawyers, if you ask us in advance, where is the edge? The smart lawyers will say, we don't know, because we don't where exactly the edge is. We don't know. We know it's vaguely somewhere over here, and we'd really recommend that you stay at least 10% away from the scary zone. Because the unknown is the line is somewhere in the scary zone, and we don't know. And we recommend that you stay at least 10% away from the scary zone so that you don't have to find out exactly where the border is. Because if you have to find out exactly where the border is, it's going to cost you money, right? It's sort of like engineering in this way, right? How precise does your model need to be, right? Does it need to be accurate within a mile? Does it need to be accurate within a foot? Does it need to be accurate within an inch? Does it need to be accurate within millimeters, right? These numbers are not the same number. How accurate do you need to be? So the lawyers will recommend that you stay away from the edge so you don't have to find out where the edge is. And if we have to find out where the edge is, it's going to cost you a lot. So, the better discretion being the better part of valor, and so forth and so on. In any event, the source apparently said go stalk, whether that's legally stalking to be decided at a later time, noting that she states at the Omni Hotel. Miss Peter bragged that she had previously taken photos of Reed and sold them to the Daily Mail. Additionally, Miss Peter alleged that Jennifer McCabe bought her a brand new sexual account as compensation for assistance. This is entirely consistent with Miss Peter's text messages in which she and Janetti detailed their plan to stalk and harass Karen Read and her attorney. And then there's a link to an X, which I'm not going to read right now. Most shockingly, Miss Peter was told by Jennifer McCabe that Mrs. McCabe threatened Morrissey with withholding testimony in Karen Read trial if Miss Morrissey didn't put me in jail. That's Turtleboy in jail. When Morrissey didn't back down and threatened to subpoena her if she didn't testify, McCabe told her, "We won't say what you want us to say." That's why David Unetti filed a motion asking for evidence of any Commonwealth witnesses expressing hesitation to testify at trial. Miss Peter told the source that she had followed the lead of Brian Albert and Brian Higgins, the Bryans show up unsurprisingly, by getting rid of her phone. Again, who would destroy their phone? Who would do such a thing? Did she also go onto a military base and dispose of it in the same dumpster? Unclear. After I announced that they'd be looking to get personal communication with DA Morrissey, she told the source they'll never get the communications. You know, just because you destroyed the cell phone doesn't mean that there aren't records of the communications. Depending on how you communicated, of course. The cell phone company might have the record, WhatsApp might have the record, the other person might have the record. If it was a group chat, other people might have the record. So, you know, it doesn't necessarily mean the record evaporates, but you can try. On June the 18th of 2024, Miss Peter and the so-called Food Stamp 5, showed up outside Norfolk Superior Courthouse during jury deliberations to disrupt peaceful supporters fighting for justice. Additionally, the source said that on March the 16th, she witnessed Miss Peter return home holding a manila envelope after meeting with Morrissey and McCabe at an undisclosed location in Braintree. Miss Peter then told the source that she had seen emails between Brennan and McCabe that are subject to the protective order, and that Brennan asked her to provide him with a spreadsheet of the Free Karen Read Facebook supporters before trial, presumably to weed out jurors who would be favorable. I don't know why the prosecution would do that. That doesn't make sense. I mean, if they want a list of the supporters, they would just get their own investigators to do that, which isn't necessarily invalid. It's not wrong to try to figure out whether the jurors have perspective biases. Good lawyers do it all the time, especially in higher profile cases. And the prosecution has detectives assigned just to them. So they could just ask the detectives, find us all the Karen, please find for this for us. I mean, that's not invalid, but why would they ask her to do it? That seems odd, but okay. Peter then told the source that Brendan was providing information to federal authorities about Karen Read and Turtleboy because he wants them in jail. Again, how would the feds get involved in this? Unclear. Peter also told the source, with respect to the feds being interested in the potential 1983 violations of the government, yeah, that makes a lot more sense. Being interested in Karen Read and Turtleboy, less so. 5 CHF from Nina saying, read the Massachusetts law regarding witness intimidation. It's crazy, in my opinion, against the Constitution. It's enough to feel intimidated. That's why they're charged. Yeah, I don't want to get specifically into the delineations right now on that issue, but, you know, whether it's unconstitutional or not, you know, another step. And of course, it would be potentially unconstitutional as applied. But that's another issue for another day. We don't have to get into the finer points about what witness intimidation is or is not for the moment. But you might be right. It might be unconstitutional, at least in part, at least with potential respect to specifically Turtleboy, which would be an as-applied challenge. So it might not be unconstitutional in general, but it might be unconstitutional with respect to Turtleboy. And exactly where those borders are, of course, is another fight for another day. And we don't have to adjudicate that right now. I take no position at this time on the ultimate issue as to whether or not Turtleboy intimidated anyone or not. I've never taken a position on the issue, and I'm not taking a position on the issue now, simply because I don't know enough, and also partially because, to be frank, at least at this particular time, I don't want to know enough. I'm already deep enough into Karen Read as it goes, okay? I'm deep enough into Karen Read lore as it is. I don't, at this particular time, relish diving deep enough into Turtleboy land to try to figure out what is or is not true with respect to Turtleboy. My head is already too full with Karen Read. Okay, I don't have the mental bandwidth for it right now. I can only do so many things at once. Okay, I don't have the mental bandwidth for Turtleboy. So I take no position, nor have I ever taken a position as to whether or not Turtleboy is guilty of witness intimidation. The only thing I have noted on this is I watched one hearing. I watched one hearing, and I didn't even watch all of it. I only watched parts of the hearing. But the parts of the hearing I watched, it seemed to me that the Commonwealth was talking about, what were they talking about? They were talking about defamation and whether or not Turtleboy defamed anybody, which, what does that have to do with witness intimidation is beyond me. How did defamation get into this discussion? I don't know, but somehow defamation entered the party, which didn't exactly strike me as the most solid witness intimidation case I've ever heard about, but that's as strong as an opinion I've had. The 10 minutes worth of hearing that I saw, in between fragments of the hearing didn't necessarily to me scream witness intimidation, and that's as close as I've gotten to an opinion. Please leave me alone. I don't want to know more things. £5 or €5 from Coach Bev. The Ask Trooper Rhino. Get the names from Facebook, but he couldn't find any. How? How could he not find names? How could he not find it? That's amazing. Karen Peters in chat. Okay, well, welcome to the chat, Karen. Hopefully, welcome to the chat. You're welcome to be here as long as you're nice and otherwise follow the rules. Everyone's welcome. Everyone's welcome as long as they follow the rules. So if Karen is here or Turtleboy is here or the government is here, everyone, if the FBI is here, we welcome everybody. We welcome the DOJ. We welcome the FBI. We welcome the prosecution of Karen Reed. We welcome the defense of Karen Reed. We welcome everyone. Everyone's welcome to join as long as they participate by the rules. Fair enough. It's my channel. It's my channel. I'm king of this particular channel. You have to follow my rules as long as you're here. Lol. All right, pressing on. Peter also told the source that she's going to start rumors about jurors being afraid to serve out of fear that'll go after them with the goal of being removed from the courtroom during Karen Reed retrial. She claims that everyone is working overtime to make sure Turtleboy can't be in the courtroom for trial, something that Brennan attempted to do by putting you on the witness list. Fine. Ms. Peter has been using online platforms to try to keep me out of court for almost a year now, starting with a change.org petition, which was unsuccessful. Oh, that's why they called him Mafia Masshole earlier. Oh, it was literally their Twitter handle. Oh, I guess I missed that. I didn't understand that was literally their Twitter handle. I thought it was just like just a generic euphemism. That's why you called him Mafia Masshole. You think it's literally their Twitter handle. Oh, okay, that part was unclear earlier. Thanks for clarifying that. $5 from Annie Oporowski. Seems like Turtleboy has gotten the rotten underbelly exposed en masse. Turtleboy certainly has done a lot to bring attention to this case. Whether it has been ethical is one set of issues. Whether it has been legal, an entirely separate set of legal issues. And of course, you're also free to like or not like him personally, because you're allowed to have an opinion. So is it ethical? You can raise the question. Is it legal? Separate question. Do you like him? Entirely separate question. But we can keep these questions separate in our minds. Additionally, Miss Peter confessed to the source that she was the one who created the AI image appearing to show Karen Reed and Alan Jackson embracing outside a steakhouse, which was picked up by the New York Post, the Daily Mail, and other media outlets. Thank you, Rachel, for becoming a civilian. Finally, Miss Peter told the source that she's well aware that her former friend, Lindsay Giannetti, was never pregnant, and the two of them conspired to frame me for domestic assault and witness intimidation in order to have me incarcerated. Please don't frame people. I take no position as to whether or not they did frame people, but, legal advice for the day, please don't frame people. I mean, don't frame people. The Norfolk County District Attorney's Office and the state police are so low. Thank you, Unbalanced Equation, for the 5 gift memberships. The Norfolk County District Attorney's Office and state police are so low. They don't mind associating with and paying a woman serious felony charges in multiple counties to run a Russian-style disinformation campaign. Nice word choice there. In order to subvert justice in the murder trial of Karen Read. This is a woman who's previously admitted to forging federal court documents and attempt to have me removed from YouTube. Please don't forge documents, 1, and please don't forge documents in a legal proceeding, 2. Those are 2 separate pieces of legal advice. Don't forge, 1. Don't forge in a court case, 2. Don't do that. I take no position as to whether or not that did happen. Just don't do it in general. And then apparently Karen Peter said, FYI, Aiden's mailbox is on the ground, being held up by a rope. His soft hands have never touched a hammer before, I'm certain. Less certain about other men's penises, though? What the fuck? Okay. A woman who's frequently used homophobic language in her online threats and voicemail she left on my phone, bragging she would work with the DA's office to put me in jail. Apparently, Masshole Mafia apparently texted or tweeted, hey, Dr. Turtleboy, answer your phone, faggot. The Jane account was me. I'm responsible for all your suffering. Blame me, bitch. Well, I mean, the word choice is aggressive, but of course legal. Hate speech is legal in the United States. So, not necessarily reflective of necessarily great character, but, a little aggressive, so maybe don't do that. And then said it may violate X's rules, which of course X is, of course, master of their own rules because they're, of course, king with respect to their platform. So, is it legal? Yes. Can Twitter block you for it? Also, yes, because they have the right to block or not based on their own standards, as do I, because we're both kings of our respective sandboxes. It's nice. A woman that the Commonwealth proudly associates with while she posts online that Karen Read is a murderous hooker. Aggressive. A woman who posted, thank God she's dead after your mother died. Holy shit. Wow. I mean, that's kind of not in great taste, no matter who said it. Masshole Mafia apparently tweeted, the world is a better place without Turtleboy's mother. Holy shit. Dude, man. Legal, not classy. Damn. Damn. Thank God she's dead. Holy shit. I'm hearing that after using her to try to get out of jail, it failed because no one cares what that useless, decrepit piece of shit has to say about her useless son. Wow. That Turtleboy killed her with all the stress and shame it caused her. Also not necessarily ideal to suggest that the son killed her because that potentially goes into the territory of negligent or intentional infliction of emotional distress. So when you now suggest that Turtleboy himself was the one that killed his mother from the stress, you are flirting with some torts. Namely negligent infliction, possibly intentional infliction of emotional distress. So also not necessarily advisable for civil liability reasons. First good thing he's ever done, in my opinion. Shit. Brian Rico at least had a family who cared, not so much for Manish Mary. And then apparently tweeted in response to Willowboy Billy saying, I don't care either way. Rico's in hell where he belongs regardless. Apparently tweeting, so is Turtleboy's mom. Suggesting Turtleboy mom is in hell. That's a lot. That's pretty aggressive. A woman who was issued a harassment prevention order in Leumeister's district court for repeatedly threatening to physically assault me showed up to my daughter's cheering events and posting sexual things about my children. Okay. Masshole Mafia apparently tweeting, total coward, answer your phone. Let's talk live. I don't care what cases you erroneously claim you're a witness in. My animus towards you is clearly centered around the fact that you're a woman abuser. I have no knowledge relating to that. I don't know what that's based on. I got nothing. And apparently there's a voicemail from apparently Katie Peter, who apparently said, Katie, Peter, you know, crusty panties. Are you called Ice? Want to let you know every time you get a blocked number, it's not Lindsay or LG or anyone else, it's me. And I just want to let you know that you'll go back to jail. Well, I mean, that would be harassment. So that's an example of harassment, right? If someone is calling you or texting you and you make it clear they're unwelcome to do so, and they repeatedly do so under new accounts, that would be harassment. That's harassment, right? If I make it clear that you're unwelcome to contact me, and I block you and all the rest of it, and you circumvent that, that legally is harassment. Please don't harass people. If they don't want to be contacted, leave them alone. It's not that hard, guys. Masshole Mafia apparently tweeted, tell Dr. Turtleboy's bitch ass to answer his phone since he's clearly still awake in his parents' basement. I want to hash some shit out before he goes back to jail. We're running out of time. Yeah, I'm not particularly inclined to take your call either at this point. So I'm not particularly surprised that Turtleboy is apparently not taking your calls. Doesn't feel like it's going to be a productive conversation, although it might be mildly hilarious to take your call and say this call is being recorded and then, release the audio. That might be hilarious. But, that's his choice either way. So I'll let him, decide which one of those paths he prefers to go down, his call, literally. Masshole Mafia apparently tweeted, hi, Aiden, tell your wife I'm coming soon. You're still a junkie in a Lexus, pal. What the fuck? Masshole Mafia apparently tweeting, I recall her saying that Aiden's poor abused daughter would grow up to be promiscuous. World is all restarted. Such a shame. He should stop sexualizing children. That's potentially tortious, especially if it could be understood to be talking about his own child. If that could be understood as suggesting that he's sexualizing his own child, that could be negligent or intentional infliction of emotional distress. So our potential torts, the lawyer in me is like, danger, Will Robinson. I wouldn't necessarily recommend saying those kinds of things. You're flirting with problems here. You're flirting with harassment. You're flirting with harassment. You're flirting with defamation. You're flirting with negligent and intentional infliction of emotional distress. If you're not already there, bail out anytime would be the lawyer in me's recommendation relating to that. Probably should stop doing those things. Apparently a text message, I don't know if this is a text message from Masshole Mafia, unclear who these text messages are with because it's not specified, but some text message from somebody, presumably between somebody and presumably Turtleboy. Apparently somebody said, I'll make your kids want to fucking kill themselves for embarrassment. Shut the fuck up. Want to talk about me and my little brothers. You look like an infected Gustavo from Ratatouille. Katie, did you threaten to send pornography to small children? Not Katie blank, you know how to spell it. I would send you a pic of me to prove it, but I don't want your weirdo ass to save it. My mom doesn't have it in heart to bring your kids into it. I do. Please try not to bring people's kids into it is just generally good advice. Just leave people's kids out of it. Just probably for the best. That's a good tip. Your daughter is so fucking ugly, crying emojis. High school gonna be hard for her. Might end up in a suicide, might end up in a GED. You're just doing this expecting a reaction. It's not gonna work. Did you break her teeth? I'm calling DCF. Let me call. I don't think that's appropriate. I tend to agree. I'm sorry you feel you have to act this way. I'm sorry your marriage is so miserable you had to go fuck any broad who gave it up. Your daughter's going to be on OnlyFans showing her lopsided Somali I can pronounce this word. Salami is the word I'm looking for. Thank you. Showing her lopsided nipple tits. You certainly have a way with words. I tend to agree. She's going to have no teeth, Miss Gum Job Warrior. Probably going to be in a suitcase warrior by 13, gum job warrior by 17. Maybe she'll get added into your Addy stash. Take too many, bite her fucking lip open and bleed out. Your son looks like he's from where the wild things are. Don't you have homework to do or something? Cute response. Don't you have hot milfs in your area or something? Or the wife had you on lockdown since all this happened. Then there's some sort of picture which is unclear. This looks like a traumatized child to me. Why is she scared to have her dad in her room? She's a victim. Sucking dick on school staircase. She's probably gone how to cope. You know, legal or not, putting aside legality for just a moment, this isn't really a nice thing to do. Don't be like this. This is not nice. Don't be like this. This is really dickish. Please don't behave this way towards other people. Some kindness goes a long way. You're not exactly doing the kindness. And then we've got a message. Please stop messaging this page. This is not appropriate and not the kind of person you should aspire to be. You have so much more potential and you don't have to follow in your mother's footsteps. Okay. And then Masshole Mafia apparently tweeted, how many times have I harassed his wife? By his own metric, 0. I'm a journalist working on a story. Those, again, are not the same thing for the reasons I previously alluded to. Okay? In the same exact way, it would be true for Turtleboy. It would be true for any other person. Journalist is not some magic shield that somehow just gets you out of all the things. Journalists can break the law too. And they can harass people. And they can intimidate witnesses and so forth and so on. Journalist is not a magic thing. So, just because you call yourself a journalist does not mean that you're allowed to just do anything. Did Turtleboy break the law? I take no position at this time. Did Masshole Mafia break the law? I take no position at this time, although on the civil side, it seems like if these messages are all from the same person, which is not necessarily clear, but if they are all from the same person, that it seems much more that we're running into torts at least. If I won't take a position on the criminal law, but the tortious elements are flagging my spidey senses. So, but there's that. And, whether or not Turtleboy has committed torts or crimes, I don't know. But another issue for another day. $5 from Jefferson C. Post. Doesn't Mass sound like a great place to visit? Makes me glad I stayed on Cape Cod. Here's to the demonetization. Thank you. Apparently, Mr. Potato says in chat, apparently those texts were from KP's daughter's account. Fair enough. So if they're not from the same person, then they have to be analyzed under their own merits, which is why I wasn't sure. And I said I wasn't sure multiple times because it was unclear. So assuming that they're from a daughter's account and not from the same account, then they have to be analyzed under their own terms. And now we have potentially 2 potential people who might be potentially committing torts and or potentially crimes again. Some of my spidey senses are being flagged. Of course, also to the extent that the daughter is being directed by the mother and they're not independent, then also that could potentially bleed over. So if they're independent, which you would presume on their own terms, they're independent, then if they're independent. Of course, if you're dealing with a minor, then also potentially there's also potential civil liability even if they are independent because they're a parent, especially if the parent has knowledge of it's happening. So if a child commits torts, the parent can be responsible for those torts, essentially for failure to supervise their child, particularly if they're aware of it. But again, you still have to get into legal delineations relating to that, and that's where the lawyers have fun. So it could be independent, it could not. If it's directed by, then you run into liability because it's being directed by. If the parent has knowledge of it's happening and they're not stopping it, you could get into liability relating to that and so forth and so on. That's where law has fun. So potential legal issues, Potential legal issues surround these messages. $9.99 from Patty Hossman, helping offset demonetization. Thank you very much for the super chat. It's appreciated. So yeah, you can't just so respecting the journalist thing, you can't just call yourself a journalist and get away with it. That is not how that works. I don't have any particular respect for journalists when it comes to their ability to do things. Journalists are not the special, in my view. Journalists are not the special. Freedom of press belongs to everybody. It's an individual right. Everyone has freedom of press. Everybody. Everyone has freedom of speech. Everybody. The fact you call yourself a journalist does fuck all for me in terms of your First Amendment protections. At least in my humble opinion, you have no particular First Amendment protections because you call yourself a journalist. Because freedom of speech belongs to everybody. Freedom of press belongs to everyone, and you're not one of the specials. You may or may not have protections under state level law relating to this. Consult your state level law. But as a matter of federal law, if you're a journalist, you can fuck right off. You are not part of the specials. You have just as much freedom of speech and freedom of press as I do. So if I'm guilty, you're guilty, and so forth and so on. You are not the specials. Please stop pretending you're the specials. Moving right along. Kate Peter apparently said, left this in the door at 111 Madison Road. Can't wait for the call from Holden Police because he's a hypocrite. Apparently the message says, hi, Julie. Sorry I missed you. As I leave this note, your husband is leading a quote-unquote parade of morons around the homes and businesses of the state's witnesses in a murder case. He's terrorized these people at home and their children's events numerous times, but good news, it's legal. It might be legal. It might be legal, although protesting outside someone's home might not be legal. Please consult your relevant law on this point, right? Because time, place, manner restrictions, we're aware of this concept, and some jurisdictions have rules when it comes to protesting outside someone's home. You know, the home being someone's sanctuary, and so forth and so on. So before you go protest outside someone's home, please consult your local law. It might not be legal. You know, even if you're in a public space, even if you're on a public sidewalk, it still might not be legal because you're outside the person's home, and a person's home is their sanctuary, time, place, manner restrictions. Please consult your local attorney for further information. So I'm a reporter working on a story about his penchant for witness intimidation, and I'm looking for a comment from you. Additionally, I took the liberty of sharing your address with these witnesses, friends, and family of the murder victim, not like I needed to, as it's available online. Doxing generally is not illegal in and of itself. Merely providing private information such as address, real names, phone numbers is not inherently illegal. However, if you're doing it for an illegal purpose, it might be an element of a crime. It is not a crime unto itself. It might be an element of a crime if you're doing it for the purposes of harassment and so forth and so on. So, you know, you might want to be careful. But doxing unto itself is not illegal anywhere to the best of my knowledge. But, you know, you might want to double check. But I don't believe it's illegal anywhere. And I'm not sure it could be illegal anywhere. Although if you're revealing private facts, it might be tortious relating to revealing private facts, but it's not criminal anywhere, I don't think, but yeah. Pressing on. Don't forget your husband established through his actions that it's legal. Again, that is not how that works on any level, right? If Turtleboy did something, it does not become legal because Turtleboy did it. And you can't just be like, because you did it, it makes it okay for me. That is definitely not how that works. If Turtleboy's breaking the law, you're breaking the law. So, you know, you have to account for your own legality unto itself. And $10 from FOP444 says, Kurt, you're looking great. Keep up the healthy you. Thank you. I appreciate the encouragement. These things help me. Thank you. As of yesterday, I believe, let me double check because numbers continue to go down. I didn't weigh myself this morning, but I believe I did weigh myself yesterday. So give me just a second to check what the magic scale says. What did the magic scale say last time I weighed myself? As of April 25th, which is now 2 days ago, as of April 25th, I was at 326.7. Yeah. Yeah. So we're making progress, baby. We're making progress. Like my peak weight was something around 392, 393. So we're down. What is that now? Can I do math? Is that 65 pounds? There or thereabouts? Yeah. Progress is being made. Under 300 soon, baby. Under 300 soon. Exciting. I'm fun. $10 from Virginia Little. How's dating going since I moved to Houston? Well, I do speed dating sometimes. It can be fun. Thank you for the super chat. We're making progress, baby. We're making progress. So I have basically 100 pounds left to lose. That's sort of my target. My target right now is 220. And then we'll sort of reevaluate from there. So yeah, I'm basically, I have 100 pounds towards my goal. 65 pounds down, 100 pounds left to go. I am a real American. Fight for the rights of every man. All right. To CHF from Nina said, I heard the Commonwealth's asking for a new jury. They can't get one. If you mean in the Turtleboy case, I mean, I don't think there's a jury yet. If you mean in Karen Reed, there's no way. How would you, no, not a chance. How would they possibly be able to do that? If there's a motion filed for a new jury, I would be amazed. And no. $9.99 from Pixie Designs. Thank you very much. So in any event, just because Turtleboy did it doesn't mean it's legal. Please consult your own lawyer for further information about what is or is not legal. Just because Turtleboy did it does not make it legal. That is definitely not how that works. Mandy Strong has been a member for 16 months. Annie L has been a member for 25 months. Thank you. Miss Peter has previously bragged to the court she furnishes information to the Commonwealth as met with special prosecutors. Apparently, Masshole Mafia said, Dr. Turtleboy, turn yourself in, domestic abuser. What a way for your family to find out you impregnated another woman, forced her to abort the baby, your baby, and abused her. Yeah, we already know a little bit about that lore, and I don't really want to go back into that. Apparently, it was never true. And then, yeah. Stop talking about my fucking kids because at least they're alive. You murdered your own child. Monster, narcissist, abuser. That's why we all fucking hate you so much. You're subhuman. Please don't talk to people this way. It's just not good. Don't do this. Legal or not, please just don't. She just failed to mention that they're paying her due too. It's surprising that someone like Hank Brennan would align themselves with a woman who lost 2 of her children to the state after years of drug-fueled abuse and neglect. And then apparently there is what appears to be an excerpt from some kind of legal document that says, on March the 10th, mother and father, Stephen Young, signed an open adoption agreement for some people. In April of 2014, the child was discharged from St. Vincent's and reunited with mother. Someone was reunited with mother on February 19th. Someone were removed again in May 2015 after a hotline response was initiated due to mother relapsing and going into crisis. Department had concerns regarding mother and her ability to be honest with the department and her mental health issues. In July 2016, there was a verbal altercation between Katie and her boyfriend at the time, Andrew Johnson. The argument stemmed from Andrew possibly taking Katie's AD medication, Vyvanse. I take Vyvanse. I found it to be helpful for me. I take it for depression, though, not ADHD, and I found it to be marginally helpful towards that end. So we got that in common. Katie obtained a 209A, and she and Andrew raised their relationship. The child returned to care. Yeah, I'm not sure this is necessarily what that says or what the value of that is relating to this discussion, but it seems off point, related, whether or not this person is bad towards their children or not, I'm not necessarily sure has really anything to do with whether or not they're a government agent or not. So I don't really feel like it's on point. It feels off point, but maybe that's just me. $4.99 from Spoonful Snark says, this is Pearson's 16-year-old daughter. It's really sad how she talks. She's had a hard life, but sad she's involving herself. Yeah, fair enough. With respect to who it is or not. So if it's the daughter and not them, with respect to I don't know who these messages are from because they're not apparent. So again, who are they from? What messages are from who? Who is acting on whose behalf? If it's a 16-year-old, they're a minor, and that potentially exposes potential liability to the parent, particularly if they directed it, potentially even if they were aware of it, even hypothetically, even if they weren't aware of it, possibly. But there's basically a generalized duty to basically generalizedly supervise your children. And so you can run into liability for your children's torts, for failure to supervise and stuff like that. But it's potential. So who are these messages from? Who are they not from? Not sure. But whoever they're from, even if they're legal, I'd recommend not talking like this. It's not a good road to go down. Just be a better person. Please try not to do this. Yeah. Also the relevance to the underlying issue, it's irrelevant. They're separate legal issues, right? They're completely separate legal issues. So even assuming they're from the daughter, or for that matter, from the mother, either way, it doesn't really have much to do with whether or not the mother is a government agent or not, acting on behalf of the government. It's kind of irrelevant to the issue at hand. So it is irrelevant to the issue. It's not legally important. It's just off point in any event. And then we have a message relating to child custody, which I'm not going to read. Then we have a photo. And then we have some more stuff relating to child custody, which I'm not going to read because I can't be bothered right now. She's also bragged about getting dinner and doing mushrooms with Boston Magazine reporter Gretchen Voss, who arranged for her to go on a date with the former Norfolk County DA spokesperson. Whatever. A masshole mafia saying they've never been to dinner. Lol, I've had dinner with Gretchen and I can assure you we're not banging. She's a talented writer, honest and fair reporter, and a good person. That's why she gets to work in major publications. Those are definitely not the same thing. I am quite positive of that. Yeah. It's not because you work in a major publication that you're either talented, honest, fair, or good. Yeah, those are definitely not the same thing. I can find counterexamples, but let's not dwell. If what Miss Peter told the source is true, it means that Hank Brand is actively using this unemployed degenerate to circumvent the gag order he's filed for the last month. It means she's being bribed by Jennifer McCabe and the D's office to spread disinformation on social media, interfere with murder charge, and violate my civil rights. It means Jennifer McCabe is willing to alter her testimony in exchange for my incarceration. All this needs to be thoroughly investigated by someone outside the Norfolk County DA's office, as it directly impacts 2 criminal proceedings. Well, that's a whole nother set of problems. What am I doing to lose so much weight? The magic of Monjurna, otherwise known as trisepatide, otherwise known as Zepbound, because Zepbound and Monjurna are the same drug, a GL1P inhibitor, in the same vein as Wegovy, which is a different drug, semaglutide. So you've probably heard of semaglutide because it's the more popular drug, Wegovy and stuff like that. But semaglutide and I did not get along. It caused a lot of nausea. Trisepatide and I had a much better experience. I basically had no side effects with trisepatide. So yes, the magic of a GL1P inhibitor has been what's worked for me. Is it cheating? I don't fucking care. First of all, who or what am I cheating? I'm not competing against anyone. Second of all, it works. So what the fuck do I care? So in any event, yeah, but yeah, the Monjurno has helped, although it is incredibly expensive. Yes, I've looked into it with my insurance. Yes, I've looked into discounts and so forth and so on. $650 a month. So it is not cheap, although I'm saving a lot of money on food. So I might be breaking even, but still $650 a month for medication is not exactly cheap. So there's that. Yes, compounding pharmacies can do it for cheaper, although I'm not necessarily sure I trust them, so forth and so on, blah, blah, blah. We've had this discussion. But yes, the trisepatide is working. So all that good stuff. And that apparently is the end of that string of comments. So that is the end of the discussion. All right, so how I thought about doing public defender work for money. Well, criminal law really isn't my bag. So, because I'm much more familiar with civil law than criminal law. So, I mean, I could get into doing public defender work, although I'd have to start with the basics because it's not really, I mean, I understand the principles, but it's not really my principle. Civil law is much more my thing than criminal law. So, and federal civil at that is where I would ideally like to be as a lawyer, is federal civil law. And that's sort of where I would prefer. And as to what kind of civil law, I don't really care. I mean, that's a lot of domain, but I don't really particularly care beyond that. I find learning things very interesting. For example, last year I was hired by somebody to work on their Supreme Court brief, and they ultimately decided to go with a different lawyer, which, is their prerogative, but I still got paid. And I had a lot of fun with it because I learned about something about an area of law I had no knowledge about before, which was fun. I was learning about, in this particular case, the client claimed that they were fired or otherwise discriminated against because they were a veteran, which is illegal. You can't do that under federal law. And they had lost at the trial court and lost at the Court of Appeals. And so they contacted me to help them on their brief for the US Supreme Court. And it was fun, interesting learning about that area of law. It's like going from I don't know anything about it, I've never heard of it before, to, by the time hopefully I get to the Supreme Court, hopefully I am the foremost expert, because that's where you want to be. And, that's fun. And I had a lot of fun writing it. And hopefully I'll get to do something like it again. And, I thought I wrote a very good brief, and I didn't really much care for the person they hired's brief. I didn't really like it as much as I liked my own work, which isn't necessarily true all the time. Sometimes you read something, you're like, oh, this is better. And I'm like, no, I don't think I like their work as much as my work. But, it was what it was. So hopefully I'll get to do something like that. So if you've lost at the Court of Appeals and need someone to write your Supreme Court brief, give me a call. I'm available for hire. So let us read some of your super chats and other comments relating to this. Oh yeah, I needed to summarize my thoughts as to where we were legally on this. All right, so first of all, relating to the messages themselves that we reviewed as to potential issues there, I take no position at this time, except to say that I have noted the potential issues relating to potential legal liability in the civil domain, relating to potential civil charges of harassment, defamation, and negligent/intentional infliction of emotional distress caught my potential interest. To the extent it's the kid, that may be severable from the adult. And also to the extent it's the kid, may not have anything to do at all with the adult, particularly as it relates to the issue of whether the adult has responsibility for being a government agent. I mean, it's just like, it's off point. It doesn't seem to have any connection that's obvious or on point. So okay, so there's that. So we have messages that may be from, Peter, maybe from Peter's child, that may potentially be illegal, either civilly or potentially criminally with respect to certain things. Just because Turtleboy did it doesn't make it legal. You might want to consult your own lawyer. Turtleboy may or may not have violated the law with respect to these issues. I take no ultimate position on that because I haven't learned enough things at this time to take a position on whether or not Turtleboy is guilty of witness harassment, except to the extent that I watched 5 or 10 minutes of a hearing, and not 5 or 10 continuous minutes at that. And based on what I saw, didn't appear to be the strongest case. So, seemed pretty weak based on what I observed, but I take no ultimate position at this time. As to the underlying issue here, as to whether or not this person is a government agent or not, I will simply note that there appears to be enough information, in my opinion, to ask the question. A lawyer just needs to have a good faith basis to ask the question. And a good faith basis doesn't need to be very much. It's a fairly low standard. So I will agree there's a good faith basis to ask the question about whether or not this person is an agent, and to at least ask the government to give me a response. And if the response is, no, they're not an agent, we have no idea what we're talking about, we have no records relating to this, we have nothing to give you, you're out of your mind, that would be a potentially valid response. And then whether or not I'd be able to fight that response, we could sort of go from there. but there's enough to ask the question and enough, at least in my opinion, to demand an answer, whatever the answer happens to be, and then, go from there. And as to whether or not it's true or not, who can say? And then, of course, as to whether or not it impacts Karen Read for the moment, no, it doesn't, because all these are filings in Kearney's case, and Kearney's case is legally distinct from Karen's case. So will Karen's lawyers use potentially any of this potentially to ask the question? Maybe. I don't know. And, as terms of what motions they will file, who knows? They probably have enough of a good faith basis to ask witnesses relating to this on the stand. If these witnesses came on the stand, they would have enough basis to ask the question on the stand. But if the witness denies it on the stand, I'm not really sure where you go from there, because you have a good faith basis to ask the question, but you don't really have enough to meaningfully impeach them. So I'm not sure that as the attorney, I'd ask the question, because if they denied it, I don't know that I really have anywhere to go. And so I might not ask the question. I might try to file a motion in court, but I don't know that I'd really expect even a neutral judge in the Karen Read case to get too deep into this. Like it's enough to ask, but it is a little thinner than I'd like. It's a little thin. I'd want a little bit more. It's the difference between making a frivolous motion and a successful motion. Is it frivolous? No, it wouldn't be frivolous for their attorneys to do so. Would it be successful in Karen Read's case? Even if you had a perfectly neutral judge, I have my doubts. And this judge, at least in my humble opinion, has been anything but neutral. So I wouldn't really expect it to go anywhere. But, it could have potential implications, but probably not. So that is where we're at relating to all that. So we'll see how it all goes. And also, just generally, try to be a nicer person. That's not legal advice. That's just generally good advice. Try not to be a complete dick. Would also be just generally good advice in general. So that's good advice. Let's see what else you got in chat. Let's make first of all sure I responded to any of your super chats I missed. Maximum Bacon joined at the higher membership tier of the Uncivil Posse. Thank you. Bob became an uncivilian. AJ Red Sox has been a member for 22 months. $5 from Annie Asparowski. $5, 5 pounds from Coach Bev. We read $5 from Annie Asparowski. Rachel B. PSYD became an uncivilian. Doctor of Psychology, I believe that means. Unbalanced Equation has gifted 5 gift memberships. Therapist became an uncivilian. Thank you. $5 from Jefferson C. Post. $9.99 from Patty Hossman, helping to offset defamation. $10 from FOP 444. $10 from Virginia Little. To Swiss franc, I believe. From Nina, $9.99 from Pixie Design. Annie L gifted 20 gift memberships. Mandy Strong's been a member for 16 months. Annie L's been a member for 25 months. Karate Cat Mom's been a member for 31 months. Kathy Paraso's been a member for 2 months. $2 from Jefferson C. Post. So the doctrine of uno reverso doesn't protect you. Not really, not so much. No. $4.99 from Spoonful Snark, who said it might be Pearson's 16-year-old daughter. Brandy Snaps became an uncivilian. $4.99 from Spoonful Snark says, is it relevant to Aiden's case? If Pearson's involved with the prosecution to put him in prison and they're harassing him behind the scenes, it may well be relevant to Aiden's case. Yes. Aiden is entitled at least to an answer to the question. I would agree with that. He's entitled to an answer answer to the question. He has enough information to ask the question, and he's entitled to have the government respond, even if it's no, we have no idea what you're talking about. We haven't done anything to that. We have no records relating to that, and none of that's true. If that's the response, that's the response, and where he goes from there, who knows? But I think he's entitled to at least that much. So it's relevant that far, and if it's relevant beyond that, well, we'll have to see how it goes. Fuel Me Once is a member for 32 months. Ask Bob has been a member for 2 months. $2 from Swiss francs. When will we now know if the Supreme Court will hear the case? I believe they were scheduled to hold discussions on it around this time. So probably, Yeah, weren't they scheduled to hold here a thing on it this week? You'll probably know when they probably know as soon as they had their conference. So I believe they had the conference on Monday or Tuesday. You're going to know Monday or Tuesday, and the answer is going to be no. The Supreme Court's not going to get involved on this case. I find that exceptionally unlikely that the Supreme Court's going to get involved. April 25th, this past Friday, and they didn't provide an answer on Friday? They didn't give an answer on Friday? Let me check. I thought it was Friday. It might have been Friday. Let's check the docket and see if they gave an answer. Okay, hold on. Talk amongst yourselves while I look this up. Granted noted cases list. No. Orders by the circuit. No. What day is it? 421. Orders by circuit. 421. There's no orders on the 27th, on 25th yet. Yeah, so there's no orders by circuit. I don't even know what that means. Orders of the court. Let's see. Miscellaneous order on the 25th. Yeah, order in a pending case. Yeah, there's nothing that I can see on the docket. Let me do a docket search and see if it's on there. Okay, yeah, circuit for, okay. We have a right, distribute, application, yeah, there's distributed for conference on the 25th, and then the emergency action was denied on the 9th, and there's no answer on the conference yet. So probably Monday, probably tomorrow, I think is when you'll know. And the answer is going to be no. So fair enough, probably tomorrow. Let me read your super chats or other comments. Yeah, Rose says we might need a new Don't Be a Dick merch. Yeah, maybe. Commonwealth provide evidence, then the Commonwealth said the evidence they provided was not trustworthy. Those aren't necessarily mutually inconsistent concepts. The Commonwealth has to turn over basically any information they have, but whether that information can be used in court is subject to evidentiary standards. So the standards for disclosing information isn't necessarily the same standard as for presenting that information in court. So those aren't necessarily inconsistent positions. But thank you. Yeah. Thank you, Hardy. Thank you, Harley62 for the 10 gift memberships. Where can he go from there? Unclear. Yeah, assuming that he gets a denial, where can he go from there? Unclear. But, you know, one step at a time. One step at a time. You tried to make a donation, it didn't work, but memberships work. That's interesting. Turtle Boy doesn't want the couch? Funny. A lot of hearsay? It is a lot of hearsay. I don't disagree, although at one point it looks like we only have one level of hearsay. But yeah, we might have multiple levels of hearsay. But it feels like enough to at least ask the question. Because the standard to ask the question is pretty low. You know, it's just like any good faith basis. And you have a sworn affidavit that overheard them talking. And so it feels like enough to ask the question. Is it anything more than that? I don't know. I'd have to analyze separately. Yeah. Does something happen in the Karen Reed trial regarding this file? Not unless something's filed in the Karen Reed case. Nothing happens. Nothing will happen in Karen Reed unless someone asks. Yeah, recognizing his voice, we saw that. The camera person has changed, so Turtleboy's no longer seen. He'll probably change seats. Yeah. I'm an outstanding person. I try to be. I try to be outstanding. The couch has seen some things, maybe. All right, so I think that sort of brings us to the end of that. Oh, we have 3,700 viewers. That's a lot of viewers. Wow, thanks so much for being here. That's a lot. Thanks. Damn. Who knew the story would be that popular? 3,700 viewers. Damn. Could I take a moment of your time to please hit the like button? It really does help with the YouTube algorithm. And if you'd be so kind as to check us out on Monday, we already have the stream posted, incidentally. I'll set up a redirect at the end of the stream so you can go ahead and, like that and stuff, for later. But, I would appreciate if you hit the like button. It helps. It's free and helps with the algorithm and so forth and so on. And if you wouldn't mind joining us on Monday, Monday's going to be a great day, incidentally, because Monday afternoon we have the ARCA for Dyer, right? Will ARCA be allowed to testify? About what? Tune in Monday for further information, although probably not a decision because Bev doesn't know how to make decisions from the bench for the most part. But yes, Monday would be good. What exactly would be illegal in the Turtleboy motion? I don't understand your question. There's nothing illegal in the motion itself. The motion might be referring to things that were illegal. So if you understood me as saying the motion itself could be illegal, that wasn't what I meant to say. Yeah, the motion itself is legal. Some of the activity described in the motion could be potentially illegal, depending on details. Although I don't necessarily think it's clear that anything necessarily was illegal in the motion itself, although it might implicate the state with respect to this being an agent of the state, which is discoverable information because it could potentially lend to their credibility. So yeah, I don't know if the motion itself was not illegal. I'm not sure anything referred to in the motion is necessarily illegal, but legality of this conduct isn't necessarily where it stops. If it's being directed, orchestrated by the state, then that becomes state action. And if it's state action, then the defense is entitled to know about it, even if it's fully legal. So, yeah, all that stuff. Yeah, predicting ARCA is going to come in and be pived with all the receipts. Yeah. The most likely outcome, the most likely aggressive outcome by the judge, the thing if I had to take a bet on what she's going to do, my bet would be she's going to limit ARCA to whatever reports and testimony they had in the first trial. She's not going to allow them to bring in anything new relating to it because there has been, the defense has alluded to the possibility that there is ongoing investigations by ARCA and there has been new reports. So assume the most likely thing is probably the judge saying that their testimony cannot include any new reports or any new tests that they have done because they would have not been provided to the Commonwealth in sufficient time. Incidentally, I think that that's sort of a bullshit ruling because I think that they would have been provided in sufficient time because ARCA isn't going to be testifying for a couple weeks and they would be able to call any witness they need in rebuttal. So they have plenty of time to prepare. So I don't think unfair surprise really gets them to where they want to be. But the judge might take a different tact. So probably the most likely and most aggressive thing is to restrict their testimony to what they testified to the first time. Anything more aggressive than that, though, that they're just like begging the Court of Appeals basically for reversible error. Because anything more aggressive than that is begging for problems. Over under on 2 days to decide on ARCA? Yeah, who knows? She would seem. Yeah, the prosecution has new stuff as well. Yeah, I agree with you. So, right, but we know that the judge has been treating the defense more harshly than the prosecution. We've seen that. The prosecution is able to get away with way more than the defense. They don't seem to care when the prosecution dumps more information on them, but the judge seems to hold the defense to a much more exacting standard than the prosecution. So, if you had to score the probabilities, you had to score it based on that perception, because I think that perception is reality. Hank is desperate to keep out Arca. Wonder why? Well, Arca is really good for the defense. That's why he wants to keep them out. He wants to keep them out because they're among the best experts in the world. Arca helped to investigate the Challenger explosion. They're pretty good. It doesn't mean they're infallible, but they're pretty good. And so, they could be wrong, but their testimony is pretty strongly persuasive that the physics don't make sense. Sounds like, yeah. A month is sufficient for Arca to test and write a report, but not for Hank to review it. Yeah, exactly so. Yeah, so the judge would basically say this is unfair surprise, which is pretty rich, given how long they would have to prepare a response. It's pretty rich. Hank is doing a way better job than Lally. I agree. I know it's an unpopular hot take, but I believe that Brennan has been essentially flawless so far in his presentation, given what he has to work with. But given what he has to work with, I think he's essentially flawlessly presented it. People disagree with that opinion, and that's fine. Particularly, they disagree. They think that Brennan's opening was boring and monotone, which I tend to agree it was monotone, but I thought that the story was pretty good. So I think story gets you a long way. And so it was a bit, and I agree that Jackson has way better stage presence. I'll agree with that all day long, although I think Jackson has been way too aggressive in cross. But yeah, in terms of the opening, if you wanted to score Brennan much lower than I did, I think you could justifiably score him a lot lower just based on the fact he's monotone. I said it was 9.8, but if you think that that's ridiculous because you think that his monotone is so strong that it drops him down even substantially, I wouldn't necessarily fight you. If you said, no, I think it's 6 out of 10 because he's so monotone and so boring, I'd be like, okay, I think that's a reasonable opinion, even if I disagree with it, right? It's like, I might have scored him too high. That's a fair point. But I still think he was better on story. So Brennan was really good on story on opening. Jackson's story was not as good. It was okay, but it wasn't as good as Brennan's story. Jackson's, however, stage presence was far better than Brennan by a lot. I mean, he's just more interesting to listen to. And so his stage presence gets him a long way. So yeah, that's true. Brennan has been essentially flawless on direct. He's let the witness be the star. He's gotten them. He's managed to direct them in a way to tell the story. He's, again, a little monotone, but the way he's doing the style of direct is essentially flawless. Jackson has been way too aggressive on cross, in my humble opinion, with respect to the witnesses. He has been way too aggressive out of the gate and fighting way too hard over way too little. I fear that he's coming off as a bully. And I fear that he's coming off poorly in front of the jury. And he's being overly aggressive about discrepancies. There's a difference between noting the discrepancy and then just basically berating them on the discrepancy. And I think in my humble opinion, it's been much more berating. So I think the prosecution has been, and also for my taste, again, people will disagree, but I think that the prosecution's use of the Karen Reed clips has been incredibly tactically wise. I really like the way that they're bringing in the clips. I like the way that they're bringing them in piece by piece, because I think it's much more effective. Rather than trying to just dump all the clips at once, I think that by bringing in a clip and then having a witness and bringing in a clip and then bring a witness, I think is a much, much more effective way of presenting those clips, because you're using Karen Read's own words in pieces to emphasize and highlight and augment the witnesses. I think that's been incredibly tactically wise. And I think it could be playing very well for the jury. And so I think that I think right now you'd have to say that the prosecution's winning. Again, it's 3 days into it though. But they've made, at least in my humble opinion, they've made a strong initial presence. And, other lawyers disagree with that. Some of them strongly disagree with that. But that's my opinion. And so that's my opinion for what it's worth. I think the prosecution has been near flawless. I think the defense has not. And I think so far the prosecution is winning the game. A lot of game left to play. Of course, where this all really falls apart for the prosecution is once they start getting into the police conduct. That's where this really falls apart for the prosecution. So if I were going to redo this, I would have been a lot softer with the EMT and firefighter witnesses. To the extent there are discrepancies, I would have simply noted the discrepancy. I would have said something like, okay, you previously testified to this. Now you're testifying about this, right? And just left it. And just let the accumulation of the discrepancies speak for themselves, rather than trying to make any one discrepancy work. I would have simply noted the discrepancies and let the accumulation speak for itself. In my humble opinion, would have been a better way to go. But they didn't do that, and I think to their detriment. But where they're going to really, they should have saved their energy, and they should have saved their indignation for the police officers, if for no other reason than by contrast, right? By being indignant about everything, it's basically highlighting everything. And to highlight everything is to highlight nothing. By being indignant about everything is to be indignant about nothing, because it's just now your baseline normal, right? You need the variety to highlight the contrast. And so I think they should have saved their indignation, and should save their indignation for the police and the investigation and the solo cups and the lack of evidence logs and the fact that evidence was floating around in someone's trunk for a month, and then we handed it over to a guy and there's no log of it being recorded, and we don't know where the evidence came from. We don't know where the evidence went to. And then we had leaf blowers, and we had rakes, and we searched twice, and we didn't find any pieces. Oh, and then we found 4. Oh, we found 8. Oh, then we found 12. Then the magic pieces just keep appearing. Oh, the fact that none of the pieces, even though they're apparently the pieces that cause these deep gashes, none of those pieces have DNA on them from the deep, deep gashes. None of them have DNA of the victim on them. That seems impossible. The fact that, that the victim doesn't appear to have any torn ligaments or bruised muscles or broken bones, or not even so much as a bruise from this 7,000-pound car hitting him at 25 miles an hour backwards, causing hard enough for him to, pirouette through the air and land on the ground and knock him out, but apparently didn't cause any bruising. How does that work medically, right? The fact that the medical examiner was unable to determine the manner of death to be homicide, right? Those are the things you want to save your indignation for, rather than, crucifying the poor EMT because, previously he testified he heard I hit him twice, and now he says it's 3. Is it really worth going to the wall on 2 versus 3 as opposed to simply noting the discrepancy and letting it speak for itself? In my humble opinion, no, it wasn't worth it. The juice was not worth the squeeze. I think it didn't work. And then other examples beyond that, where they want to crucify. And then also they asked the ultimate question, which is more than once, which is a mistake. They asked doesn't that mean that you're a liar version of the question. You don't ever ask that question. That's a mistake every single time. The witness is incredibly unlikely to give you the answer you want. It undoes all your hard work. And then you have to try to undo your mistake. Don't ask the ultimate question. Let the pieces stand for themselves. Don't ask doesn't that mean you're a liar? Doesn't that mean that you lie? Don't ask that question. It's a mistake every time. So those are my notes relating to this. No one from 34 Fairview ever found a piece of taillight in their backyard. That's also weird. As they were walking, they never saw pieces of taillight. That's also strange. Fair point. Stacy says, you've been listening in your garden all day? Outstanding. I hope you're enjoying my gardening, or I hope you're enjoying your gardening. We like gardening over here. Arca's text may get Jackson in trouble. Possible, but probably not. Arca's more credible than anyone the Commonwealth has. Facts. Cameraman got in trouble. Fair enough, man. I mean, the camera people just cannot stop themselves with what they choose to focus on, right? Focusing on like Karen Reed and focusing on our table and watching what she says to her defense lawyers and stuff like that. Yeah, the camera people can't stop themselves. They can't stop themselves. The camera people should not be focusing on Karen Reed. They shouldn't be focusing on like when she's talking to her lawyers and stuff. The camera people can't stop themselves. I'm not surprised that the camera people got scolded. They can't follow the rules. This is why, by the way, a lot of judges don't want cameras in the courtroom, because the camera people suck. They can't stop themselves, right? There's a lot of reasons the judges don't want cameras in the courtroom. Some judges think that it changes the nature of what happens. The very fact that there's cameras in the courtroom changes what would occur. People act differently because the cameras are there. So they're afraid the presence of the camera changes the observation. The observing changes the observation. And they prefer to have it not change. That's one reason. Another reason is because the camera people just can't stop themselves. They keep doing the dumb. They keep trying to zoom in on the defendant while they're talking to their lawyer. They keep trying to zoom in on things on the defense table. They keep trying to do the stupid. They just can't stop themselves. So this is a lot of reason why judges don't want cameras in the courtroom, because the camera people just cannot be trusted, because they are dumb. Please stop doing the dumb. Just film the proceedings like a normal person. Jeez, man, come on. The prosecution has a new theory. The prosecution may have a new theory of the crime. Maybe they do. If they have a new theory of the crime, then they're free to change their theory of the crime. They are free to change their theory of the crime at any time. They can change their theory of the crime in the middle of the trial. They're allowed to argue to the jury any theory from the available facts. So they can change their theory of the crime at any time. Of course, the defense has the right to note that and be like, even they can't make up their mind, but they have the right to do it. So if the prosecution has a new exciting theory of the crime, we can hear their new exciting theory of the crime. That will be fine. Makes you sick how biased the judge is? Yeah, the judge is pretty biased. It's pretty hard not to reach that conclusion. It's not a conclusion I like to reach, because, I have a lot of respect for my profession, and I expect my profession to act honorably. There are some people who don't act honorably in my profession, but that's true of every profession. I'm not necessarily sure that it's necessarily worse in my profession than any other profession. I'm not sure that the quantity of assholes is necessarily significantly more than other professions, although maybe it is. But I have a high respect for my profession. So saying the judge is biased is not my favorite thing, but it's pretty hard to not draw the conclusion the judge is biased based on the differential way she treats the defense and the state's witnesses, right? When the defense wanted to bring in their own medical expert in the previous trial, she had a whole voir dire over it, right? Whether this emergency room doctor could testify as to dog bites. It's like, okay, but you're not doing that for the prosecution witnesses. When, the prosecution fails to turn over something, it's not that big a deal. When the defense fails to turn over everything, she chastises the defense in open court. It's like, that's weird. The way she's treating Arca, right, with respect to the voir dire and the respect to the exacting standard she's holding the defense and turning over things, it's kind of weird. It wouldn't be such a big deal in and of itself if she was treating both sides the same. Different judges care about different things. They're human beings. Different judges care about different things in different ways. Some judges don't particularly care about some kinds of objections versus others. Some judges really care about leading. Some judges don't. Some judges really care about foundation. Some judges don't. Some judges really care, some judges care about, because, there's a lot of latitude of judges. The rules and tradition afford judges a lot of latitude, not for least of reasons they're human beings and they have different styles. Some judges don't care about speaking objections. Some judges do. But as long as the rules are the same for the judge, as long as the judge is treating everyone the same, it's not a problem. The lawyers can adjust. They just are like, oh, this judge really cares about leading, but he doesn't really care about foundation. Oh, okay, so we're gonna, therefore spend a lot more time on the one thing versus the other thing, because that would be the rational response, right? And not necessarily anything wrong with that, because judges get a fair amount of latitude. So the problem isn't that she's a dick to the defense, although even then I think she's being too much of a dick, but still, the problem isn't necessarily she's being a dick. The problem is she's not being equally a dick. And the discrepancy is so wide that it's hard not to draw the conclusion that she's biased. And again, it's not any one thing, because bias isn't really demonstrated. And bias also isn't legally demonstrated in any one thing. The bias is demonstrated legally in the collection of things. Because any one judge is going to judges make mistakes too. They are human beings. And sometimes a judge, makes a mistake or treats someone harshly just because they're in a bad mood that day. They didn't have their breakfast. And sometimes sometimes the judge just woke up on the wrong side of the bed, and they're going to be a dick to you and not a dick to the other side, because, that's just where their patience breaks. So, and again, that's not necessarily even the problem. The problem is in the day after day, week after week. The problem is in the accumulation. The problem is in that we see it repeatedly over time with respect to multiple different witnesses and with respect to multiple different issues. That's the problem, that the judge has a problem. It's also worth noting, of course, as I've noted before, that just because the judge is biased doesn't also mean that she's necessarily wrong. She could be correct despite her bias, because those are not the same thing. Just because the biased umpire calls a strike doesn't mean it wasn't a strike. It could have been a strike. So I've said before, for example, that I think the judge was correct on various rulings, despite my feeling or my conclusion that the judge is biased, because those aren't the same thing. So that's also worth noting, as long as we're trying to make these distinctions, because I think the distinctions are important if we're going to try to be as legally precise about things as we should. So is she biased? I think so. Does that mean she's wrong? Not inherently. And also, whether or not the Court of Appeals will do anything about it is also a whole nother set of issues, because courts of appeal typically give a lot of discretion to trial judges. And the courts of appeal, generally speaking, are not thrilled to reach the conclusion of bias for a lot of practical reasons, as well as, it's not their favorite thing to do. So you have to sort of understand it in that sort of vein as well. I've said before, and I'll say again, the sooner that you realize that trial judges are minor demigods, the sooner that you'll understand what's going on. Trial judges are minor demigods. Try not to piss off the judge and, hope for the best and go and do what you can. Turtleboy has jury tampering breakdown to the source. We could read the article. Okay, that sounds like an interesting thing to do. Let's read that article. If you could be so kind as to drop that on my Discord so you can drop the link, I will cover that story, because you guys are here. As long as you guys are here, I'm happy to talk to you about stuff, because I have an audience that's interested. 3,600 people is a big audience. I will talk about anything relevant as long as it's interesting. So drop me the article and stuff like that. In my Discord, someone said, mods are costing you members. Well, just because you're a member doesn't mean that you can violate the rules. So you still have to obey the rules even if you're a member. So you don't get to own me for your 99 cents. So if you're a dick and you're a member, you're still going to get banned. If the mods are being overly aggressive in their moderation decisions, maybe, but you still have to follow the rules. So there is that. So Please note, you're 99 cents. Even your $500 super chat. If you're a dick, I will ban you, despite your $500 super chat. You don't get to control me. It's not worth it. So, please obey the rules. There's no way Brandon wrote the opening statement. He may not have done. He may not have written it, but it was still well done, whoever wrote it. Oh, yeah, you guys are getting ads, and I forgot to turn off the ads. See, you guys have to remind me every time because the default to ads being on. I don't want ads on my live stream, but I have to manually change it. All right, no more ads. Is it common to bring in a new lawyer and bypass your own prosecutors? No, it's not particularly common. It's not unheard of, but it's not common. Perjury is a discrepancy? A discrepancy isn't necessarily perjury. It's worth noting. Right? I mean, for it to be perjury, it has to be knowingly false. And if just because you gave testimony differently 2 different times doesn't necessarily mean you were lying either time. If I testified 2 and then at a later time I testified 3, it doesn't necessarily mean it was a lie. It shows that I'm not consistent. It shows perhaps I'm not reliable, but it doesn't necessarily mean I'm lying. People's memories are not perfect, but simply note the discrepancy and move on. But yeah. Also, I don't think it's worthwhile to openly accuse them of perjury. Doesn't that mean you're a perjurer is asking the ultimate question? I don't think you should do that. Reserve that kind of thing for close. But yeah. Yeah. Whether the witnesses have been caught in lies is sort of a matter of opinion, right? Just because they're inconsistent doesn't necessarily mean it's a lie. People aren't perfect. If you asked me to tell you something and I told you 2 different things at 2 different times, does it necessarily mean I was lying either time? No. But, distinctions. Stinker Bell says you so disagree. Well, that's fair. You're not required to agree. What was John O'Keefe's cause of death? We don't know. That information has not been presented in court yet. We don't have information relating to cause of death. $4.99 from Mandy Strong. I'm so proud of you. You're doing so good. You will feel better and better as you continue the journey. I support you 100%. Thank you. Yeah, save it for Proctor. Yeah, that's kind of what I'm saying. Try to give yourself somewhere to go. It's also good advice for improv. Like improv, they tell us the same thing, right? When you come out with an emotion, try to give yourself some space to grow so that you can, probably starting out at 10 doesn't give you anywhere to go. Then you could weaken the emotion. You could go weaker, which could be fun, but you probably want to give yourselves latitude in both directions. Try not to box yourself in. I do improv acting, by the way, in case you didn't know. I like improv. It's fun. It's also just good as a skill as a lawyer, incidentally. So it's also good as a legal commentator because you learn how to riff on things. So it's good all around. That makes it a business expense. You better bet your ass. Don't go full Michael Scott when doing improv. Always good tips. Canton cover up 505. Okay, thank you for just the reference. That's fine. So now I have to find it, but I will find it for you because I love you. If I just search for 505, presumably it will pop up. Canton cover up 505. It did pop up. Exciting. Excellent. All right, let's read this thing and see what it has to say about whatever. We turn our attention to Turtleboy Daily News. Canton cover-up part 505. The fact that he has a 500-plus part series is mildly hilarious. Yeah, yes and gets you a long way in improv. Serve the server, yes and, other sort of improv kicks ass. I love you guys. Thank you for being here. You make me feel validated. I'm not going to lie. The fact that there's 3,600 of you that are here and spending time with me really makes me feel good. Thank you for spending time and being with me. It's very, very nice of you. Please come back Monday. Baby, come back. You're like a fool to me. Can't live without you. Baby, come back. All right. Canton cover-up part 505. Disgraced former Dedham cop Ty Donahue is likely source of lies told to John Fanning to have not guilty juror removed on final day of trial. Okay, that's exciting. That's a lot. Let's see if I can make this a little bit easier to read. Change these margins so it's a little bit less marginy. Yeah, we can make it bigger. Make it bigger, 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 bigger. Bigger, bigger. There we go. That's better. On the last day of the Karen Read first murder trial, a female juror who had been making faces throughout the trial also is now a lawyer for Karen Read in the Karen Read case, which I continue to find hilarious. Victoria, we love you. We love you, former juror, now turned lawyer for Karen Read. You kick ass. I find it endlessly hilarious. Had been making faces throughout the trial, indicated they were disgusted with the Commonwealth, was brought in to speak with Judge Canoni. As she walked by the menacing eyes of Brian and Colin Albert, she seemed confused and shocked as Aunt Bev grilled her from the sidebar. Sidebar. This juror, known as Juror A, had previously reported another juror to the court for making negative comments about Karen Read's facial reactions during trial. The other juror was removed that day. And then there's part of a legal motion, which we've previously read, so I'm going to skip that part for the moment. On the day of closing arguments, Juror A was alerted by Judge Canoni that she'd been reported by Lieutenant John Fanning, who was the head of all the security relating to the trial, which, noted, who had told court officers after he received information that the juror had been talking about the case at the American Legion, and there may have been a recording of her doing this. Additionally, Auntie Bev claims that at roll call of the Dedham Police Department, a number of officers confirmed they had heard similar things. Well, did they hear them directly, or are they just hearing it through the grapevine? Who is the original source is still a perplexing question. The court then called a sidebar to discuss this new exciting information with the attorneys. Defense counsel asked for the name of the Massachusetts State police officer who had received the information, and the court officer said it was Lieutenant Fanning, the head of all the security, who also was Michael Proctor's boss, which seems like a bit of a conflict of interest, but whatever. Fanning is a supervisor in the Norfolk County Detective Unit. During the investigation, he was Proctor's supervisor, which seems like a bit of a weird thing. Why are we having Proctor's supervisor being the head of all security relating to the Karen Read trial? That seems like not necessarily the most ideal person to do this. Maybe we should find somebody else. But no, we're going to go with this guy. Seems questionable. Seems questionable. He was also one of a respondent of group of text messages circulated by Proctor that included reference to looking for nudes on the defendant's cell phone, which also makes him a potential witness in the case, incidentally. So further not ideal. We have a potential witness now as the head of all security. That seems problematic. As well as a reference to defense counsel's retarded client's phone. Defense counsel represents, and for the purpose of the motion, court accepts, Fanning also interviewed some witnesses in the case. Fanning himself was not a witness at the trial, but he could be. He could have been a witness. After explaining the situation, the court called Juror A to sidebar. The following occurred. And then Turtleboy writes, Who did Michael Proctor's boss, good friend, and fellow corrupt cop, John Fanning, receive information from? That's a really good question. Who is this original source? I'd really like to hear from them if possible. You know, hearsay isn't necessarily disallowed. Okay, it's not a witness on the stand. So hearsay is not necessarily unacceptable. But, you know, all things being equal, we would still prefer to hear from the original source if we could. So is this original person available? Can we hear from them? It would be nice. It would be nice, if not necessarily required. So if we could hear from them, that'd be great. How did Aunt Bev know what the topic of discussion was at the Dead End Police Department was that day? Who was reporting on their behalf? And where was the illegally recorded conversation? As to whether the recording is illegal, I don't know, because police sometimes are subject to different rules relating to recording, so I'm going to let that pass. During the sidebar, Juror A didn't do herself any favors, but also didn't admit anything she said had been accused of was true. The juror who was interviewed told me she had no idea she was recorded and still hadn't heard a tape of it. When she was asked about the recording, she simply stated she didn't know because she was last at the location over a month ago and couldn't remember what they talked about, because people's memories aren't necessarily perfect. And she is, of course, a lawyer. So she's going to say, I don't know, because she's a lawyer. You know, if you asked me what we talked about a month ago, I wouldn't remember. You know, this actually kind of popped up once. I've told this story before. It's great. It's a great story. When I was a 1L, you know, when I was a first-year law student, I was staying out on off-campus housing, as sometimes we do. The housing had some law students in it, as you would expect, and also had one non-law student in the house. One day, one morning, the police knocked on my door. They knocked on my door. Police? It's like, hold on, let me put on some clothes. It's like, yes, we'd like to ask you some questions about where your non-lawyer roommate was 2 days ago. As it turned out, they suspected my non-lawyer roommate of murdering. It was a murder investigation. It was a little light murder investigation. They thought that my non-lawyer roommate, had done a little light murder. So apparently I lived with a murderer when I was a first-year law student. So that's exciting. And they asked me, as part of this wonderful murder investigation, can you tell me where your roommate was 2 days ago? And I'm like, no. Can you tell me what you were doing 2 days ago? No. Okay, can we tell, what were you doing yesterday? I'm like, okay, here's vaguely what I think I was doing yesterday. And then I sort of was able to sort of cobble together what I thought maybe happened 2 days ago. But yeah, you know, sometimes my memory is like a sieve and so forth and so on. And then they searched the basement for the murder weapon, which they thought was a hammer. And then stories came out. So apparently here's what happened, as I understand it. My non-lawyer roommate cohort apparently had money issues, and he had issues with money in the past. And apparently there was a trust fund that his father had established for him at some point relating to something. And apparently what happened, although I wasn't there, but this is what I understood. Apparently what happened was my non-lawyer roommate friend went up to the third L who lived on the top floor. We had multi-year law students. So I was a 1L, but there was a 3L living on the top floor in the attic. And apparently the non-lawyer roommate asked my 3L cohort, he asked him, hey, by the way, my father has a trust fund for me. Under what circumstances could I gain control of the trust fund? And apparently my third L friend, working the problem, as we do, because, you know, we're just working the problem, you know, without really thinking about it, you know, because, you know, you ask us this question and we just start to work the problem. Apparently my 3L law student friend said, well, among other things, if your father died, that would give you control of the trust fund. Apparently he shared this little piece of information. Fast forward, apparently my non-lawyer friend and his father went camping in their own backyard. And then allegedly he murdered him with a hammer. And the police were investigating that. They then, at a later time, arrested him for check fraud, because apparently, again, with the money problems, they had a check that they believed had been forged by him using his father's signature, but it wasn't really his father's signature. They believed there was a forged check, and they arrested him for check fraud, presumably while they were trying to work on the murder investigation. And I don't remember what happened after that. So fun stories for me at my law school, exciting and fun. So I might have lived with a murderer, and I couldn't remember what happened 2 days earlier. So that was why I shared that story. Anyways, so this lawyer is asked about what happened a month ago, and she can't remember because I couldn't remember what happened 2 days earlier. I was not much help to the police in their investigation. $10 from Kristen from Manhattan. Would I be able to deep dive into the veteran discrimination case you worked on? It's an area of law you don't see on YouTube. The cases are super interesting. Yeah, sure, what the hell? If time allows, and I see no reason not to, I could walk you through the brief I wrote. I've never done it before. I'll walk you through the brief I wrote. And you guys can judge for yourself how good of an attorney I am or not. But I'll walk you through the case. Why not? I mean, she filed, it's all public information. So, you know, and she had previously given me, I won't tell you any conversations we had, but I'll give you the case I wrote. I'll give you the work product because she previously said I could discuss it. So I'll give you that and that'll be fine. So we can go over it. We can go over it today. That'll be fine. I'll share with you the brief I wrote and you can decide for yourself whether or not I'm a good lawyer. It'll be fun and exciting. Anyways, let's finish Turtleboy and then we'll do Supreme Court brief I wrote time. And you can decide for yourself how good I am. In any event, during sidebar, it will be interesting reviewing my own work. It's been a while. It's been a year since I've read it. So it'll be interesting reading and potentially critiquing my own work. That'll be fun. During the sidebar, Juror A didn't do herself any favors, but she also didn't admit that anything she'd been accused of was true. The juror who I interviewed told me she had no idea she was recorded and simply said that I did not know. The juror told me that on her way to court that day, she'd received an ominous threat from an unidentified man trafficked telling her to go quietly. When she got into court, she was flustered and felt ambushed after being called in front of the judge. She felt like she was being put on the spot to remember a night at a bar over a month ago, and for her first time told she was potentially illegally wiretapped. At no point did the juror admit to anything, but yet she was knocked off the jury in the final day based solely on the unconfirmed secondhand story from someone who was invested in seeing Karen Read convicted. Which, incidentally, by the way, if she winds up being convicted and they appeal on the basis of that issue, I wouldn't expect the Court of Appeals to do anything about it because the court gets a wide range of discretion. And the fact the court didn't find her believable is sort of enough. So I don't think that that's appealable grounds. Doesn't mean that they won't try if she's convicted, but I wouldn't think that's likely to win the thing. As evidence of bias, maybe, but unto itself, probably not. There's a backstory to this. This is Ty Donahue from Dedham. Hi, Ty. You could also lose some weight. Ask me how. Lol. Also, we need to talk about your sweater choices. What is up with this sweater orange pant combo? Whatever you're going for is not working, man. We need to talk. Yeah, no. Okay. Not so sure about the hat either. He was a Dedham police officer until 2008 when he was fired for being arrested for driving drunk. Another officer who was driving drunk? Oh no, what are the odds? What are the odds? And flipping his car over on I-93 in Canton. Ty had a personal relationship with Juror A and admitted knowing Brian Albert. Text messages reveal that after the juror found out she'd been chosen to be on the jury, she told Ty Donahue about this, and she said she never heard of any of the witnesses before. Ty is friends with a Dedham man named Ron Hathaway, as is Ty's brother married into the Holloway family. Okay, that's a nice suit combo. Although, ideally, I think your jacket length is a little long. You want to ideally show a little bit of cuff. So I think your jacket needs a little bit of tailoring. But other than that, you're doing okay. And then we have text messages that apparently reveal like their relationship, but we'll let that slide for the moment. We'll just assume the relationship, pressing on. Various text messages. Ron Hathaway didn't want to be tied to the anonymous account because it would reveal that source of his bias. They relay by blood to Jen McCabe and 3 sisters. Is anyone not related to anyone as it relates to this case? Why is everyone related? Does your family tree fork in Massachusetts? Why is everyone related to everybody in this case? Seriously. More pictures of more people. We know each other. Nice bolo tie. Respect. Nice bolo tie. That's bonus points. We got some dancing, presumably at a wedding. That looks like wedding dancing if I've ever seen it in my life. Yeah. On June 25th of 2024, the juror and Ty Donahue had a falling out over a personal issue that got ugly. Coincidentally, the next day before closing arguments, Judge Cannoni claimed members of Ty Donahue's former employer and one of the cops who was on Michael Proctor's inappropriate group text messages reported the juror for statements she allegedly made a month ago at the bar. It just so happens that the guy who felt disrespected over the personal issue with the juror happens to have direct ties to all of McAlberts because of course they do. Everyone's tied to everybody. Everyone knows everyone and everyone's tied to everybody. At this point, I'm wondering how I am tied to these people. Because I must be, right? I mean, I'm talking about the case. I must have a relationship or blood relationship or somebody. I'm not sure who it is, but I must have a relationship to somebody. Who is it? Who do I have a relationship? Where do I fall in this? Who is my real dad? I have questions. I have questions. Have I ever been to 34 Fairview? I don't think so, but at this point, who knows? All of the McCabe's were testified just sat away from the juror who was making faces that suggest they didn't believe a word that was said. Yeah, I'm not surprised either. Brown shoes with a black belt? That's a fair point, man. You're not wrong. The juror was seen making faces in court by Michael Proctor, Yuri Butnick, Brian Tully, Nicholas Garano, $25 from Florida Dad. Didn't catch the beginning of this, but a former Boston resident here. Robbery with a financed couch illustrates just how white trash Massachusetts actually is. And I've lived in Missouri, Indiana, and Florida. I know my trash. Respect, Florida Dad. Respect. Yeah, the white trash is everywhere. New England white trash thinks that their shit don't stink, but in some ways it stinks more, man. Yeah, that's fair point, man. Fair play. Respect. The juror was seen making faces. In October, the same juror received a threatening email from Kevin Leonan, a McAlbert propagandist with a small audience who's been faking terminal cancer for personal gain for 7 years. Please don't fake cancer for personal gain. It is not a nice thing to do. In addition, it's also fraud. Also, it's really dickish. The email is not publicly available, which means Plevin got it from somebody that knows the juror personally. Based on what he said, he clearly has been speaking with people who knew the jury personally, did not like her, and were using Plevin to try to dox her. Plevin falsely accused the juror of being a Turtleboy plant. How's that even possible? Despite the fact that her and I have never spoken prior to trial, and she's only seen one Turtleboy blog from 11 years. And then we apparently have a text message from Kevin Leanham. It says, "You might know of my channel, and because we don't agree on the case, you're probably not my biggest fan. I understand. If you follow me back in summer 2023, summer of 2023, you know my opinion on things evolved as I got more evidence and had time to test the logic. But I always tried to be fair and open with the evidence. Well, we all hope for that. We all hope for that. I always try to put my cards on the table. I'm doing a book on the case with November 15th deadline by the publisher. I know some of your story and plan to include a small part of it in the book. I'll protect your anonymity. I think all the jurors should be protected and I don't think the list should ever be made public. Your jurors suffered a lot, as it's made a huge difference. If you'd like to talk to me, I welcome it. If not, I completely understand and will be assured I'll never bother you again. I endeavor to write things in the book in a way which won't risk your exposure or make you uncomfortable. Thank you for your service. Sincerely, Kevin, apparently from Yellow Cottage Tales, I'm assuming. And then someone said, presumably the juror said, how did you get my name and contact? As much as I always aim to lay my cards on the table, I always keep my promise. So if anyone gave me something anonymously, I honor that. I hope I didn't alarm you. You have nothing to worry about. I have no intention of outing you or doing anything you're uncomfortable with. And then apparently they said, what part of my stories do you believe you know? The message does alarm me. I never get this email. What part of my story do you believe you know? I have a live show in a few minutes, so let me get back to you in more detail. I know of what happened right before you were dismissed, so he has personal knowledge, apparently, relating to this. I'm only interested in parts relevant to your jury service. I don't think I want to go into a whole lot of detail. My objective is to tell what needs to be told and no more. But some of this needs to be told. The objective is not to sell books. Well, if you're writing a book, it is. I mean, just, that's literally the objective if you're writing a book, literally. But, pressing on. The objective is not to sell books, but we have another trial coming up, and there are questions about how you got on the jury in the first place, concerning the passionate beliefs you seem to hold before being impaneled. Well, if those facts weren't illuminated during that voir dire of that juror, then that's the lawyer's bad. So if she has passionate views that weren't exposed, then the lawyer's screwed up. Did you tell the complete truth on the jury form? That's pretty aggressive. I protect your anonymity and will continue to protect it. I've shared no identifying information about you and will not. But now you've sent my number to Aiden, which he broadcasts on the show, so I'm being bombarded with calls. Yeah, probably don't do that. Again, it isn't necessarily illegal to dox people, but just don't do it. It isn't nice because you don't necessarily know where that's going. And also potentially could lead to civil liability. It isn't necessarily illegal in and of itself, but it could be reckless that potentially could expose you to liability because you might know or should have known that exposing the number could lead to harassment, and so could potentially expose you to civil liability, and also still not necessarily a nice thing to do. So try not to do it. Jen is her own grandma. Respect. I thought you couldn't dox jurors. No, it isn't illegal unto itself. If somehow you know that, it isn't illegal unto itself. The court will not necessarily make the information public, but if you happen to know it, you happen to know it. So if you happen to know who the juror is from whatever, and you make that information publicly known, it isn't unto itself illegal. I say with very deliberate care, unless of course you're one of the attorneys. If you're one of the attorneys, it might be illegal, but if you're just a general member of the public, then not so much. $4.99 from Morrissey's iCloud. Kurt, is that really you? I've been searching for years. Your sister in Boston. Hello, Denise. I didn't know I had a sister. Nice to meet you. That was a good one. Thanks for the funny. I appreciate it. That was good. Well timed. Well done. Oh man. Did you answer the jury questionnaire honestly? Did you inform the court that time you were a turtle rider? Turtle rider is an interesting juxtaposition. That strikes me as very humorous. And we're very well aware of his coverage of the Karen Reed case. Did you inform the court during the trial you were following his coverage? Everyone's entitled to fairness in the court system, Karen. Oh, apologies. Everyone's entitled to fairness in the court system. Karen, John, everyone. A fair trial with impartial jurors is essential. Maybe you can be helpful in ensuring the next trial is fair. Each of us must let our consciousness guide when doing what's right. To repeat and reemphasize, I'll never pass or report identifying information. And then Turtleboy writing says, it's a complete lie that this woman was well aware of Karen Reed's coverage prior to being chosen on the jury, and Ty Donahue is well aware. Here's a text message sent from the juror to Ty Donahue after she was chosen to be on the jury, in which she said she didn't recognize. Well, just because the juror says it doesn't necessarily mean it's true, to be fair. The juror could be lying. So just because you tell me you didn't know doesn't mean that you didn't know, or I don't have information you knew. So, I mean, those aren't necessarily the same thing, but pressing on. The text message apparently said, they took me back and forth from the side of the bench 3 times, the judge and all the lawyers. Brian Albert is a piece of shit. I know him personally. He wasn't on the list of witnesses. I don't know who that even is. They read 160 names. I recognize 0. He must be somewhere between your age and my age. He's a Dedham kid. He's a detective for the DA's office. Jeff or Brian? Jeff wasn't on the list. No clue who Brian is. I would have recognized it because I know Chrissy. Yeah, his brother. Brian Albert is the Boston cop. Guys, try not to let the chat devolve, okay? Just let the moderators handle it, please. And try not to exchange words, okay? Then it gets messy. Just let the moderators handle it. And if someone's bothering you personally, you can always personally block them. It goes a long way. Just saying. So, but let's try to, not, keep things nice. You guys are doing okay. Try to keep it nice in there. Multiple sources reported Ty Donahue is also an illegal bookie, which is somehow still a thing despite legal online gambling, who may or may not have been thrown out of his house by his wife in July after he became upset with a juror, and this post was left about him on Free Karen Reed Facebook group, which cannot be confirmed. Seems Emily threw him out of the home, and this is just some random post from somebody, so who knows how true this is. Seems Emily threw him out of the home that she owns back in July. He wasn't allowed at the hospital where the second kid was born, and there are 0 family pictures of him on her social media. Someone should let this woman know she looks better without the extra 400 pounds of dead weight. The guy is a piece of garbage. He will lie and manipulate anyone and everyone to get what he wants. For some reason, he thinks he's God gifted to the universe. He's known for being completely drunk, drinking upwards of 24 beers a day. That is pretty hefty. And putting his something in the car after driving, presumably kids in the car after driving. The friends and coworkers I spoke to weren't surprised that this fat slob thought he could get away with jury tampering. Sounds like he's a pompous ass who believes he's untouchable by law enforcement and will never have to face any consequences. Needless to say, no one has anything nice to say about this guy. It seems unlikely to be a coincidence on the day after the jury had indirect ties. You thought Kurt was thought Kurt was wrapping it up? Yeah, at one point Kurt thought he was wrapping it up too, and then I noticed I had a huge audience, and people asked me to talk about more things. And I'm like, geez, as long as there's 3,600 of you, guess what I'm going to do? I'm going to keep talking about things as long as there's things for me to talk about. As long as there's 3,600 of you here, damn, I'm not giving up a captive audience. Are you out of your mind? So as long as there's things for me to talk about, I'll keep talking, man. I'll keep talking. We can stream all day. We can do anything, man. That's great. I get some water. I can do some caffeine. It's perfectly fine. Anyways, carrying on. It seems unlikely to be a coincidence that the day after the guy with indirect ties to the McAlberts had ugly falling out with a juror who had been lying about personal matter for months, the Judge Canoni would suddenly get secondhand reports from John Fanning and Dedham police officers about something she allegedly said at a bar over a month prior. Either way, Ty Donahue was upset and wanted to harm the juror with by having him thrown off the jury, and in doing so, a clear not guilty juror with strong personality wasn't to be in a jury deliberation. This is jury tampering. It might be jury tampering, which incidentally, by the way, doesn't necessarily mean the judge made a mistake, because those are separate issues too. So whether or not someone could be charged with jury tampering is not quite the same issue as whether or not the judge made an error in excluding the juror. because the judge only knows what they know. Now, maybe they should have known more things, but whether they were required to know more things is not the same thing. And whether or not they made a reversible error is also not the same thing, because, of course, every question has to be analyzed under its own terms. Yeah, keeping your eye on the ball of the question in law is a very good skill. Keeping your eye on what the question is important, because then you'll know what's relevant and what's not relevant, and also as you ask different questions, you might get different answers. So yeah, that's important. $4.99 from English Kate says, I'm glad too. Just miffed I didn't stay tuned in. But back again, let's go. $20 from Forrest Dump. Running cross country Texas from Boston, looking for a long lost cousin, Kurt, aka Bubba. I hope I find him. And that's all I have to say about that. And $5 from John, who chose to yell at me, which isn't necessarily appreciated, but at least it's a super chat. John said, please try the carnivore diet. It saved my life. You have my number. Well, I've tried many different diets at many different times. As you can appreciate, I am a fat and have been a fat for quite some time. And I have tried many different diets to limited to no success. Also, at the moment, I am doing something that's working. Stay off my lawn. And that's what I have to say about that. If the carnivore or keto or any other diet worked for you, I'm glad something worked for you. That's awesome. I'm glad that what worked for you. That's great. I'm doing something that works for me. Stay off my lawn. I've also tried many other things in the past. Stay off my lawn. But thank you for the super chat in any event. It seems unlikely to be a coincidence that day that after this guy with indirect ties to McAlbert's had an ugly falling out with a juror who'd been lying about a personal matter for months, that the judge would suddenly get secondhand reports from John Fanning and dead-end police officers about something she allegedly said at a bar over a month prior. Either way, Todd Donahue was upset and wanted to harm the juror by having her thrown off the juror, and in doing so, a clear not guilty juror with strong personality wasn't allowed in the jury room. That is jury tampering. It might be jury tampering, which also is not the same thing as the judge making a legal error. And that is the end of that post. All right, as promised, we are now going to go through the Supreme Court brief I wrote. I know you're excited. I'm excited. I haven't looked at this in a while. So we're going to take a look at this. And give me a second to pull it up, because I have to remember, I have to find it. So talk amongst yourselves while I pull this up real fast. Okay, hold on. Ba 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 ba. Do 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 do. Ba 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 ba. I'll just pull it up from my folder and hope it's the last thing I sent. Let's see. Where's mine? I'll just pull it from my docs. Let's see. What is the last thing in time? And this looks like it might be the last thing. Why is this one dated after this one? That's a good question. I think this is the last one in time I wrote. All right, let me just, make sure. Let me check something real fast. Okay. And Case documents, document search. Yeah, petition was denied. Of course it was, back in November. I just want to double check to make sure before I reviewed it. So yeah, the attorney that she wound up hiring filed, and the petition was denied, which incidentally, by the way, I told her, well, yeah, I mean, I will just, yeah, I won't tell you what I told her, but I'm not surprised. And, you know, because Supreme Court petitions are hard. But I will share with you what I wrote, and you can judge for yourself whether or not you like my writing style. And we'll go from there. And if you want to read, you know, what her lawyer wrote, you can, of course, just pull it up on the Supreme Court docket and read the brief. It's public record. So if you want to read it. So, and, you know, there's nothing in this that would reveal like confidential communications, because it was all intended like to be publicly filed eventually anyway, of course. So, you know, all that good stuff. Disclaimer, disclaimer, disclaimer. Let's see. Transform, reset transformation. Okay, great. All right. All right. Let's read a Supreme Court petition that yours truly wrote. But did not file, because, as I mentioned, the client decided to ultimately hire a different attorney to file a different petition, because the client had reasons for believing that that attorney had a special in, and I was like, I don't think so, and they didn't get it anyway, but that's all right. So we turn our attention to the case that would have been in the Supreme Court of the United States, in the case of Luz Maria Arrero versus Volvo Group of North America, on petition for a writ of certiorari to the United States Court of Appeals for the Seventh Circuit, petition for writ of certiorari, written by yours truly, Kurt Mueller, counsel of record, or would have been if I had been retained or capped, law offices Kurt A. Mueller, at, you know, my address, kurt@uncivillawllc.com. Exciting. Counsel for petitioner. The question presented. Here's how I would have phrased the question. The Uniformed Services Employment and Reemployment Rights Act, USERRA, safeguards military personnel, including National Guard members' employment, from being affected due to military service. Specifically, USERRA protects service members disabled, incurred during military service, from job termination by requiring employers to accommodate service-related disabilities by offering suitable alternative employment. So this is similar but different to the American with Disabilities Act. The American with Disabilities Act generally requires employers to continue employ disabled people, but they don't have to necessarily provide as much accommodation as they do with respect to disabled service members. So disabled service members get some additional protection on top of what they get under the ADA. So the ADA, like if you're handicapped, generally your employer can't fire you, but they only have to provide accommodation that is not unduly burdensome. And so that doesn't necessarily require them to necessarily do anything. It doesn't necessarily also require them to find you a different job within the scope of the employment. So if they hire you to be one thing and you become disabled and you're no longer able to do that job with more than, you know, a basic accommodation, if they have to do more than the basics, they don't have to continue to employ you, and they don't necessarily have to continue to find you a new job. So in the service members, they get more protection. So they have to, like, basically, among other things, they have to basically find you any comparable work they could do. So they have to give you more. So USERRA protects service members who are disabled as a result from military service from job termination by specifically requiring employers to accommodate service-related disabilities by offering suitable alternative employment. So they have to find you any job that you're qualified for. In the lower courts, Volvo contended that the petitioner in this case, was unqualified for her pre-service position upon return from combat due to disability. Under USERRA, the client had a right to argue that Volvo failed to sufficiently attempt to qualify her for an alternative position. However, the lower courts erroneously prevented the client from presenting evidence of her post-traumatic stress disorder, incorrectly deeming it to be irrelevant to her claim and ruling that it would only be pertinent to the American with Disability Act. The Seventh Circuit Appeal Court erroneously affirmed. So my legal argument is, okay, I think she was disabled. The nature of her disability is PTSD. That's the nature of her disability. I believe that PTSD was caused by her service-related employment. Okay, that is the nature of the claim. Therefore, she had the right to argue it under USERRA. The lower court said no. You only have the right to argue it under the ADA. The Court of Appeals said no. You only have the right to argue it under the ADA. So that is my basis of legal error. That is the argument of legal error. It's like, no, she had a viable claim under USERRA as well. She should have been allowed to argue it, and she wasn't. Thus, the question presented. When there is a claim under USERRA, must the trial court permit a veteran to submit essential, logical, and legally relevant disability evidence to support a claim of an employer's failure regarding quote unquote reasonable efforts relating to their service? And then related, I would have hopefully caught that typo because this was a draft. It was a non-final draft. So this was the latest draft, but not necessarily final draft. So that is my argument. So if there's a claim under USERRA, must they be allowed to present essential, logical, and legally distinct evidence to support what reasonable efforts mean within the scope of USERRA, and reasonable efforts within the scope of USERRA do not necessarily mean the same thing as they mean within the ADA. Must they be allowed to present that evidence? So that's the way I framed the question. I thought that was pretty good. The parties to the proceeding, the petitioner was plaintiff appellant below, Volvo was defendant appellant Revo, and then, cases responding to this because she's already been to the Court of Appeals now twice. So there were two proceedings, right? There was a Court of Appeals opinion that reversed. The Court of Appeals, the district court initially ruled summary judgment. The Court of Appeals reversed, said not so much with summary judgment, back to trial court. The trial court said on the second trial, this evidence doesn't come in. The Court of Appeals said the evidence doesn't come in. So two Court of Appeals decisions that are relevant and two district court proceedings that are relevant relating to this case. Then we have our nice table of authorities, which is all nicely laid out. Reasons for granting the petition. The stipulated facts of this case, because this was a stipulated facts case, which makes life easier. So we don't have to worry about what the facts are. They're stipulated. Great. That makes our lives easier, right? So why should you take this case? The stipulated facts of this case make it a good vehicle for deciding the issue of reemployment protections for wounded and disabled veterans. The manifest intent of Congress was usurped by the courts below to the severe detriment of veterans. The scope of USERRA is greater than that of the ADA, as informed by the Department of Labor's rules, which demand evaluation of failure to accommodate claims within the meaning of USERRA. For what it's worth, by the way, at the time I wrote this petition, Chevron was still good law. Chevron was still good law at the time I wrote this petition. So you better bet your ass that I'm citing all the rules, relevant to it. And of course, the agencies, they're entitled to all the deference. The agencies can't ever be wrong. Don't you know Chevron is good law? Do I hate Chevron as a case? I think as a case, Chevron's bullshit. I've said Chevron's bullshit multiple times, but now I'm your lawyer. Chevron's the greatest thing ever. Chevron's, of course, fantastic. We love Chevron because Chevron helps you. Chevron helps my client. So Chevron's the best thing ever. Of course, it's great and wonderful in every way because it assists my client. So please do the Chevron, nice Supreme Court. And then carrying on, PTSD as a disability impacts millions of veterans who are entitled to reemployment. So I'm going to do a little bit of, emotional appeal here at the end. I'm going to do a little emotional appeal here at the end. Think of the veterans, think of the millions of veterans. I'm going to do a little tugging at the heartstrings at the end, hopefully to sell the case. And then we're going to send the conclusion. And then we have a whole bunch of appendices relating to a whole bunch of stuff, relating to the cases, because I have to give them all the cases. So I have the appendix, which I would have given them, and along with the associated case numbers on which, they appear in my appendix. Then, of course, we have our nice little table of authorities, which is all written very nicely in nice table of authorities format. It's all very pretty with the right page numbers, the right pages. It's all very pretty. Then we have a whole bunch of statutes that we cite along with their pages in which they appear. Here, I should have just probably written passum instead of giving each individual page number, but again, it was a rough draft, so I would have probably changed that to passum. And then also I'm citing a law that no longer exists, but I think is relevant. So I'm citing law that was eliminated, but I'm still going to cite it anyway because I can. Congress may have repealed the law, but I'm still citing it anyway. You can't stop me. Ha 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 ha. I will cite anything if I think it helps. And then we got some other authorities, including some statutes. We got some stuff that Congress wrote, from the congressional record. We got, some law review stuff. We got some, U.S. bills that, have some text we're going to cite, some more, some more articles that we wrote, some laws that were passed, some more, things that people wrote. We have something from the U.S. Veteran Affairs itself. Then we have a whole bunch of federal rules we're going to cite. And of course, we're going to cite the Constitution at one part because we love the Constitution. Constitution's great. All right, $5 from Jen Decker. Thank you very much. Petition for writ of certiorari. Disabled veteran of the United States Army respectfully petitions for writ of certiorari to review the judgment of the U.S. Court of Appeals for the Seventh Circuit. The opinion below. Not $4.99 from Vasker. You mentioned Alan's stage presence earlier. Is that part of a law school curriculum, or do you take improv or acting lessons? It's not part of the curriculum. Some people do take lessons, and they really should. Some people are just naturally good at it. But every attorney should take public speaking lessons, and in my opinion, should take some acting classes. They literally have acting for lawyer classes. You should take some acting classes. It's a different stage, but it's a stage. The courtroom is a stage. You have an audience. So you absolutely should do it. So do that. Thank you for your super chat. The opinion below. The District Court for the Northern District of Illinois' initial summary judgment of all claims in favor of respondent is reproduced because, as I mentioned before, initially the trial court said you just lose on the merits. You just lose summary judgment for Volvo. The Seventh Circuit reversed and said not so much summary judgment for Volvo. Back to trial court. The District Court for the Northern District of Illinois entry of order for a new trial on USERRA claims is reproduced. So the Northern District of Illinois, or the Court of Appeals said specifically, do USERRA. Because I think the trial court initially just did ADA. And the Court of Appeals said, no, you got to do USERRA. This is a USERRA claim. And so, please do USERRA. So, and I want to mention that, of course, because I'm like, this was about USERRA, because that's my entire point, is this is about USERRA, not the ADA, because I think I can win under USERRA. At least I think I have an argument under USERRA. The order relating to operative motions in limine is reproduced because there were some motions in limine that are important for me to note. The Seventh Circuit opinion is unreported and reproduced. Seventh Circuit denial of motion for rehearing and rehearing en banc is reproduced. So they denied rehearing, denied en banc, which means it's time to go to the Supreme Court. Jurisdiction. The U.S. Court of Appeals issued its second decision relating to the second appeal and denial for petition. The petition is timely. It would have been. The court has jurisdiction because it's a writ of appeal from a court of appeals. So you have the right. You have jurisdiction because I want you to review the Seventh Circuit because you're their boss. Statutory provisions involved. The relevant law. 38 U.S.C. 4313A3 is entitled Reemployment Positions and provides. So this is the law that is going to be the most operative to me, in my legal judgment. And the law says, in the case of a person who has a disability incurred in or aggravated during such service, military service, and who, after reasonable efforts by the employer to accommodate the disability, is not qualified due to such disability to be employed in the position of employment in which the person would have been employed if continuous person of such person with the employer had not been interrupted by such service. Okay, Part A. in any other position in which is equivalent in seniority, status, and pay, the duties of which the person is qualified to perform or would be qualified to perform with reasonable efforts, or, if not employed under subparagraph A, in a position in which is the nearest approximation to a position referred to in subparagraph A in terms of seniority, status, and pay. So, rephrasing into English, USERRA goes further than the ADA. USERRA says you have to not only employ reasonable efforts to make the employee qualified in the job they had, but you have to do more than that. You have to do reasonable efforts to make them qualified in any position in the employer has. And even more than that, you have to give them equivalent seniority, status, and pay to what they had. So not only do you have to make them qualified in this new exciting position, you have to pay them as though they had the same level of seniority in their old position. So it goes a lot further, right? It's like you were this position, now you're this position, but I'm going to pay you based on whether basically that you had been doing this new position the entire time. So if you had been doing 8 years in one position and now suddenly you're in a new position, I am required by law to pay you and give you the same status, same seniority as though you had been doing this new job for 8 years. So it goes a lot further. At least that's the way I read it. And and basically I have to give you that position or any position that's the nearest approximate to that position. So I have to go a pretty long way under USERRA. USERRA gives you a lot of protection. All right, so let's read what happened in the case, at least according to me. I wrote this. It is designed to be biased in favor of my client. Disclaimer, I am not neutral. I am not trying to be neutral in this document. I am literally paid to advance the client's interest. So this is designed to be biased, or it's designed to be, let's say, as favorable as it can be towards them. So everything I say is true. I hope it's true, but it is designed to be favorable. So, just to, make obvious what's obvious, paid lawyer going to advocate for their client's interest because that's literally the job. All right, so what can we learn about this case, at least according to me? Luis Maria Herrera was an Army reservist and veteran that was hired by Volvo in 2005. During petitioner's employment, petitioner was called into service in 2006, 2008, and 2009. Pursuant to USERRA of 1994, her employer was required to reemploy her after completion of each term of military service, which they do, right? Every single term, they're required to reemploy her. They don't have a choice, hire her back. The critical issue is that unlike the Americans with Disability Act of 1990, the relevant law here, or that's the ADA rather, the obligation to reemploy requires the employer to reinstate a disabled veteran regardless of whether the employee remains qualified or not in their prior position. So the ADA only requires that they be qualified in their current position. It only requires that they extend reasonable accommodation, which is basically de minimis. So they're not required to basically do anything more than de minimis. And they're not required to find you any new job. That's the ADA. The ADA provides you some protection, but not as much as USERRA. With USERRA, Congress clearly intended to provide additional benefits to veterans above and beyond those in the ADA. My entire point is USERRA goes further than the ADA. And so I should be allowed to argue this under the ADA. The decision of the Seventh Circuit violates the constitutional separation of powers by usurping the exclusive authority of Congress to write laws upon the weighing of the competing interests at play. If the employee is qualified, USERRA requires that the employer to reemploy the veteran, quote, in a position of employment in which the person would have been employed if the continuous employment of such person with the employer had not been interrupted by such service, or a position of like seniority, status, and pay, the duties of which the person is not qualified to perform, citing the relevant statute. However, if the employer is not qualified due to a disability incurred in or aggravated during such service, as the stipulated facts in this case provide, so I'm arguing that Volvo agrees to that, the employer must first make reasonable efforts to accommodate the disability, which would be consistent with the ADA, and if the employee remains unqualified, the employer is required to transfer the employee into, quote, any other position which is equivalent in seniority, status, and pay, the duties of which the person is qualified to perform or would be qualified to perform with reasonable efforts. So again, like, find them anything else. Do you have to train them? Too bad. Do you have to give them training? Too bad, so sad. Do you have to treat them as though they've had this new exciting position for 8 years? You sure do. Is that sad for you? Perhaps that's sad for you, but that's the way Congress wrote the law. So suck it up, buttercup, as they might say. Respondent Volvo has argued, and the courts below have found, that petitioner was not a qualified person within the meaning of ADA because petitioner was unable to satisfy conditions of her employment either with or without accommodation. Assuming arguendo, of course, I'm not going to concede anything I don't have to, so I'll just say it's true for the purposes of argument. I'm not going to concede it. Assuming arguendo, petitioner was not qualified, if petitioner was not qualified due in any part to disability incurred in or aggravated due to military service, the employer under USERRA has an obligation to reemploy into any other position which is equivalent in seniority, status, and pay, the duties of which the person is qualified to perform or would be qualified to perform with reasonable efforts by the employer. The evidence of petitioner's disability, including its origin and how it was aggravated by military service, was not only relevant, but essential to the claim, right? It's like, okay, her disability is pretty relevant. Also, how did she incur the disability? Also kind of relevant. Because USERRA only protects the disability if it incurred because or was aggravated due to military service. If she's disabled for some other reason unrelated to military service, she has no protection under USERRA. She might have protection under ADA, but she has no protection under USERRA. So she's only protected under USERRA if it happened as a consequence of her military service. So, what caused the disability and whether it was aggravated by her military service, kind of relevant because it goes directly to the USERRA claim, right? I'm not saying she's disabled just because. I'm saying she's disabled because of military service. That's the point. The claim was against Volvo for failing to reemploy or transfer her to a position that had accommodated her military incurred disability. Additionally, evidence of underlying military-related animus on the part of respondent was firmly established in the court below. And there sure is. I actually have evidence in the case that was presented at trial that Volvo had messages. They had emails that seem to reflect they're not really happy with the fact that they have the USERRA. They're kind of a little bit pissed about it. They're kind of a little bit pissed that they have to reemploy and pay this military service person because she's gone away for long periods of a time. They're not super happy that this person that they're employing is gone for like 6 months at a time or 8 months at a time or a year or whatever, or 2 years or whatever. They're not really super thrilled with the fact that this employee is gone for long periods of a time. And then, 4 months later, 6 months later, a year later, 2 years later, they're not super duper thrilled with the fact that they have to bring the employee back. And even worse than that, they have to pay her as though she were there the whole time. So if she would have been entitled to a raise, they have to give her a raise. They have to treat her though she was there the entire time. Sucks to be you. Sucks to be you, but that's the law. So suck it up, buttercup. Right? So I have some emails from her employer that say they're not super duper thrilled. So it's like a little bit of animus. They're not super duper thrilled. Are they required to be thrilled? No. Are they required to suck it up? They sure are. 499, ARCA should be able to let through your son to persecutions experts. Maybe so. Maybe they should be allowed to. That's fair. So anyways, I have some evidence of underlying military-related animus. The trial court found and the Court of Appeals argued that there is evidence that from the beginning of her employment, whose supervisors disliked the burden her frequent military leave placed on the company. They repeatedly discussed disciplining her and denied her rights, such as travel time, to which she's entitled. Some of the emails come close to a direct admission of management's frustration. I am now quoting a court finding. It's not me who sang it, right? As a lawyer, the best things you can do is cite the court or cite the opposing party, right? So I'm like, it's not me, Your Honor, who sang it. It's Volvo who sang it, or it's the court who sang it. Believe them. Believe Volvo. Don't believe me. Believe Volvo. Believe the court. Don't believe me. The court said it was true. The court said The court said there is evidence that the supervisors disliked it and repeatedly discussed disciplining her, and some of the emails come close to admission. The court said that, so I'm feeling pretty solid for my argument, you know? Furthermore, the employer stipulated that the employee's disability was incurred for military service. Well, that's nice. So I don't have to have that argument. The employer said it's true. Again, nothing better as a lawyer than quoting the opposing side or quoting the court. It's not me who says the disability was caused by the service. It isn't me, Your Honor. Vavo says it. Believe them. Vavo says it. Believe them. Evidence regarding her military incurred disability was essential to her claim that the employer did not reemploy her in a position that accommodated disability. I really would have liked to been able to present that information, Your Honor. Seems like it's probably pertinent. Would be nice. The trial court erred and engaged in an egregious abuse of discretion in finding presentation of PTSD disability evidence irrelevant to USERRA. And I'm like, yeah, that doesn't make sense, right? I mean, it's any disability that incurred his military service. Volvo says the disability occurred as a result of her military service. The disability is PTSD. So it's like, this doesn't make any sense, right? It doesn't to me, right? It's like USERRA protects you for any military disability. Volvo themselves say it's a military disability. Yet the trial court said, I can't present evidence of PTSD. Or not me, but, the client, because I wasn't her lawyer at that point. But they said the client can't present evidence of PTSD as evidence relating to her disability, relating to management's failures. She can't present evidence of PTSD. How does that make any sense? I don't think it makes sense. So I'm like, yeah, that doesn't make any sense to me. The trial court made this reversible error by erroneously finding USERRA is not a disability discrimination statute. I don't know. I mean, kind of seems like it is to me. It talks a lot. I mean, I don't think I'm just making shit up. It seems to me that USERRA talked a lot about disability and disabled during service. It seems like it's a disability discrimination statute. I mean, veteran specific disability discrimination statute, but the trial court apparently thought USERRA is not a discrimination statute, which seems like a hot take. The trial court inexplicably limited the statute to USERRA discrimination claim arising out of a different section without application of the entire statute, specifically this statute. So the statute, of course, has multiple different sections, as one does. And the trial court said you can only make arguments under this section, not this section. And I'm like, but I have an argument under this section. I'd like to be able to argue section 4313, Your Honor. You said I can only argue 4311, but I think 4313 is also relevant. I'd like to be able to talk about that too. And the trial court's like, no, you're not allowed to talk about 4313. But I'm like, but that's my claim. That's my claim. I want to be able to talk about it. And the trial court's like, no, you can't talk about it. Can't talk about it. I'm limiting you to 4311. I'm like, I don't like that. This manifest error disregards this court's repeated instructions in previous case to liberally construe for the benefit of those who leave the private life, who left private life to serve their country in honest to greatest need. Always helpful to cite the U.S. Supreme Court. So I'm like, why should the Supreme Court take the case? Right? Well, Supreme Court, they're disobeying you. They're defying you. They're defying you. You've said that, cases should be liberally construed for the benefit of those who left private life to serve. Cite the U.S. Supreme Court, which also incidentally cited another case from the Supreme Court. Cite you twice. The trial court found that it was, quote, it was not until after returning from her second disability that she received treatment from symptoms from PTSD, was formally diagnosed with PTSD, and began therapy for the condition. Put differently, Arrera, the client, did not have PTSD until the final year or so of her more than 6 years of employment. The trial court found that she had a military incurred disability, but with manifest error and in complete disregard to her enhanced rights as a veteran due to service of her country, refused to allow Arrera to present evidence of her disability as part of her claim that Volvo failed to meet their obligations to provide the disability suitable work. I'm like, that they didn't allow me to present the evidence, Your Honor, so how was I supposed to win? Evidence of discrimination on the basis of military incurred or military aggravated disability was available to the trial court as confirmed by the Court of Appeals in their first reprimands. The Court of Appeals said, no, there's evidence of military-related animus. In interpreting the law of the case, which, this is where law of the case comes down, right? Because, it's the law of the case. The Court of Appeals has made a decision, and that binds the lower court now. So it's like, that's law of the case doctrine all day long. Every day, twice on Sunday, right? In interpreting the law of the case and mandate from the appellate court, the trial court found that in discussing the evidence that could be sufficient to convince a reasonable jury that the client was the victim of disability discrimination, the Court of Appeals focused only on events that took place after she returned from her second tour of active duty and began exhibiting of PTSD. There was evidence that the petitioner had disability incurred from military service upon returning from her second combat deployment. Therefore, the petitioner had a valid disability claim under the ADA. However, due to the stipulated fact that disability was directly caused by military service, the petitioner also had a valid claim under USERRA, which she was unjustly prevented from fully pursuing. So I'm like, yes, she had a claim under ADA. I mean, everyone's protected by ADA. She might not have been able to win under ADA, but she had a claim. Her ADA claim, incidentally, was dismissed. So she did file an ADA claim. It was dismissed. And she also filed a claim under USERRA, which also was dismissed. I'm not arguing ADA. I'm not raising the ADA issue. I'm just going to argue USERRA. Again, strategic consideration. Because I think, I'm trying to present the best possible case. So I thought, I didn't really think I could get anywhere with the ADA, but I thought maybe I could get somewhere with USERRA. So I'm like, I'm only going to talk about USERRA because that's how lawyers have to make decisions. And that's one of the decisions I made. Unlike the ADA, a USERRA claim remains valid even if petitioner is deemed not qualified due to disability. So under ADA, if you're not qualified, you lose, but you don't lose under USERRA. If, as petitioner contended, that the respondent exhibited animus resulting from military disability, shown by their unwillingness to accommodate her disability, the existence of the military disability was crucial and fundamental to her claims under both 4311 and 43 Part A and Part C. This animus informed respondent's actions related to the military-related disability. The trial court erred as a matter of law by ruling the jury could not properly find for that. Yeah, just to kick in the teeth, it went to the jury. The jury reached a finding in favor of my client. And then the trial court's like, nah. So yeah, just additional kick in the teeth. The trial court reversed the jury. The jury found in favor of my client. And then the trial court's like, nah. The jury shouldn't have considered that evidence. The jury shouldn't have, no, how about no? How about you lose? How about that verdict just disappears? So that, just further kick in the teeth. The client won for a jury and the court's like, nah. So that was not great. Anyways, pressing on. The jury could not have properly found it for the client if it were to conclude that PTSD was a substantial or motivating factor in the decision to terminate her. Yes, they could have, at least in my opinion. They could have absolutely done that. Yeah, injecting the issue into the case would risk inviting the jury to do that, given the client had an unjustifiable second bite at dismissing her ADA claim. So the trial court's like, this is a second bite at the apple. And I'm like, no, it's not. It's a different claim. It's a different claim. It's a different cause of action. She has more than one cause of action. It's not a second bite at anything. They might be related. They might have close relations, but they're not one and the same. And that's not like unheard of. Lawyers do it all the time. Lawyers bring causes of action that have overlap. There is some overlap between ADA and USERRA. I won't deny it. There is some overlap, but they're distinct. And the trial court's entire theory here is, well, PTSD would have been valid under ADA, but if I allow you to argue it under USERRA, I'm giving you a second bite at the ADA claim. I'm like, no, you're not. You're not giving me a second bite at the ADA claim. You're giving me a bite at the USERRA claim, because the USERRA claim is distinct from the ADA claim. Are they similar? Yes. Is the evidence overlap? Yes. Could I have won under ADA? Probably not. Might I have been able to win under USERRA? I should have at least had the chance. And so the trial court's saying you can't present the PTSD evidence because it would have tainted things, because it would have been a second bite at ADA. I'm like, no, it's not. It's none of those things. No, it's not, Your Honor. You're just wrong. I continue. The command of USERRA mandates the presentation of the very evidence the trial court excluded. That's the way I read it. USERRA mandates that the jury be presented with evidence regarding the disability to accurately assess the nature of the disability. I mean, duh, right? I mean, I'm trying to argue that she has a military disability. It would be really helpful if I could present evidence, relating to the disability. That would be nice. So the jury could consider it. That might be helpful. I should be allowed to do that. This allows the jury, as finder of fact, to properly evaluate Volvo's failure to make suitable employment efforts under the relevant law. The Court of Appeals for the Seventh Circuit was thus also in error as a matter of law by finding the district court did not abuse discretion in excluding the evidence, because I think they did. The decision below must be reversed. This court should grant certiorari in reverse. So far, I think I'm doing pretty well as a lawyer. I think I'm making a fairly persuasive case. There's an argument against. I'm not going to lie that there aren't arguments against. I'm presenting the best possible case for my client, but I think I'm doing a pretty solid job trying to make this case. Think I'm doing all right. Hopefully you agree. Hopefully you think I'm doing okay. All right, statement of the case. So now I have to educate the Supreme Court about what happened, because I have to tell them what happened in the case. So I have to kind of get through the case as fast as possible to give them the information that they understand. So let's tell the Supreme Court, and thus also you, what exactly happened. First, the statutory background. Protections for those serving have long been a feature of U.S. federal law. As early as the Militia Act of 1792, Congress provided that if any person, whether officer or soldier, belonging to the militia of any state and called out into the service of the United States, be wounded or disabled while in actual service, he shall be taken care of and provided for at the public expense, citing 1 Stat 273, which I personally find hilarious, right? I personally find hilarious because stat means statutes at large. The statutes at large is the compilation of every statute Congress has ever passed ever. That's the statutes at large. It's every law Congress has ever passed just in order, okay? That's what it is. 1 stat means I'm literally citing the very first volume that's ever happened. That's how far back we're going. 273 means it's page 273. So of all the laws Congress ever passed in the history of ever, the 273rd page of all the laws, Congress says, how about some protections for disabled veterans? So I'm like, kind of goes pretty far back. Congress kind of thought it was important. It's like literally one of the first things they ever mentioned. It's literally on page 273 of all the laws Congress ever passed in the history of ever. So kind of important, right? 50 SEK says, Ian Runkle says he doesn't have to like super chats. That's true. Do you also have to subscribe to the don't tell the internet what you don't like, I'll remind you mindset? I mean, I will definitely tell you what I like and don't like, so I'm not sure you have to remind me, but all the rest of it, right? Also, I think this is pretty good. And pretty solid for a lawyer who literally did not know USERRA existed before the client hired me. So I can do my homework, guys. I can do my diligence. It's like, I didn't know USERRA existed. Military veteran protection, what's that? Never heard of it. And it's like, well, I can do my research. I will find it. I will dig it out for you. I work hard for you. Anyways, with respect to employment and reemployment rates, the USERRA traces its origins to the Selective Training and Service Act, which has been eliminated, but I'm still going to, mention it just so Congress cares. The relevant law initially only applied to those drafted in full-time military service. Reemployment protections for all regular veterans, excluding at the time reservists and National Guard, regardless of whether the military service was via conscription or voluntary enlistment, was extended to the next year by a relevant law. So initially, only drafted. Then, okay, drafted or not, but only regular military. That was their next thought. All right, then Congress had some further thoughts on the issue. Much like the USERRA of later years, the relevant laws entitled the service member to reemployment by the employer or successor in interest or to a position of like seniority, status, and pay. So again, like this is not a new feature of law. The new aspect of law is it also protects the National Guard. But the protections go further back than that. So Congress initially is like only drafted. And then they're like, okay, drafted and people who enlist. And then at a later time, they're like, okay, drafted, people who enlist, and also the National Guard. So yeah, pressing on. This court has interpreted the protections afforded by the relevant law expansively on numerous occasions. So again, quote the Supreme Court when you can. When faced with the question as to whether service members were determined to seniority based on time that include the time spent on leave, this court in a case called Fishgold established that the service member does not step back on the seniority escalator at the point he stepped off. He steps back at the precise point he would have occupied if he kept the position continuously during the war. So again, like you have to pay them and give them seniority increases as though they were there the whole time. I'm sorry they weren't working for you for a year or 2 years or 3 years. I'm really sad for you. That's really sad. Do you regularly give people promotions like on fixed intervals? Do you regularly give people pay intervals at fixed intervals? Congratulations. You have to give this person pay and promotions as though they were there the entire time. But they weren't working for me for 3 years. Well, that sounds really sad for you. I'm sorry about that, but that's the law. Suck it up, buttercup. You know? All right, pressing on. The court noted these protections afforded service members must be liberally construed for the benefit of those who left the private life to serve their country in the hour of greatest need. And then, citing a different case from the U.S. Supreme Court, I have a little parenthetical quote, the law is always to be liberally construed to protect those who have been obliged to drop their own affairs to take up the burdens of the nation. Some nice, powerful quotes, yeah. Legislative measures gradually expanded employment protections beyond full-time military personnel, initially covering reserve forces in 1951, and subsequently extending those protections to guardsmen. So first they were like, how about only those drafted? And then they were like, okay, how about those drafted, but those who enlist in full-time service? Okay, how about those who enlist in part-time service? Okay, how about also people who sign up for the reserve forces? And how about those who are also National Guard? So Congress is just moving step by step. How about only those drafted? How about full-time regular? How about part-time regular? How about reserve forces? How about National Guard? Congress has step by step enacted laws to provide further and further and further protection. And that's where we sit today. Do I know if USERRA may or may not apply to bonuses if they're paid regularly? If they're paid regularly, I argue they would, because it's part of the normal compensation. So if bonuses are paid ordinarily, then yeah, they'd be entitled to any bonuses that they would have been paid had they been there, which might be interesting trying to calculate that. But yeah, I would argue in the first instance they would. That's the way I'd read it. In relevant part. So anyways, Congress has been extending these rights gradually, point by point. The Vietnam conflict provided the impetus for the next major revision of law. Congress extended and expanded the protections of the relevant law, and also via the Military Selective Service Act, and also via the Veterans Reemployment Rights Act, established under the Vietnam Era Veterans Readjustment Assistance Act. We've got lots of different laws. We got STSA, we got SEA, we've got the VEVRRRAA. I mean, we just got lots of fun laws. They're very exciting. In Monroe versus Standard Oil, this court noted that the legislative history indicates that the Vietnam law assures that those reservists will be entitled to the same treatment afforded by their coworkers without such military obligation, and the law does not now protect those reservists against discharge without cause as it does with inductees and licensees or enlistees. So, so the Supreme Court said, okay, it doesn't protect reservists. No problem. Congress has got your back. Right? The Supreme Court said it didn't protect reservists. No problem, we got your back. In 1994, Congress passes yet another exciting law, like their sixth or seventh version of this at this point. So they passed something called USERRA in order to clarify, simplify, and where necessary, strengthen the existing employment and reemployment provisions that previously existed under the VEVRRA and all the other laws I previously quoted. Congress has stressed that the body of case law developed under the VEVRRA remains in full force and effect to the extent it's consistent. So I want the benefit of all that case law because of course I do, right? I want all that case law because all that case law says veterans are great. Veterans are great, provide them all the protections. And the new law says, okay, we're also going to give it to the National Guard and the reservist people. And someone might say, well, that those old decisions only apply to, the full-time military. But Congress said it didn't. It said, okay, those old decisions are still good law to the extent they're consistent. So I can still quote them. So good for me. I would have quoted them anyway. I would have absolutely quoted them anyway. But anything that helps me, I'm going to quote. So Congress said, give it full faith and effort. You better believe your ass. And then I'm going to cite, whatever provision, helps me. So I'm going to cite legislative history. Is legislative history the greatest authority ever? Not really, but it helps me. So you better bet your ass I'm citing it. I'll take anything that helps. So the Congress at one point said the committee wished to stress the extensive body of case law that's evolved over that period to the extent it's consistent with the provisions of this act remains in full force and effect in interpreting these provisions. This is particularly true of basic principle established by the Supreme Court that the act is to be liberally construed, and then citing the Supreme Court. Congress has also affirmed the holding of this court from its decision in Fishgold, making it clear that Congress desired these anti-discrimination provisions be broadly enforced and strictly enforced. So Congress likes what the Supreme Court is doing. We like your Supreme Court work, Congress. Of course, Congress can change the statute. Congress has that power. Congress can overrule the Supreme Court when it comes to statute. That's one of the things they do. In fact, it's one of the things they did in this case, to be exactly honest, right? Because the Supreme Court said, well, that statute only protects, it doesn't protect the reservists. It doesn't protect the National Guard. And the Congress is like, no, that's some bullshit. Yes, it does. Here's a new exciting law. Fuck you. And that's one of the things Congress does with it at the time. So Congress can overrule the Supreme Court when it comes to statute, and that's exactly what they did. But they can also say we like Congress. They can also say we like the Supreme Court. And so all those old decisions, we're taking those along for the ride because we like them. We just want to extend them into a new domain. That's one of the things Congress does with its time when it's doing what it's supposed to do. As recited within the statute itself, again, quoting the statute itself better, legislative history is one thing, but let's talk about the statute. As recited within the statute itself, USERRA has three purposes: to encourage non-career service in the uniformed services by eliminating or minimizing disadvantage to civilian careers and employment which can result from such service, to minimize the disruption to the lives of persons performing service in the uniformed services, as well as to their employer, their fellow employees, and their community by providing for prompt reemployment of such persons upon their completion of such service, and to prohibit discrimination against persons because of their service in uniformed services. That's all good stuff. I'll take that. Thank you, Congress, for writing those things. Pursuant to USERRA, an employer is mandated to undertake reasonable efforts for a service member returning with disability incurred or aggravated in the line of duty. This obligation is activated when a service member's disability precludes the performance of fundamental duties of her position. Should the service member, even with accommodation, find herself unable to fulfill the essential functions of her role, the employer is then required to provide alternative employment commensurate with the service member's capabilities and conditions. So unlike the ADA, if you gave reasonable accommodation, whatever that means, and they're still not competent, the ADA, you can fire them, not so much under USERRA. And then I quote some relevant law. If the employee had a disability that was incurred in or aggravated during the period of service the USERRA requires, the employee be qualified for a reemployment position regardless of any disability. The employer must make reasonable efforts to help the employee become qualified to perform the duties of any position for which the employer is qualified or can become qualified, citing relevant provisions from the Code of Federal Regulations, administrative law. This framework ensures those who have sacrificed for their country are not disadvantaged upon the return to civilian employment, embodying a critical principle of equity and recognition of service. A particular critical import, the reasonable efforts required under USERRA are broader and more expansive than the reasonable accommodations required by the ADA. So I want to argue that reasonable efforts are different and also broader than reasonable accommodation. I mean, they are different words. They presumably mean something. So what's the distinction between reasonable effort and reasonable accommodation? What's the distinction? The distinction is anything that helps my client is the distinction, right? That's the distinction. Anything that helps me, that's the distinction. Because I'm a lawyer. So what does reasonable effort mean? Whatever I want to mean.
It means at least a reasonable accommodation, and anything else I want to mean, because I'm an advocate, and means anything I want to mean. Let's go. Guidance issued by the Department of Labor elucidates the determination of suitable accommodation is contingent upon the analysis of particularized factors. The reasonable efforts of USERRA require, and then it's not just me, thank God. So fortunately, I don't have to just make up shit, and I absolutely would, because sometimes lawyers have to make up shit. So if I had to, I'd just make up an answer and say it's the right answer because I say so. But, not necessarily ideal, but thank God I have something else to lean on. So I have some other stuff. The reasonable efforts of USERRA require placing the reemployed person in an alternative position or on light duty status, modifying technology or equipment used in the job position, revising work practices, or shifting job functions. And then I cite a whole bunch of law, right? And then, I cite some statutes, I cite some federal regulation, I cite some reports from the House, I cite some Senate reports, I cite a whole bunch of authority that says because I say so, also these people say so. This approach underscores a nuanced and individualized assessment, ensuring that accommodations are both appropriate and effective, tailored to specific need of returning service members and operational necessity of the employer. To prove an employee cannot be reemployed in the previous employment role, the employer must show the employee is unable to perform the essential parts of the position. The determination of whether a task is deemed essential hinges on its integral connection to actual performance exigencies of the position, transcending the sole confines of any written job delineation. Long story short, basically, it's not just what the employer writes. So what's essential is not what's in the job description. At least that's the way I'm going to interpret the law, because again, it's favorable to my client, right? So if you write it's essential, it doesn't make it essential. I can go past that. And also the fact that you didn't put it in there. So the fact that you didn't put it in there doesn't mean that it isn't essential. And the fact that you did put it in there doesn't mean it is essential. So essential doesn't mean what the employer says it means. It means what's inherent to the job. And what does that mean? Again, I'm the lawyer. It means whatever I want to mean. So that's what we're going to do. And then of course, there's a statute which lists a non-exclusive 7-part test for determining if a task is essential. So also I've got some rules that help me on that. However, in the event the veteran is not employable at the previous employment role, the employer has the additional and supplemental obligation to find a new role for the employee, as is the case in the present case. The employer is required to prove that they've engaged in reasonable efforts within the meaning of USERRA as separate and distinct from reasonable accommodation under the ADA. I mean, it is a separate statute. It's got to mean something, right? It's got to mean something separate and apart from it. Hopefully more. And that such efforts are futile before they'll be excused from reemployment. And then I cite some relevant authority. If the employee is not qualified to perform the duties of the position, the employer must make reasonable efforts to help the employee become qualified to perform the duties of the position, citing authority. If the employer is not qualified to perform the duties of the previous employment position, after reasonable efforts by the employer, the employee must be reemployed in a position of like seniority, status, and pay. The employer must make reasonable efforts to help the employee become qualified to perform the duties, citing relevant law. A claim that the veteran cannot be employed in any role is an affirmative one, and the employer carries a burden to prove by preponderance of the evidence that any one or more of these defenses is applicable, a burden that the respondents was relieved of due to the trial court's improper determination. So, right, I mean, they are only required to provide reasonable accommodation, but it is their affirmative defense, right? And because I wasn't even allowed to present the information to the jury at all, or technically I was, and then the trial court, kicked it out later, because they said that was something the jury wasn't supposed to consider, then Volvo didn't have the burden of proving its affirmative case. Could Volvo have won? Maybe they could have won, but I didn't have a fair chance, Your Honor. I didn't have a fair chance. I should have been allowed to present that information to the jury and let the jury decide, because juries are smart, don't you know? The trial court erred in ignoring Department of Labor regulations when the court determined that USERRA is not a disability statute. And then I cite some relevant law. However, how or when the employer initially finds out about the disability is wholly irrelevant. As long as the disability is linked to military service, the employer must rehire the veteran in a suitable role. If the disability is discovered after the service member resumes work and interferes with his or her job performance, then the reinstatement process should be restarted on USERRA. So, when you discover the disability is not the thing, right? Maybe the disability only becomes apparent after they restart work. Who knows? Who can say? So they restart work and the disability manifests itself. It's like, well, then you have to go to the other provision of statute. At least that's what I think, right? So that's why I'm going to argue, and I have some authority for that proposition. I cite federal law. This duty involves making reasonable attempts to help the veteran get qualified for a job, either in their previous position or in a different role that suits their abilities for service. This responsibility highlights the employer's role in aiding the veteran's return to work, regardless of when the disability manifests. So I think, that's a pretty reasonable summary of the facts of the case. All right, the proceedings below. So now, having sort of discussed what the case involves, trying to present it in the best possible light, trying to present it in the most favorable light that can humanly be written, having tried to present the fact pattern as best as I can, now I have to describe what happened in the case below. Again, as favorably to my side as I can. Petitioner is a disabled veteran of the United States Army Reserve who was deployed on 3 separate occasions. Petitioner's employment by respondent was interrupted on 3 occasions pursuant to military service. The first such occasion occurred from April 2006 to May 2007. Petitioner was called in active duty in support of Operation Iraqi Freedom, sent to Baghdad, Iraq, and was put on military leave from her employment at respondent's Joliet plant. By the way, if you don't think I'm mentioning this in detail about exactly what her service was and trying to make her service look as good as it can, you're out of your mind, right? I'm absolutely trying to make this person look like a big goddamn hero. I want them to look I'm going to absolutely mention their service. I'm going to mention everything about it. I'm going to make this person look like a goddamn hero. Am I going to fly the flag as I'm, making this petition? You better bet your ass. I am flying the American flag. I'm getting myself a bald eagle. I'm gonna scream YOLO freedom, basically every possible way. So I'm mentioning what it is in detail because I want them to think about it, right? You better bet your ass. She served our country for a year. She went to Baghdad. She's awesome. The second such occasion occurred from March 2008 to October 2008, when petitioner was again called to active duty for training in service of country. Training counts, by the way, for the purposes of the law. Training absolutely counts. The third such occasion occurred from April 2009 to August 2010, when again, petitioner was again activated for Operation Iraqi Freedom for the second time. She's been to Baghdad, Your Honor. She kicks ass. After petitioner's second combat tour, petitioner experienced symptoms of PTSD that were caused by her military service. Pursuant to party stipulation, it was acknowledged that petitioner received treatment for PTSD subsequent to her return from active combat duty, with initial treatment commencing not later than December 2010. Furthermore, a formal diagnosis of PTSD was rendered in January of 2011, at which time respondent was notified of such disability, that's Volvo in this case, failed to make the required accommodation under USERRA, and instead flagrantly violated the law by shortly thereafter terminating petitioner. So Volvo knew. They knew when they fired her anyway. The parties further stipulated that petitioner's PTSD was due to and caused by military service. I'm going to mention that many times because you better bet your ass. Petitioner was terminated from Volvo on November the 8th of 2011 after return from a third tour of duty. Petitioner brought suit under USERRA. She sure as fuck did. The trial court initially granted summary judgment in favor of respondent on all counts. Petitioner timely appealed summary judgment issued to the Court of Appeals for the Seventh Circuit. The Seventh Circuit reversed in part, finding sufficient evidence as a matter of law to allow claims under ADA and USERRA to proceed. According to the Court of Appeals for the Seventh Circuit, the evidence offered at trial, again, gotta quote the court, man. It's not me who says it, Your Honor. It's the nice Court of Appeals who says it. They're the learned ones, Your Honor. They're the smart ones. They're great. According to the Court of Appeals for the Seventh Circuit, the evidence offered at trial reflected evidence that allowed a reasonable jury to infer respondent was motivated, at least in part, by anti-military animus. They're bad people at Volvo. They suck. In reaching that conclusion, the Seventh Circuit noted that petitioner presented evidence indicating her supervisors disliked the burden her frequent military leave placed on the company from the beginning of their employment, again, citing the court. For example, the trial court noted that petitioner presented emails indicating petitioner's supervisors were unhappy with petitioner taking off time to travel to and from her military service to Fort Benning, Georgia, and citing further authority from the court, right? Because appendix would be my appendix where I'm citing the court. The Seventh Circuit in its first decision also noted that the evidence supported petitioner's claim of service-related disability and requests for reasonable efforts to accommodate. So there's sufficient evidence that she notified the employer, they were aware of it, she requested accommodation, so forth and so on. The petitioner prevailed at the first jury trial of claims under the ADA and USERRA, with the jury awarding $2.6 million in compensation and $5.2 million in punitive damages for ADA. So the client got the jury to say, how about $7.8 million? That's nice. Unfortunately, it didn't stop there. The trial court reduced the jury's award of compensation to $300,000 and then zero. So instead of $7.8 million, how about $300,000? So, not as great on the basis of some statutory caps. And the court itself awarding damages in lieu of submitting to the jury for USERRA. So they reduced caps based on law, but that law only relates to the ADA and not USERRA. And so, I don't think that was necessarily a proper reduction. But that's what happened. Upon reconsideration, the trial court inexplicably entered a judgment of determination of the jury for respondent as a matter of law as to the ADA and granted a new trial on the sole issue of USERRA. In doing so, the trial court violated the law of the case as informed by the Court of Appeals reinstating USERRA ADA. So yeah, the ADA said, the Court of Appeals said there seemed to be enough evidence. Now the trial court's like, no, there's not. So I'm going to argue they violated the law of the case. Try to make them look as bad as possible. Yeah. As part of the second trial on the USERRA claim, petitioner again attempted to present evidence relating to both animus on the basis of military status and failure to accommodate military disability. However, the trial court excluded all evidence relating to military disability and respondent's failure to make efforts to accommodate her for her disability in contravention of law, which makes it really, really hard for her to win, right? It's like, okay, so we're just going forward on USERRA. I'd like to argue about my military disability. You can't present any evidence of military disability. Well, that's going to make it really hard for me to win a USERRA claim now, isn't it? €5 from Kajet the Frankenfurter. Started improv because of you and I love it. Thank you. I'm glad you enjoy it. So then I cite the relevant law again relating to disability. So we've read that before. After her third deployment, petitioner returned to work on September 27, 2010. At the time of her return to service, both respondent and petitioners agree that she had PTSD caused by military service. Again, I'm going to mention it again because they concede to the point. Petitioner filed suit in August 2012 with the operative third amended complaint being filed July 2013. Among other causes of action, petitioner filed to seek redress for violations guaranteed to petitioner under USERRA. Count 1 sought relief pursuant to the entirety of USERRA, including the relevant law. So she said, I want to sue under USERRA, right? And therefore, all of it. That was count 1. Okay. The trial granted summary judgment as to all counts. Petitioner timely appealed. The Court of Appeals issued a reversal in part. The Court of Appeals noted that the treatment for symptoms of PTSD upon return from her second combat deployment. The appeal court noted that the client presented evidence that Volvo's failure to make reasonable efforts by the employee, the relevant statute, and unwillingness to find petitioner any other petition which is equivalent in seniority, status, and pay, the duties of which the person is required to perform or would be qualified to perform with reasonable effort, citing the relevant law. In particular, the appeal court noted that respondent wrote that now this is again, again, if I can quote the opposing side or quote the court, every day, all day. So in particular, the appeal court noted that Volvo wrote, so Volvo said these things. Volvo says it. Volvo said that the client is really becoming a pain with all this and wrote that there were several rumors of them not being there, including she's on vacation to Hawaii when she in fact was suffering from military disability. So again, try to make Volvo look as bad as they can. I'm going to cite everything they said to make them look like the biggest monsters ever. The appeal court therefore reinstated the claims under both ADA, and USERRA. A jury found petitioner A jury found for a petitioner on both remaining counts with jury awarding damages as to the ADA and the judge issuing damages as to USERRA. For some reason, the judge issued damages as to USERRA. Unclear why, right? Why did the judge do that as opposed to letting it go to the jury? It's just a claim like any other claim. Why wouldn't the jury decide it? I don't know, but that's what happened. Judgments as to these amounts was issued in July of 2017. However, more than 2 years later, in September 2019, the trial court withdrew its prior judgment and instead issued a judgment on a matter of law on ADA and granting a new trial. I mean, that's really frustrating as shit, right? I mean, in 2017, the trial court said you win. And then 2 years later, the trial court said, not so much. Not so much with you win. How about not so much? That's really frustrating, man. You got to be pissed about that. So anyways, we move on to the second exciting trial. As part of the second exciting trial, Volvo sought to preclude at the upcoming trial any reference or testimony or other evidence concerning the PTSD diagnosis on the basis that it was not relevant. The trial court inexplicably limited the issues to be presented at trial to a single claim, that the claim that Volvo violated USERRA when it terminated her employment. However, the complaint was not so limited, and doing so, the court effectively summarily dismissed claims without any specific order as they sought relief under the entirety of USERRA, including failure to make reasonable efforts to accommodate the surface. So the trial court inexplicably limited this to the moment of firing. And I'm like, no, I don't want to limit it to the moment of firing, Your Honor. I'd like to talk about everything they did because it makes them look like jackasses. I like to talk about, it's not just the moment of firing. That's not the critical moment. It's certainly a critical moment, Your Honor. But I want to talk about everything else that happened because I can make them look like assholes. But you won't let me talk about everything else that happened, so I can't make them look like assholes. That's not nice. The trial court wrote that any discrimination she might have been able to prove on the basis of PTSD as opposed to military service, which, by the way, those aren't distinct, right? Why would... it's like it was a disability that was incurred from military service. Here's what happened. The trial court limited her to 4311. And the trial court said that 4311 only extends to your status as a military member as such. That's why the court made that determination. Okay, so they said, okay, you can only file suit under 4311, not 4313. So all this statute that I've been citing with 4313 relating to disability, the trial court said that she couldn't even argue it. They couldn't even argue 4313. All they could argue was 4311. 4311 only extends to military status as such and nothing more. So the trial court would be right that she can't argue about PTSD if she was limited to 4311. Because under 4311, the claim is you fired or discriminated against me because I'm a military member. The fact that I have PTSD is irrelevant to 4311. The court's not wrong as to that. They're wrong for limiting me to 4311. Because it's like I had a pretty good claim under 4313. I really would have liked to argue, and I think I should have been able to. So anyway, the trial court wrote that any discrimination she might be able to prove on the basis of PTSD, as opposed to her military service as such, is compensatable only under disability law, and no such claim remains in this case. I'm like, I don't think so. But the issue isn't abstract discrimination, but rather the specific failure responded to make reasonable efforts to make an employee who's not qualified due to such disability to be employed in the position of employment for which they would have been employed, to transfer the employee to any other position and blah, blah, blah under 4313. In other words, the issue is not just 4311. The issue isn't just they fired her because she's a member of the military. The issue is, at least in my humble opinion, they did not provide her sufficient accommodation, and I can argue that 4313 case too. My trial counsel should have been allowed to argue 4313. You were wrong for limiting me to 4311. That is the basis of the lawsuit. The trial court therefore erred in limiting the issue to discrimination under 4311 without also allowing petitioner to present evidence of lack of respondent's reasonable efforts to place her within a position of employment she could have performed with military incurred disability. The trial court determination granting the response motion in limine 3 and 4, excluding the presentation of evidence relating to disability, was therefore legal error, which artificially limited petitioner beyond the scope of her own well-played complaint. So there was a motion in limine, which of course there was. Volvo said not so much on the PTSD. Volvo won the PTSD, so she wasn't allowed to present it at trial. and artificially limited her because her claim was under the entirety of USERRA, not just 4311. So the trial court made an error in excluding the evidence and limiting her cause of action. That's the argument by me. Petitioner's third amended complaint alleged that she was disabled and that she was diagnosed with PTSD and substantially limited in a major life activity of brain function. While petitioner argued as part of her complaint that she's qualified, respondent, that is Volvo, has vigorously disagreed. Respondent thus put her disqualification into direct issue, and respondent was entitled to argue that they failed to provide reasonable efforts to make her qualified. So Volvo's argument is that she's not qualified. Well, if that's true, I should be allowed to argue that she is, or could be made to be qualified, and they won't let me. They won't let me, so that's not fair. Petitioner, respondent, the client, repeatedly and strenuously argued that Volvo's violation of USERRA are not limited to discrimination, but extend to many additional aspects of the statute. So she is preserving the issue. That's why I'm trying to argue she preserved the issue. A trial court characterized petitioner's efforts to take full advantage of her own complaint as an attempt to add USERRA claims at the late stage, but this fails to allow petitioner to be master of her own complaint and take full advantage of the entire scope of her claims, as in the complaint, the allegations were made under the entire of USERRA, not one specific part of it. So they're like, you're trying to add to the complaint. I'm like, no, she's not. She's not trying to add to it. Trial court's determination granting motion in limine 5 excluding reemployment claim was therefore additional legal error which artificially limited petitioner beyond the scope of her complaint. In the second appeal, the Court of Appeals compounded the error by writing. The only alleged error she raises on appeal was the district court's decision to exclude evidence of her PTS diagnosis and treatment. Only the USERRA claim remained in the second trial, and USERRA prohibits discrimination on the basis of military status alone rather than conditions stemming therefrom, see 4311. Thus, the district court did not abuse discretion in excluding evidence as irrelevant. So the Court of Appeals somehow concludes her claim was only under 4311. And therefore, the district court did not abuse its discretion, which would be true if that was the petitioner's claim, but I don't think it was, right? So if the claim was only under 4311, then the trial court would have been right, and the Court of Appeals would have been right, because it would be her military status as such. So her PTSD would be irrelevant to a 4311 claim, but her complaint was not so limited. And so the trial court artificially constrained it. The Court of Appeals artificially constrained it. And so, what do you do? Well, let's appeal some more. Petitioner's complaint was on the entirety of USERRA, and the artificial construction of the complaint solely to 4311 belies respondent's own argument that petitioner was not qualified, which subsequently necessarily triggered Act 4313. So, yeah, her qualification or not would not be relevant to a 4311 claim, right? Because 4311 has nothing to do with her being qualified or not. 4311 only has to do with whether she's a military member or not. So her qualification is irrelevant, right? Whether she's qualified or not is irrelevant. 4311 only protects her for military status. But respondent starts talking about whether she's qualified or not, which then, we have an opportunity to rebut that because they're bringing in qualification. We have an opportunity to rebut that too. That's what I think. So therefore, petitioner was entitled to present evidence of PTSD as well as respondent's failure to make reasonable efforts, as without the evidence of disability, it was wholly impossible for the jury to conclude the reasonable efforts were not made, and thus provide respondent with an undeserved benefit of a much lower burden of proof. The decision of the Court of Appeals must be reversed. I'd like to think my own writing's pretty decent. I'd like to think it's Supreme Court worthy. I'm not arguing it's the best writing of all time. I'm not arguing it's the greatest petition that's ever been written. I'm not arguing that, songs will be sung from heaven itself. But, and I know I'm biased because I wrote it. I know I'm biased, but I think it's really good. I think it's really good. I think it's a very solid, well-written petition that's making a very solid, very credible argument. I think I did good work. Let me know if you agree or not. Let's carry on with more. Reasons for granting the petition. All right, this is the hard part. This is the hard part of the petition, right? This is, okay, why should the Supreme Court take this case? This is the tricky part. Because the Supreme Court only takes 0.7% of cases. Okay, so how am I going to basically bullshit the Supreme Court? How do I bullshit the Supreme Court into saying that this is one of the cases they should take? How do I bullshit them? All right, so now's the portion where now's the hard part of it. Is there an order of the petition? Yeah, certain elements are to be presented in certain order. But yeah, I mean, certain things are, yes, there is a flow to the petition in which elements come which, or at least traditionally there is. I mean, there's probably no hard and fast rule. You probably could do it a different way, but I'm going to present it in the way the Supreme Court is used to seeing it. So, because, you know, I don't want to rock the boat. So yeah, I'm going to present it the way the Supreme Court's used to seeing. Could I have put it in a different order? Probably, but let's just do it the way the Supreme Court's used to seeing it in the normal order they're used to seeing it, and, you know, we'll live. All right, so Supreme Court, why should you take this case? The Seventh Circuit decision here departs from the statutory text of USERRA and the precedent of this court. I mean, not a bad way to start, right? It's like they're defying the statute and they're defying you. They're defying you. Only this court can resolve the conflict and validate military veterans in employment. Let's do it for the troops, man. Subsection A. The stipulated facts of this case make it a good vehicle for deciding the issue of reemployment protections for wounded and disabled veterans. Due to stipulated facts in this case, there are no complex factual issues that would exist in other cases. In USERRA, Congress provided more than 19 million military service members with a legal remedy for adverse employment actions taken as a result of military service. USERRA was enacted under Congress's constitutional war power authority, as outlined by the Constitution itself. Yeah. This legislation acknowledges that unaddressed employment maltreatment against military personnel could impede the nation's capacity to maintain a robust national defense. Yeah. The issue at hand bears significant relevance to millions of current and future military veterans. Regrettably, many veterans encounter considerable challenges upon their discharge from active service. These challenges often include severe physical and mental impairments, such as traumatic brain injury, PTSD, and depression, all of which can hinder their smooth transition back into civilian employment. Unemployment rates for disabled veterans are twice as high as those who are not disabled, which validates the need for strong enforcement of protections granted by Congress. An employment who has faced maltreatment in violation of USERRA can take legal action against their employer for compensation and equitable relief. Unlike several other federal labor laws, USERRA applies to companies both in private and public sectors, irrespective of the scale, including federal, state, and local government entities. USERRA applies to everyone, you know, deal with it, bitch. And incidentally, by the way, that's worthy of noting because not every federal statute applies to every federal employer. Like, and I couldn't quote you chapter and verse on this, but, and there's different thresholds for different things, by the way. Like the minimum wage only applies to employers of a certain size. I think the ADA only applies to employers of a certain size. But, you know, USERRA applies to everybody. USERRA applies to all the people. Public, state, one employee, 1,000, doesn't matter. So you might not have protection under ADA, but you've got protection under USERRA. Yeah. Congress established the Veterans Benefits System to provide for compensation to veterans for sacrifices they made in service of the nation. Yeah, this is definitely the flag-waving portion of the exercise. You know, hopefully not too overtly, but definitely a little flag-waving. If you think it's a little too flag-wavy, I accept your criticism, but, you know, I needed as much as I could. So we're definitely entering the flag-waving portion of the brief. The system is designed to function throughout with a high degree of solicitude for a claimant, citing the U.S. Supreme Court. The solicitude of Congress for veterans is long outstanding. The United States has historically acknowledged its special duty to protect and honor those who set aside their personal affairs to shoulder the burdens of national defense through military service, citing the U.S. Supreme Court. Always a good place to cite. Congress has consistently broadened protections for veterans re-entering the workforce. These protections were enacted to mitigate the career disruptions and financial setbacks that military services often employ, citing the congressional record, citing some random senator who said some things. Congress extended reemployment rights to our reservists and National Guard members, characterizing them as essential to our national defense, citing the U.S. Supreme Court, which itself cited, cited the U.S. congressional record. Additionally, Congress enhanced substantive protections to prohibit employment discrimination based on military service, addressing an issue that by the 1960s had become an increasing problem. Always going back to the Vietnam War, baby. Courts must interpret statutes according to their plain text. citing some U.S. Supreme Court case, which I could have probably cited lots of cases for that proposition, but that's the one I picked. In cases concerning statutes relating to veteran protections, this court consistently resolves any interpretive ambiguity in language of the statute in favor of a veteran, adhering to a pro-veteran canon. And then I cite some cases that I think, basically stand for that proposition. In cases concerning critical federal statutes, the existence of a circuit split is not prerequisite for this court's immediate prompt intervention. Yeah, that was not one of the factors that was helping me. There wasn't really a great circuit split. There's not actually a lot of case law on this point, to be quite honest. So there wasn't a lot of case law, and I couldn't really find a circuit split. There was some case law that I could have tried to manufacture a circuit split out of, but I didn't really have that indicia, but I'll do what I can. So basically, there might not be a circuit split, but it's still really important anyway. I know the Supreme Court does. And then also the reason I'm talking about the veterans, how they're disabled and everything, and how there are so many veterans, because the Supreme Court doesn't fix one guy's problem. So they're not going to fix my client's problem, but do it for America. Do it for the 19 million other veterans out there. This isn't about my client. This is about America. Eagle screeching in the distance. It suffices that the statute represents a federal policy of such significance that has been enacted into law by mutual agreement of two co-equal branches of federal government. The Seventh Circuit not only completely ignored this court's precedent under Fishgold and other cases, in that protection afforded service members must be liberally construed, but the court additionally failed to give effect to the plain language of section 4313A3. The statute requires a disabled veteran shall promptly be reemployed in a position of employment, in any position which is equivalent in seniority, status, and pay, the duties of which the person is qualified to perform or would be qualified to perform with reasonable efforts by the employer. There is no discretion. The word shall is a language of command. The lower court's decision to reject USERRA's protections for gainful employment for disabled veterans has a significant impact because USERRA represents a careful and specific use of Congress's power under war power to allow legal actions against private employers. Insert screeching eagle noises. All right, subsection B. The manifest intent of Congress was usurped by the courts below to the severe detriment of veterans. Congress enacted USERRA to minimize the disruption to the lives of persons performing service in uniformed services as well as to their employers, fellow employees, and their communities by providing for prompt reemployment of such persons upon completion of such service. The USERRA supersedes any state law, including local law or ordinance, contract, agreement, policy, plan, practice, or any other matter that reduces, limits, or eliminates in any manner any right or benefit provided by this chapter, including establishment of additional prerequisites to the exercise of such right or receipt of benefits, citing 4302. Yeah. So Congress was clear. They are usurping all the things, and they are not shy about it. 4302, we're usurping everything. We're usurping everything. We're usurping local law. We're usurping state law. We're usurping contract. You have a contract. You have a union agreement. You have a plan, a policy, a practice. You have something. Go suck our collective dick, says Congress. Go suck it. Go suck it. Our law beats you. Our law beats all the things. America, USA, 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 USA. USERRA trumps everything, baby. Get off my lawn. The Supreme Court's interpretation of USERRA highlights that it offers significant greater protections compared to other workplace anti-discrimination statutes. In Fishgold, the court emphasized that USERRA was to be given as liberal a construction for the benefit of this veteran as the statute can permit. Always cite the U.S. Supreme Court when you can, man. And then we cite a case, which cites a case, and we cite some other cases from the 11th Circuit. That's nice. The court noted that USERRA was deliberately and purposely directed to providing an advantage, which the law withheld from those who stayed behind, citing some more law. This court also emphasized that all interpretive doubt is to be resolved in the veteran's favor, citing more U.S. Supreme Court, citing some Fourth Circuit law. Because USERRA was enacted to protect the rights of veterans and members of uniformed services, it must be broadly construed in favor of military benefits. Citing a Seventh Circuit case, like the VRRA, the USERRA is to be liberally construed in favor of those who serve their country. It's interesting because sometimes people say USERRA and sometimes they say the USERRA. So, inconsistent there. So pick your poison, which you like better. Do you like USERRA or do you like the USERRA? citing the Federal Register, citing some other things in the Federal Register, which say USERRA establishes a floor, not a ceiling, for employment and reemployment benefits of those it protects, citing more federal statutes and regulation. The Department of Labor intends this interpretive maxim that USERRA is to be liberally construed, applied with full force and effect in construing USERRA and these regulations. The protections afforded under USERRA are significantly broader than those afforded under the ADA. For example, ADA does not oblige employers to establish an employment role specifically for an employee with a disability. Yeah, USERRA requires you to do that. You might have to create a position you might have to create one. ADA doesn't require that. You might actually have to create a position for this person. That might have to be a reasonable accommodation. So USERRA goes pretty far, man. We don't have a job, maybe create one. Yeah, USERRA goes pretty far, or at least it can go pretty far. So I cite a Seventh Circuit case, and then I cite a Fifth Circuit case, nor does it provide an excuse that another person's been hired to fill the position vacated by the veteran, or that no opening positions. You hired someone else in the interim, they were gone for 3 years. And so you filled the position, that position's filled. Fuck you, man. Fuck you, I don't know. Fire the guy, I don't know. You gotta hire this guy back, I don't know. Create a new position, fire the guy you hired for 3 years, I don't know. Fuck you. Gotta hire him back, baby. You filled the job, unfill it. Figure it out. Yeah. And then I cite a case from the Eastern District of North Carolina. I cite a case from the Eastern District of Michigan. I cite a case from the Northern District of California. I cite a case from the Eighth Circuit. I will cite anything. I'm a lawyer, man. I'm a lawyer. I am representing you. I will cite anything and everything that is tangentially related to this. I'm going to make your case look as good as possible. I have some cases that vaguely allude to what I'm saying. The reason you know they vaguely allude to it is because I don't provide you any further information. I just provide some string cites. But God damn it, they're vaguely related to my point. I'm going to cite all the authority forever. Cite all the things. Cite all the things till you die. Which is a protection afforded to veterans under USERRA unavailable under the ADA. Congress intended USERRA to require an employer to make reasonable efforts to qualify or requalify a protected returning individual for the appropriate position. And then I cite a House report which cites a different thing, noting that the summary of major provisions of USERRA as reported from the House Committee on Veterans Affairs. The obligation to requalify includes granting the veteran full company seniority for all purposes, is always to be accorded to the disabled service person, regardless of whether seniority follows an employee under other circumstances. And then I cite a House report, citing a different report, and then I cite a Fifth Circuit case, and some case from the Eastern District of Pennsylvania, some other Third Circuit case, anything vaguely on point, I'm going to cite it. The obligation also requires a particular accommodation of the veteran, notwithstanding any employer practices, policies, agreements, and plan, citing the statute. So long as the agent intends for discrimination reasons that the adverse action occur, he has the scienter required for liability, citing the U.S. Supreme Court. The purpose of the act expressed by Congress allowed the veteran to bring a complaint at any time for failure to accommodate disability incurred or aggravated by military service, including mental conditions such as PTSD. Not bad, not bad. I like my own writing. I like my own writing. This isn't too bad. I think this is pretty good. All right, part C. The scope of USERRA is greater than that of the ADA, is informed by Department of Labor rules. Again, reminder at the time, Chevron still exists. So Chevron, of course, is great and wonderful in every way. So we're going to use it to our maximum benefit, which demands evaluation of the failure to accommodate the claim within the meaning of USERRA. The rules relating to USERRA make clear the concept of effort differs from the difference of accommodation in ADA and are more significant. When it comes to interpreting efforts of USERRA, employers are required to make significantly more effort under USERRA as compared to the ADA. For example, under USERRA, employers must modify technology or equipment used in the workplace, change work procedures, or adopt an employee's job duties, which is a burden not present under the ADA, citing some federal authority, citing some House reports, citing a Senate report. When applying this burden shifting analysis, courts interpret USERRA liberally in favor of service members, citing some Seventh Circuit case. USERRA, as detailed in the relevant law, unequivocally mandates that if a veteran remains qualified for their previously held position, they must be re-employed in that position or in a position of like seniority, status, and pay. This provision underscores a firm commitment to restoring veterans to their rightful employment status upon returning from service. This court must reaffirm Congress's intent. USERRA provides a more robust protection than ADA by requiring employers to take proactive steps to ensure their veterans are re-employed in positions of equal seniority, status, and pay to those previously held. According to a relevant law, if the veteran is not initially qualified for their prior position, the employer must make reasonable efforts to help the veteran become qualified. These efforts must be comprehensive and provided at no cost to the veteran, as stipulated in a different portion of the law. This obligation to incur costs and provide extensive report is a distinctive feature of USERRA, surpassing accommodations typically required under ADA. Yep, they have to do more than the ADA does. The clear language of the statute, again, man, I'm just going to cite this. I'm going to just say it's clear in the statute. The statute is clear, baby. They're defying Congress. They're defying you. The clear language of the statute and accompanying regulations contemplate a commitment that extends beyond a singular moment of reemployment. Training to make an employee qualified cannot be completed in an instant, and finding an appropriate fit for an employee may not be immediately obvious, particularly as the disability itself changes. Respondent argued and the court agreed that petitioner was not qualified for a position upon return. Assuming arguendo this was the case, again, I'm not going to concede any more than I have to. I'm not going to say she's disabled, but I'll assume it for the sake of argument. The petitioner is entitled to demonstrate at trial that it was her military incurred disability that led to disqualification, present evidence relating to her disability, and present evidence regarding respondent's lack of attempts to make reasonable efforts to make her qualified either her previously held position or any other position within VAVO's employment. The Department of Labor has specified in final rule, making a broad understanding of USERRA above and beyond the protections provided for by the ADA and other federal law as that is disregarded in position below. And then I have a nice little quote. In comparison to the ADA and Title VII of the Civil Rights Act, USERRA's definition of employer is different and quite broader. So yeah, it's different. Further, the ADA only covers disabilities as defined in that statute, whereas USERRA covers any disability incurred in or aggravated during service in uniformed services. Unlike the ADA, which does not require an employer to displace a temporary worker to accommodate a disabled worker, create jobs, or keep a disabled on unpaid leave. So like, see, I'm citing some cases, right? So I'm saying I'm distinguishing from the ADA, right? So the ADA does not require an employer to displace. I cite a case. It does not require them to cite a job. I cite a case. It does not require to keep a disability on unpaid leave indefinitely. I cite a case. So I'm distinguishing between the ADA. So the ADA does not require these things, but USERRA may require such actions on behalf of the employer. And then I cite, basically a law review article, which provides the history of USERRA and the purpose behind legislation. So USERRA may require all these things unlike the ADA. So USERRA goes further. The entitlement of the military member to present proof of her disability, along with her employer's neglect to make reasonable efforts for accommodation, remains valid irrespective of whether the employer knew about the disability at the precise instance she returned to work. They don't necessarily have to know about it then, if it becomes later. And then I cite a provision for that. If the disability is discovered after the service member resumes work and interferes with his or her job performance, the reinstatement process should be restarted under USERRA's disability provisions, and I cite a federal regulation, which is administrative law, which I will take because Chevron still exists and Chevron is great. So of course that's what they're supposed to do. This rule is applicable as long as the disability stems from military service. The rule guarantees that veterans are not disadvantaged due to their employer's initial ignorance, reinforcing the employer's continuous responsibility to assist veterans in adapting and succeeding to the work environment. Part D. Now I'm going to try to sell you on the fact that part D is the part where I'm going to hammer that this is more about more than just about my client. Part D is where I'm going to try to make you care because part D, we're going back to flag waving for a while. So a little bit more flag waving. PTSD as a disability impacts millions of veterans who are entitled to reemployment based on PTSD. This impacts us all. It impacts us all. It's not just about my client, Your Honor. It's about millions of veterans. PTSD is recognized as a condition that can persist and have an impact showing symptoms like reliving experiences, avoiding triggers, changing in thinking and mood, and heightened arousal levels. And then I cite some, medical research article that, blah, blah, blah. The Diagnostic and Statistical Manual of Mental Disorders, the DSM-5, related to PTSD includes 20 specific symptoms categorized in 4 main groups: intrusive thoughts, efforts to avoid reminders, negative changes in thoughts and emotions, and notable changes in alertness and responsiveness. Specifically, it can manifest in reliving the event, feeling numb, hyperarousal, and persistent avoidance of stimuli. And then I cite, what is PTSD, by the National Center for PTSD, from the Veterans Affairs, because, why not? The development of PTSD can last for an extended period of time, even a lifetime. And then I cite, some article about factors associated with persistent post-traumatic stress disorder among U.S. military service members and veterans from some psychiatry report. PTSD often manifests as depression and anxiety. Persistent PTSD is associated with increased disability, lower productivity, and decreased well-being, all of which impact a person's ability to perform effectively in specific work settings. PTSD is highly prevalent throughout American society, including Veteran Affairs medical centers. Epidemiological estimates of PTSD put lifetime prevalence at 8 to 14% in the general population, with higher rates of both current, up to 15%, and lifetime, up to 31% prevalence for veterans exposed to war trauma. Then I cite some article for that proposition. For veterans like petitioners who has served as part of Operation Iraqi Freedom and Operation Enduring Freedom, 29% of veterans have PTSD at some point in their life, according to the Department of Veterans Affairs. So with respect to this deployment in particular, up to 29% have PTSD, according to Veterans Affairs. However, this average number misrepresents the risk factors for those who have been deployed like petitioner, where the risk factor is 3 times greater. This problem remains with ongoing post-Iraq, with 90% of women veterans who served in 2021 alone diagnosed with PTSD. So if you've actually been deployed, the risk is actually 3 times greater than that and impacts at least 19% of women veterans. Ongoing treatment for PTSD is often difficult, as wait times make seeing care ineffective. For instance, at the Veterans Affairs facility located in Fayetteville, North Carolina, the waiting period for a new patient to obtain mental health services in general, as recorded in August 2023, extends to 106 days. And for PTSD specific care, no services were available locally, requiring veterans to visit a different county, which had no new employment slots. So Veteran Affairs may not necessarily be doing great in taking care of people's conditions. 499 from Fachi says, I noticed you had almost 4K live viewers. Any tips for YouTubers turned drug addicts who cannot get similar numbers? Asking for not a friend. I don't really know that I have any specific advice. I don't know why this stream got so many people. I don't know the answer to that question. I wouldn't have anticipated that it got 4,000 viewers, and why 2,100 people are still watching. I don't know the answer to that question. I don't know the answer to the question. I don't know. If I knew what the magic was, I would just do the magic all the time. I don't know. I wish I did. I don't have any magic tips. I suppose my only tip is cover what you love, because then it will be effective. Try to cover what you care about, and then your passion will come through. Is really all I have to offer. But yeah. It's because people are looking for read content, apparently, man. Damn, who knew? But you're not getting read content right now. Right now, you're getting U.S. Supreme Court briefs written by yours truly on a petition for a writ of cert relating to PTSD and military. You're getting that right now. Anyway, so Veterans Affairs may not necessarily be doing the greatest job in taking care of veterans on PTSD. Experience has shown that the U.S. Department of Veterans Affairs has implemented a web of refusing to refer veterans to community care, poor community care conditions, wait time manipulation, and administrative hurdles that keep veterans out of community care and in the VA system. And then I cite, the article I cited earlier from Veterans Affairs, I think. This assumes veterans even attempt to seek immediate treatment. Research has demonstrated that in addition to practical barriers, stigma, negative attitudes related to mental health, and poor recognition of the need for treatment further exacerbate PTS-related care. Citing an article, Stigma as a Barrier to Seeking Healthcare Among Military Personnel with Mental Health Problems from Johns Hopkins. With respect to stigma in particular, stigmatizing belief are reported at consistently greater levels than practical or logistical barriers to care, irrespective of whether personnel are full-time regular military, reserves, or veterans or former military, citing that same exact article. So some people don't even seek care. PTSD is also not a static disability in the same sense a physical disability may be. Meta-analysis has estimated that delayed onset PTSD manifests in approximately 25% of PTSD cases. So unlike a physical injury, which you're probably going to notice kind of right away, PTSD doesn't necessarily do that. PTSD can be a weird thing. So apparently in 25% of cases, PTSD may show up at a later time. It may not show up immediately. So that's super exciting for that mental disease. So then I cite an article relating to that, Delayed Onset Post-Traumatic Stress Disorder, a systematic review of the evidence. The intensity of PTSD symptoms may fluctuate over time. Individuals also often experience an exacerbation of PTSD symptoms during periods of general stress or when encountering triggers associated with a traumatic experience. Post-traumatic stress disorder symptoms and causes by Mayo Clinic. The flux in PTSD experience is particularly acute in early stages of illness, leading to greater uncertainty in the initial period in which PTSD is first expressed. And then I cite a systematic review of PTSD prevalence and trajectories in DSM-5 defined trauma, exposed populations, intentional and non-intentional traumatic events. The combined practical and societal barriers to treatment coupled with dynamic nature of PTSD as a military-incurred disability makes full presentation of PTSD-related disability at a time of reemployment a pragmatic change at best and a practical impossibility at worst. So I tried to sell the Supreme Court on why this case would be one of the few cases they would take. I tried my best to sell them. I tried my best. It didn't really have any of the typical markers, I'm not gonna lie. It didn't have any of the typical markers, but I did my best to try to make the case as good as I can. I think I did a good job. Would it have succeeded? I have my doubts. I have my doubts that it would have succeeded. I feel like if I could have gotten to the merits, I had a pretty decent chance of winning. But actually taking the Supreme Court to pick up the case, I didn't have the highest of hopes. As I said before, like 0.7% of cases, and it's lacking a lot of the traditional markers. It's like if I can actually get them to pick up the case, I think I can win. But getting them to pick up the case was the challenging part. But I did my best to sell them that was important, an American flag and all the rest of it, blah, blah, blah. So conclusion. The review by this court is crucial because cancellation of USERRA puts many Americans at risk of discrimination for due to military service. So aggressive framing, they have canceled USERRA. They've canceled it. This includes discrimination related to injuries incurred while serving our nation. Our nation's veterans have made significant sacrifices for the country. It's important for this court to promptly review the situation to prevent the Seventh Circuit's misunderstanding the law from depriving them of important and necessary benefits meant to help veterans with combat-related discoveries overcome the workplace challenges intended by Congress. The petition for writ of certiorari should be granted. Respectfully submitted, Kurt Mueller from the Kurt Mueller Law Firm. And if you have a U.S. Supreme Court case that you'd like me to write, I can work for you. And I will try to produce a brief that is of equal quality to this, because I wrote this. And I think it's good. I think it's solid. I think I've read a lot worse. Again, not claiming, the angels are singing. Not claiming that the light of heaven, not claiming the light of heaven itself shines upon me. But I think I did really solid. So what are typical markers that would make the case successful? Circuit splits are the most common way to get there. So when you have the same issue of law that's been decided by multiple courts of appeal in distinct ways, that's the best way. That's the most common way. So there are 13 circuits in the country, 12 of which are geographic based. So we have 12 geographic circuits. And not infrequently, they come to different decisions from each other, and they rule the law means one thing. One circuit says the law means one thing, and a different circuit says the law means a different thing. And it's particularly helpful if you can get multiple splits, because that tends to, the Supreme Court doesn't pick up every circuit split, but they're likely to pick up circuit splits when either you have they're unlikely to pick up a case if all you have is one circuit disagreeing with another circuit. But if 6 circuits have ruled on the issue, Like, well, 6 is just an arbitrary number in this case. But if multiple circuits have picked up the issue, 3, 4, 5, 6 circuits have picked it up, then they're going to do it. If you have a multi-way circuit split, so you have more than 2 interpretations, if you have 3 and 4 interpretations, that's the most common way. So the most common way is a circuit split. There wasn't really any circuit split here. There wasn't really any case law at all on this. I had to stretch a little bit to find law. I mean, I cited a lot of cases, but I had to stretch to find cases. There weren't a lot of cases, So the circuit split is the most common way. Second most common way, a case of particular national importance, a case that involves particularly important, particularly notable issues of manifest, unique importance. Most often, constitutional crisis kind of cases, or cases that involve that's basically cases that despite the lack that need to be resolved right now, cases that impact lots of people. For example, the deportation cases, because they're not really about one person, they're about a lot of people, right? And also there's splits on top of that and things like that. And so also it's a case of national importance, because it's important, and also because it involves separation of powers issues, and also because it involves a lot of people. But yeah, cases of unique national importance, cases that impact a lot of people. Those are sort of your typical markers, or much less common in category number 4, hidden category number 4. The Supreme Court just really wants to beat up on the lower court for some reason. Hidden category number 4. They really just want to beat up on them for reasons. Because right now the Supreme Court has decided that your circuit is its bitch. This happened previously with the Ninth Circuit, for example. So even if they lacked the markers, the Supreme Court was making the Ninth Circuit its bitch for a while, and just bitching and just making its bitch for a while. The Sixth Circuit on habeas issues. Is it a habeas case? Does it come out of the Sixth Circuit? Oh, good. The Supreme Court's probably going to take it. Right? It's like, oh, not because it's particularly important, not because there's a Sixth Circuit, not because there's a split. Oh, because the Sixth Circuit made a decision. Oh, they're wrong. Yeah, the Supreme Court likes to make the Sixth Circuit its bitch on habeas issues. Or the Court of Appeals for the Federal Circuit in recent memory. Like when it comes to patent issues, right? For like 25 years, okay, the Court of Appeals for the Federal Circuit was created in 1981. It has exclusive jurisdiction on patent issues. So you can't have a circuit split. It's not possible, because only the Court of Appeals for the Federal Circuit hears patent cases. So you can't possibly have a circuit split, right? And like, okay, so you can't possibly have a circuit split. What cases are particularly important? What patent cases are particularly important? Not usually. Is it a crisis? Is it a constitutional crisis? Not really. So for 25 years, the Supreme Court never heard a case from the Court of Appeals for the Federal Circuit. Okay? For 25 years, they never heard a case from the Court of Appeals for the Federal Circuit. And the Supreme Court and the Court of Appeals for the Federal Circuit became a little too cock of the walk. The Court of Appeals for the Federal Circuit decided it was the Supreme Court, because after all, the Supreme Court wasn't telling it otherwise. And so the Court of Appeals for the Federal Circuit decided it was the Supreme Court. And and then at some point the Supreme Court was like, no, you're not the Supreme Court, and we're going to make you our bitch for a while. So the Supreme Court then suddenly went from hearing no cases out of the Court of Appeals for the Federal Circuit, suddenly to hearing comparatively a lot of cases out of the Court of Appeals for the Federal Circuit, and basically reversing them on everything. Just to remind them that the Federal Circuit was, in fact, the Supreme Court's bitch. So those are your markers. Circuit splits, cases of unique national importance, cases that involve a lot of people. The Supreme Court wants to make you its bitch. Those are your 4 markers, but none of those markers really existed in this case, so I had to come up with other stuff, which basically boiled down to America. To my credit, however, the Supreme Court had, at the time I was writing this at least, taken up what seemed to be a disproportionate number of veterans cases. So they seemed like they were on a bit of a veteran kick, which was helpful, right? They seemed like they were taking an abnormally high number of veteran cases at the time I wrote this petition. So that was nice. They're kind of interested in the subject matter, so maybe that gets me a buy. But we never got to find out because my client fired me and hired someone else who filed a shitter brief. And we could compare the shit brief compared to my brief and see which brief, if you like their brief better, but I thought it sucked. Well, that's not fair. It didn't suck. It just wasn't as good as mine. Who's the person in the photo? You mean behind me? Who are the people in the photo? This is Norman Rockwell. Do you not know Norman Rockwell? This is Norman Rockwell's freedom of speech. This is Norman Rockwell's The Troubles We All Live With. This is depicting an integration event in New Orleans during desegregation. This girl's name is Ruby. This is Ruby being taken to the school by the federal marshals because they're integrating the schools in New Orleans. This is the Statue of Liberty. Hopefully that clarifies. So two Norman Rockwells and a Statue of Liberty because kick ass. Yeah. I find this painting very inspiring. I find it very inspiring for a number of reasons. It's like, it's a reminder of how far we've come. People who say things like racism is as bad as it's ever been. You ever hear those people? Like, racism is as bad as it's ever been. And you're like, seriously? Really? Are you sure? Are you sure racism is as bad as it's ever been? Because I don't know, man. I don't know, man. I'm not 100% sure about that, right? I think maybe things were worse in the past. So it's like it's inspiration to remind us of how far we've come. It's inspiration to remind us of the rule of law. It's inspiration of a lot of things. I find it very inspiring. I find it very hopeful. I look at that picture and I'm like, kick ass. America kicks ass. So, yeah. Some people find it depressing. I find it very, very encouraging and uplifting. It's also a reminder that in the end, you need strong men to stand up. It's like Ruby can't do it by her own. She needs she needs strong men to literally walk her to class and force her through the schoolhouse gates. It's like, at the end, we need force sometimes to make things happen. It's a reminder of a lot of things. So yeah, that's New Orleans during desegregation. I'm not sure that this event, I'm not sure that this is like a photorealistic picture. I'm not sure that this exact scene actually exactly happened, but that is a real girl, and the event happened. So I think this is an interpretation of the event. I'm not sure that this is like a photo or equivalent. I don't know that this like photo exists, but it's a painting of that event in any event. So yeah. Yeah. Also, Clemson, go Tigers. Clemson bears the distinction of being the first, at least public school, and I think maybe first school in the South, first university to desegregate. I met the guy who was the first before he came to our school and spoke. So Clemson has the distinction of being maybe the first public school and maybe the first university in the South to desegregate. So Clemson got there first. Kick ass, man. We're the best. We got there. We're number one. All right, what else can I talk to you about? Because there's still 2,000 of you here. And what else do you guys want to talk about? Yeah, and if you thought 1950s racism was bad, you're going to be even more surprised by 1850s racism. That too. Yeah, 1850s racism. Yeah, what was happening in 1850? How are African Americans being treated in 1850? Let me think. Okay, when was the Civil War again? It was the 1860s, wasn't it? Yeah, the Civil War is the 1860s. So how are things going in the 1850s? Probably not that great. Yeah, probably not super wonderful. Yeah, we can discuss watch content another time. Watch content is used for breaks in court and otherwise when I need filler. But we can discuss watch content another time. Let's do the shitty brief for Schedule 1. We could do the shitty brief. It's calling it shitty is unfair. It's just, it wasn't as good as what I wrote. But we could read what they wrote. Then you can decide if you like their brief or my brief. Taking note, of course, is my channel. And if you say you like their brief better, I might be sad. But we can see if you like their brief or my brief better. Give me a second. Cover the 2 judges who were arrested. I covered one of them yesterday. I did a stream about it yesterday. The judge did it bad. At least the one judge I did it bad. She seems guilty, and she's going to prison or jail, probably. So yeah, I mean, yeah, all those things. My insight on Turtleboy 508, we covered 508, didn't we? Yeah, we did. That was the first one of the first things we read was Turtleboy 508. That's where we started, was Turtleboy 508. Let's see. Let's read slightly inferior brief. Now, I mean, this guy has a lot more experience than me, but I still don't think it's as good. So this guy is a more seasoned attorney, but I still don't think it's as good. And also, very strangely to me, and I still don't understand this decision, he filed it. He filed it on the standard paper, which the client had to pay for that, which was really weird, right? My client didn't have to pay for printing costs, but he got the client to pay for printing costs because my client has special protections under law. So there's special rules because of the statute. My client doesn't have to pay costs. She didn't have to file. She didn't have to pay for the lawsuit. She didn't have to pay the $400 filing fee. And she didn't have to pay any of the other filing fees. And she wouldn't have had to pay the filing fee at the Supreme Court. And she also didn't have to file it on the special paper, which would have been a lot cheaper because the special paper is a pain in the ass. Special paper costs a fortune because no one prints it, right? No one prints the special paper. So you have, so if you want to get it done, you have to get it done by like basically a few companies, and they charge you like $5,000. It's outrageous. And it's like, I could do it at Kinko's for $1.59, not quite, but damn close, It's like, because I could have just done it on 8.5 by 11, but for some reason when they filed it, they didn't file it on the special paper. They filed it on the normal paper, and they charged the client for it, and they wasted several $1,000s of my client's money, which seems like a really odd choice. But that's apparently the way they roll. I don't know. So here is this, more questionable brief in the same case. This is the one that was actually filed. John Meyer filed this brief, and this was produced by Legal Printers LLC. See, it's stamped at the bottom, Legal Printers. This costs $5,000. This is expensive. Why? Why'd you get it printed by Legal Printers? I would have done it myself at Kinko's. It would have been fine. Shit. All right, here's their question presented. These are the longest asked questions presented ever. This question is too fucking long. Okay, my question presented, I give a lot of background. Okay, so I wrote this question presented and gave a lot of background. But then the actual question, so I wrote 2 paragraphs of introduction. But then the actual paragraph was 1 sentence. This is the actual question I proposed. It's 1 sentence long, right? It's 1 sentence long. Look how fucking long their question presented is. Who writes a question presented like this? Who writes this? This is bullshit. All right, their question presented is, where the Court of Appeals for 7th Circuit erred in applying 38 U.S.C. 4311 of the Uniform Services Employment and Reemployment Act, USERRA, the wrong provision rather than 38 U.S.C. 4313, the right provision, which applies to a person who, like the client, has a disability incurred in or aggravated during her military service, and in doing so, endorsing the court's decision preventing the client from offering a trial consequence. Anytime you want to end the sentence, by the way, would be fine. Anytime you want to end the sentence would be just fine. Preventing the client from offering at trial evidence of her post-traumatic stress disorder and subsequent treatment that ought to have been admitted, so the client could have kept her pre-deployment job. Entirely different analysis than of the Employee with Disabilities Act, period. Oh, fucking hell, we finally found a period. Holy shit. Instead, the lower courts relied on the ADA to trump USERRA's reemployment right protections to the substantial prejudice of the client and every other USERRA employment seeking reemployment after discrimination of employment services. Also, why is your question not end in a question mark? You know how I said the question presented and how it ended in a question mark? Because I'm asking a question. Where the fuck is your question mark? Fuck you. Where the Court of Appeals for the Seventh Circuit erred in affirming the district court decision that the client could not perform the essential functions of her position with or without reasonable accommodation was thus not a qualified, again, anytime you want to find a period will be fine, was thus not a qualified individual with a disability under the ADA and thereby conflated statutory frameworks for USERRA disability with ADA disability and working injustice for large swaths of American populations, both veterans and the disabled. I don't like this guy's writing as much as my writing. They don't have to end in a question mark. You're correct. They don't have to end in a question mark, but still, like, it's a question. So, pressing on. It's not a requirement that it end in a question, but it's supposed to be a question. And questions typically end in a question mark. That's typically how you designate a question. I'm just saying. Parties to the proceeding, related proceedings, table of contents. Their table of contents isn't broken up into sections. They just have arguments and then conclusion. They don't have subsections in their table of contents. I have subsections. I broke up my argument into subparts. Who doesn't break their section? Okay. We have our table of authorities. Questions, opinions below, jurisdiction, statutory provisions involved. They're citing both, they're citing the Civil Rights Act, the Americans with Disability Act, the Rehabilitation Act, the USERRA, and the Vietnam Veterans Readjustment Act. I don't think that's true. Those are statutory provisions that you might refer to, but they're not involved. You're not suing under Title VII. You were suing under the ADA, but no. You weren't suing under the Rehabilitation Act, and you weren't suing under the Vietnam Veterans Act. So they're not involved. No. Okay. The client is a veteran of the U.S. Army with 3 overseas tours and combat zones, the third of which caused her chronic PTSD. You shouldn't say that. And a U.S. Army reservist who was hired by Volvo in 2005. While the client worked for Volvo, she was summoned to active duty with the U.S. Army Reserves 3 times, 2006, 2008, and 2009. They're biting some of my shit, I can tell. They definitely... The client, of course, was entitled to and did receive a full copy of my brief because it was work product. They were entitled to it. So I think it's possible. The new attorney might have read some of my brief and might be biting some of my shit. Not that they can't do it. It's not like they're not allowed. I'm just saying they're cribbing me because I'm better than them. Under USERRA, more specifically, her employer was required to reemploy her after completion of each term military service. Congress imposed this obligation when it exists for employers above and beyond the obligations that exist pursuant to the ABA, more specifically, some statute. USERRA requires that employers reemploy disability veterans regardless of whether the employer remains qualified or not in the prior position. Stated differently, USERRA imposes a higher standard upon employers where the district court and Seventh Circuit failed to apply, which was likely explained given limited guidance. As the trial judge noted, this court has provided on proper application. No, don't say that. You just said that there's limited guidance. You just said there's not much case law. Don't say that. You don't want to, no, don't say that. No. Specifically here, USERRA requires that if the employee is qualified, the employer must reemploy the veteran or service member in the position of employment in which the person would have been employed if continuous employment. But the employee is not qualified, blah, 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 citing statute. The district court and Seventh Circuit viewed the claims under the rubrics of the ADA and pursuant to different provisions of USERRA 4311, which prescribe differential treatment of service members solely on the basis of their status. In doing so, the court erred in rejecting and failing to analyze the disabling conditions she suffered due to service. This is reversible error and must be corrected to the extent effect Congress intended and protect the client. This court should reverse and remand and instruct it on the facts presented. Is it just me, or is their writing a lot more dry than my writing? I don't. The writing is a lamb. I don't know. I don't know. I like what I wrote better. Summary of the argument. The trial judge totally overlooked the plain language of USERRA 4302, which states in relevant part the chapter supersedes any other right, reduce, or benefit. I mentioned that. Trial judge erred in elevating the ADA over USERRA. More specifically, when two statutes appear to overlap, the USERRA specifically states USERRA remains prominent, and like here, the ADA remains subordinate. I'm not sure it specifically states that, but okay. USERRA states that if another statute like the ADA grants rights, less rights or benefits, then USERRA must be applied first, and terms cannot be diminished by plain language and case law interpretation. For service members who incur disabilities during military service, USERRA requires employer to make reasonable efforts to accommodate those disabilities and rehire the service person in a position they would have held but for a position the Seventh Circuit erred in. It's by contrast, 4313 applies to a person who has disability incurred in or aggravated during her military service in doing so. Statute requires the employer to do three things. They cite the relevant provisions. District Court read out 4313A3 and instead erroneously relied on 4311, which prohibits workplace discrimination resulting in adverse employment based on anti-military animus to dismiss the $7.8 million verdict. Also, by the way, was it necessary when you wrote $7.8 million to include cents? Did you really need to include that it was also 0 cents? Finding that 4311 did not provide protections for disability. Seventh Circuit compounded the trial judge USERRA's misplacement, thank you, Miss Mandy, for the one gift membership, that's appreciated, by agreeing with the district court that the client was not qualified with a disability under ADA with or without accommodation. Further, trial judge refused to allow the client to offer evidence of service-connected PTSD and thereby gutted the claim, which had the evidence been properly amended would have proven that Volvo took new steps under the escalator principle, the equivalent position principle, nor the nearest approximation principle to lawfully reemploy them. Ugh. Yeah. She owns the brief. If they pay the attorney to write it, she 100% owns the brief. Yeah, I'm not saying anything otherwise. Yeah, the client paid for it. The client owns the brief. It's work product. It's her work. She's entitled to it. Yeah, she's absolutely entitled to it. I don't dispute it. She's absolutely entitled to give the new lawyer it. She's absolutely, because it's part of the file. In fact, she should. She'd be derelict not to give the new attorney the file, including what I wrote. But, I can't help noticing that the attorney seems to be cribbing me, which, is perfectly legal and ethical. He's not doing anything wrong, but he's biting my shit. And he's doing it less well than I. He's not only biting me, he's not only biting my shit, he's doing it more poorly than me. Put differently, the ADA does not mandate training for disability, while USERRA specifically requires employers to reapply and find a suitable position, take reasonable efforts to train, or assign the nearest approximation to their returning veteran. Stated another way, the ADA does not require the employer to prove in the affirmative they made the returning employee qualified or place them in a position with like seniority and pay. Indeed, the ADA states that the employer cannot accommodate the employer's rightful right to terminate. In contrast, USERRA imposes greater obligations on the employer and confers upon service member employers most robust protections. The employer must find the returning employee, returning veteran, any other position for which they're qualified. When the ADA standard is used in place of USERRA, as the case here, service member is denied protections Congress created. Moreover, the Seventh Circuit decision in this case conflicts with the court decision in Torres. As it turns out, the client, in consultation with counsel, remarked in person, had I sued in the Fifth Circuit, I would have been allowed to maintain my disability claim. Yeah. In the case, the Seventh Circuit shuttered the federal court doors to the claim for reemployment efforts to identify a suitable post-military provision. By contrast, in Torres, this court reversed and remanded, reopening the federal courthouse doors to Torres to bring its 43A3 claim. They should be afforded the same protection. Herein lies no reason to grant a split between the Fifth and Seventh Circuit on the very same question of law. Yeah, I think they're trying to manufacture a split where none really existed, but I don't necessarily begrudge them. But, this petition arises from a lawsuit arising from the U.S. Army reservists and veteran of 3 overseas tours who served their service. District court initially, going through the case, granted judgment, second trial, Seventh Circuit also adopted termination for Seventh Circuit. Argument, the lower court should have entertained the claim, recognized difference between USERRA, return to work. USERRA provides substantial protections to veterans who sustain permanent or damages as a result of service-connected injuries. Maybe the guy who wrote this thinks I was too flag wavy. I mean, I appreciate that. That's a fair criticism. Maybe the guy who wrote this thinks I was too flag wavy because, it's not necessarily your strongest point. It's not necessarily the greatest thing to just, to fly the flag. Maybe he thinks that there's other things to work from, and maybe he's critical of me for that reason. But this is a little dry, in my opinion. USERRA provides substantial protections to veterans. USERRA protections are in many ways similar to those provided under the APA. USERRA borrows phraseology from the ADA. There's substantial overlap. I'm not sure I would have written that. But USERRA goes beyond the ADA. For example, the reemployment rights under USERRA provides veterans are greater than those provided to other employees than under the ADA. I'm also sure this attorney charged my client a very pretty penny for the rewrite when they had already paid me and they wouldn't have been due much more money. They already paid basically what they would paid for the brief. So this is written a lot closer to what I've been taught. Yeah, I appreciate that. This is written a lot closer to like what shoe writes, to like white shoe writing. Yeah, this is fair. So this is written a lot closer to what you've been taught. I think this is a very fair point. Yeah. I tend to agree. This is much more written. This is more written like a practiced white shoe attorney. So mine is less so. But, as to which you prefer or which the court would prefer, who can say, but, fair enough. To establish a cognizable claim, they must have averred that she is subject to adverse employment action and military service is a motivating factor. Once established, the burden shifts to the employer to prove the termination would have been taken in the absence of membership. More specifically, like whereas here, a recurring veteran has a disability incurred during mobilization, the employer is precluded from law by terminating disability veteran and must follow the statutory requirements set forth in 4313. This person is a U.S. Army veteran and reservist. She began working with Volvo as a material handler. I didn't really go into what exactly her job was because I didn't think it was particularly relevant. I was, and remained employed there until she was fired. Remained employed. There's no question that she knew of the status as a veteran and Army reservist when she was hired. Not that it matters either way, incidentally. During the tenure as Volvo, she served as an Army reservist and often had to take time off from Volvo to attend to her military duties as authorized by USERRA. Also, because of her military service, she suffered from PTSD, condition she communicated to her supervisors Volvo, which manifested after her third tour. I wouldn't necessarily make clear when it manifested because why limit myself? Like when exactly did the PTSD occur? It's not really important. It's like that's when Volvo learned about it, but it's not necessarily important when it exactly occurred. Also, incidentally, like I don't know that it exactly occurred in that time. But that's just me. Employees at Volvo are subject to attendance policy under which the employer receives whole or fractional occurrence every time they're late to work. The policy outlines disciplinary steps to be taken with the employee, with the last step resulting in termination. After returning from tour duty, they accumulate several occurrences, most of which arrive to work a few minutes late. Why on God's earth would you write that? Why would you write that as the attorney for the clients? That's Volvo's argument. Why would you write that, right? My job as your attorney is to put your case in the best possible light. Of course, Volvo's going to come back and say, we fired her for reasons other than she was a veteran. We're going to fire her because she was late. We're going to fire her because she wasn't on time. That's Volvo's argument. But why would you, as the attorney, why would you make that clear in your writs? Why would you make that clear? Right? Let Volvo argue it. That's what they're going to argue, and then I'll deal with it in the reply. Why would you argue it in the first instance? That doesn't make sense to me, man. Ultimately, Volvo fired the client. When Volvo claimed the termination stemmed from violations of attendance, again, why are you pointing this out now? The client believed her termination was a result of disability and therefore pretextual. She filed a lawsuit that's the subject of this cert. Initially, in 2014, the district court granted summary judgment to Volvo on all claims, and they appealed. The Seventh Circuit reversed on both ADA and USERRA. On remand, the parties proceed to trial on two claims. A jury returned a verdict in the client's favor, awarding her the money that we discussed and finding they willfully violated USERRA. After she requested equitable relief following trial, district court awarded her back pay, front pay, and other employment compensation. However, pursuant to statutory limits, the district court reduced the compensation and punitive damages to $300,000. Volvo then moved for a judgment as a matter of law and an alternative new trial. District Court granted the motion for a judgment as a matter of law because they failed to show at trial that she was qualified under the ADA. Court next addressed the motion for a new trial. In doing so, the court found the jury's damages award to be monstrously excessive and a result of passion or prejudice. But because the court had already resolved the ADA claim in Volvo's favor, it need only determine whether the passion and prejudice likewise infected the jury's liability determination of the USERRA claim. I don't feel like that's the best ground to appeal on. Like, that is a valid ground to appeal, but I don't think that's the best ground. Because, yeah, I mean, that's an abuse of discretion analysis, but it's not as strong as what I wrote. So I think you're raising issues that are not as strong as the issue I raised. The court concluded that it thereby warranted a new trial in USERRA claim on Rome. February 2022, the district court held a second jury trial in USERRA. Prior to this, the district court excluded evidence of PTS diagnosis and treatment, finding it to be irrelevant. A turn of events that would not happen in district court sitting in the Fifth Circuit. Ultimately, the jury found in favor of Volvo. They filed a motion to reconsider pursuant to federal rule. The court denied the motion and the timely appealed. Challenged district courts granted the measure of judgment as a matter of law. Seventh Circuit affirmed as a matter of law, concluding could not prove that she was qualified. And more specifically, Seventh Circuit noted that Volvo maintained a policy that outlines attendance requirement. Again, why are you making Volvo's case for them? Like, why are you making Volvo's case for them? Why are you saying these things? That's what Volvo's going to write in response. Why are you saying it now? I mean, you hope that Volvo's going to write in response. But you know why? There's no particular reason. Maybe Volvo somehow drops the ball. Probably not. Probably Volvo has pretty good lawyers who are not going to be a dum-dum, but maybe they do a dum-dum and don't raise the issue. And then why am I raising the issue? Have I been here for 3.5 hours? I certainly have. And we still have 1,700 people left. We're losing viewers by the minute, but that's okay. I guess you guys are not as interested in this anymore. Also, with respect to the motion for a new trial, she contested trial removal to allow the evidence of PTS diagnosis. Seventh Circuit held USERRA specific court did not evaluate, and both the trial judge and Seventh Circuit missed the critical and dispositive analysis. Statute requires the court to do 3 things. Okay. The organization is arguably written better than me. In terms of how they write things in the organization, I'm not sure that they should be including everything they are, but the organization might be written better than me. Both the trial judge and Seventh Circuit missed the critical and dispositive analysis. Under the section imposed the duty to make accommodations. Disability cannot be reasonably. Yeah, okay, this is arguably, at least in terms of presenting things, this is arguably cleaner than what I wrote. So maybe there's something to be had there. Both the District Court and Seventh Circuit decided this upon the ADA, not USERRA, which was reversible error. And I'm not sure I can I'm not sure I can be bothered to read any more of this. I feel like we've got the gist of it. Then they're going to go through the escalator stuff, which I didn't discuss. That feels like something I could have raised at a different point. Equivalent position, nearest approximate. Yeah, then they break that down a little bit more. The USERRA does not impose the definition of disability. Yeah, I don't think I can be bothered to read this anymore. But you can decide for yourself whether or not you like it better or not. To its point, it arguably presents things in a more. It presents things. I'll give it 2 points. It arguably presents things in a arguably more organizationally clean way, as opposed to the way I present things. So arguably, it's more organizationally clean. And also, if you like it, for this reason, it's presented in a much more traditional sort of white shoe style. It's written in a more traditional white shoe, $1,000 an attorney hour kind of style. It's written in a lot safer, traditional, blander style. If you like that kind of thing, which arguably the Supreme Court might like because it's more what they're used to reading, but it didn't work. So. I'm not saying that my petition would have necessarily done any better, but, I feel like it has points and merits to it. So I'm probably too close to it to give an objective opinion as to which objectively is better. I think what I wrote was good. I think what I wrote was solid. I think what I wrote had everything it needs to have. I think what I wrote, I like what I wrote. But as to which is better, I guess you guys will have to decide for yourself what you like better. Also, mine was drafted, not final. Yeah, but it was pretty close to being final. So there might have been a typo here or there or something like that, but it was pretty close to being final. It was near final form, so it wasn't going to change substantially. Yeah, it wasn't going to change massively from that. What I think about Ohio voting qualified immunity, I think it's awesome. So I hope that they, vote on it. Yeah. So other attorneys can decide for themselves. Maybe we can ask ChatGPT which it likes better. We can ask which it likes better. That's objective, right? If we ask ChatGPT which it likes better, let's see if we can ask ChatGPT which it likes better. Okay. And see what it says. Watch ChatGPT say it likes the other guy's brief better, though. I'll even do deep research on this one, just to see which it likes better. This is going to be embarrassing. All right. There's no way. There's very little ways that this ends well for me. I feel like I'm courting disaster, but I'm going to do it anyway. All right. All right. Let's ask ChatGPT. All right. I need to upload to you 2 files. All right. Download. Let's see. I need to save this document as, so I can upload it easily enough. Save as. I'll save it in my downloads folder because I'm not sure where it is right now. Browse. Downloads. Yeah, it's fine. Oh, okay. And then I need to send my own to the same folder so I can upload it easier. So save it. All right. Save as. Downloads. So I have it easily. Okay. Let's upload both these files. Open those. Okay, 2 files attached. Okay. Both these files represent proposed writs for certiorari, which I can never pronounce or spell. Certiorari. How do you spell certiorari? Lol. CERTIORARI. Proposed writs for the search. Yeah, it doesn't actually know. Proposed writs for certiorari to be submitted to the U.S. Supreme, let's say United States Supreme Court. Please compare and contrast the strength and weaknesses of the 2 briefs, of the 2 petitions. The 2 documents, of the 2 files. In particular, evaluate each brief, each file, for likelihood to be granted by the U.S. United States. Certiorari, I think certiorari is correctly spelled. It just doesn't know the word. Yeah, CERTIORARI. That's the correct spelling. It just doesn't know what it is. I'm pretty sure that's the correct spelling. Yeah. By the United States Supreme Court. In evaluating the files, consider the Supreme Court's own rules. Also consider any academic publication or scholarly resource that details how to write a file that is likely to be successful. What else can we ask it? Let me still make sure I spelled certiorari correctly, because I'm pretty sure that's correct, but double check. Yeah, that's correct. It's correct spelling. Great. What else can we ask it? Consider also, let's see. Also consider the differences in the writing styles between the two files. Okay. Each file was written by a different author, by a different attorney. Let's see. Let's see. What else can we say relating to this inquiry? Okay. Also provide, based on all available information about United States Supreme Court practice, which of the two files is ultimately better for the client as evaluated. I'll just say it's better for the client, just leave it at that. All right, let's see what ChatGPT says. Are we going to use ChatGPT 03 using advanced reasoning? Yeah, we'll use 03 for advanced reasoning. Let's give this a shot. This is going to be interesting on a lot of levels. Please, thank you for applying files. Could you please confirm if you'd like a comparison evaluation to be organized in a formal report structure, or do more in informal side-by-side comparison? I don't really care. What makes more sense? Let's do I don't know if I can tell to do both. I'm not sure that makes sense. Do you like side-by-side better? Or do you like formal? Let's do formal. Please organize in a formal report structure to the extent it would assist the completeness of the report. You may also additionally include informal elements as just informal elements. Keep it simple. All right, let's see what's happening. All right, now we have to wait for a couple minutes for ChatGPT to think because I asked it to do deep research. So this is going to take a minute. Thank you for confirming. I'll prepare a formal report comparing and contrasting two Supreme Court certiorari petitions you upload. First, constraints, witnesses, likelihood of grants, Supreme Court rules, and scholarly standards, writing comparison, overall recommendation, which is better. Also include informal elements where they help us illustrate or clarify points. ChatGPT is going to think about this for a hot minute. So we'll see what it thinks. And in terms of changing the title, no, that's okay, because if anyone watches this back on the live stream, they can just go back to the beginning, or as the case may be. So I don't think I want to rewrite it. I'm just, you know, I'll just put in parens that involves other things and other discussions. Comparison. I am gathering info on comparing the two Supreme Court positions, focusing on strength, witness, Supreme Court rules. Recommendations include formal structural citations, possible including elements. I'm noting various ways to open and find specific pages of the PDF, including browser functions. I should have asked it to give me a grade score. That'd been good. Oh, well. I'm piecing together methods to locate PDF drafts, such as different links, Python passage searching for content. It's thinking about something. Will ChatGPT be kind to me? Will it be mean to me? Will it say I'm great? Will it say I suck? Who knows what's going to happen, man? Who knows what's going to happen? I'm assisting potentiality searches. Kurt Mueller is the attorney for the first petition, when John Mailer had the second, presumably file one. It figured out that, Miss Uncivil's a good man. I try to be a good man. I do. I try to be a good person. Sometimes I succeed, sometimes I don't, but we all give it a shot. Above all, I try to be learned and educated, which this is potentially a real blow to my ego, right? Because I prize myself on my intelligence and my education and my learnedness. So this is the potential to be a real blow to my ego. We'll see how it goes. I'm noting the second petition from Seventh Circuit decision. Checking Myers' petition has more parts. It does not. It did not break it up into sub-segments, at least didn't in the table of contents. It didn't break it up. Clarifying the question presented. Myers' petition might be simpler. I don't know about that. Searching for question presented. Yeah, we both have question presented segments. I'm not sure theirs is better than mine. Piecing together the USERRA claim, the focus of what the trial court should allow PTSD evidence to do. So it's thinking about whatever it's thinking about. I'm thinking Meyer file might have a question presented similarly phrased. It's thinking. ChatGPT generally sucks at case research. Yeah, we'll see. I put on deep research, so hopefully that'll help. If it criticizes my citations, I'm going to be mad. My citations are fine. I looked them up. Check out merch while I wait. No, I don't want to right now. I'll check out merch later, Jinx. Remind me. I don't want to do it right now. I'm too invested in this. I can't emotionally shift. We're here. We're here for whatever this is, guys. Grok is superior. Sometimes Grok crashes, though. It's Don't Be a Dick merch. Okay, be that as it may, I'm going to review that in a second, Jinx. Then I'll do the merch thing. Okay, well, I need to stay emotionally in this space for the moment. It's not. I don't think it's healthy for me to emotionally shift and then shift back. Isn't 04 the last? They have 04 mini. They don't have 04 regular yet. 03 is this. Yeah, they got 04. They got 04 mini and 04 mini high, but they don't have full 04 yet. So 03 is where we're going to stick, I think. And it thinks about something. It's still thinking. It's thinking about something, man. Is it going to grade his work? It's trying to. I asked it to compare and contrast these two briefs. What are they good at? What are they weak at? How does it compare to, rules? How's it compare to, academic articles? What is the consensus? I asked it a pretty thorough question, so hopefully we get a pretty decent answer. What were the two briefs? They're both petitions for cert. One was written by me, one was written by the lawyer they hired after me. So they're petitions for cert in the same case. One is mine and one was written by the lawyer they hired after me. And we asked ChatGPT basically who did it better. And now we're waiting for who did it better. Because I like what I wrote. I don't necessarily like as much what he wrote. His was a lot drier for my taste. It's a lot more traditional white shoe for my taste, but ChatGPT can decide if it likes that kind of thing. Mine is a little more flag wavy than his, which could be arguably a point of critique. Yeah, it's thinking. Yeah, I asked it to do deep research. When you select that deep research button, when you select the deep research button in ChatGPT, it takes a hot minute to think about it. What are the rubric grading parameters? Thoughts faster. It is when you don't ask for deep research. When you ask for deep research, it takes a long time. The parameters are both these files. Both these files represent proposed writs for certiorari to be submitted to the U.S. Supreme Court. Each file is written by a different attorney. Please compare and contrast the strength and weaknesses of the two files. In particular, evaluate each file for likelihood to be granted by the United States Supreme Court. In evaluating the files, consider the Supreme Court's own rules. Also consider any academic publication or scholarly resource that details how to write a file that is likely to be successful. Also consider the differences in writing styles between the two files. Also provide, based on all available information about the U.S. Supreme Court practice, which of the two files is ultimately better for the client. That is the criteria. It's pretty thorough, I think. If it's very harsh on me, then I don't know what I'm going to do. Ask Grok. If it's very harsh on me, ask Grok what it thinks. I'm gathering info about Mayer's two questions about misapplied legal sections and evidence exclusion while analyzing Mueller's single question clarity and impact. That sounds promising. I'm thinking through references from Making Your Case on Supreme Court practice, focusing on writing, effective writing. Exploration highlights strategic emphasis on cognizant reading. I'm digging into Scalia's tip on certiorari petitions. Progress is steady with each quote. Taking a look at Stern and Gressman petition, gather relevant information. It's considering a lot of different things, man. It's considering a lot of different things. Help me. Help me. What sources are you looking at? It's compiling, it's thinking. This is U.S. Supreme Court. This is U.S. Supreme Court. This is big boys. This is big boys league. Comparison is the theft of joy? Probably. Considering Supreme Court practice updates, legal blogs, and scholarly articles, insight and certiorari factors. I'm weighing in the addition of citation to meet instructions. Considering if citation is helpful or a search within making your case could provide a better solution. Supreme Court Rule 10 is seldom applied to correct errors indicating it's rarely invoked. Yeah. I'm considering if any upload files include relevant commentaries or excerpts from Scalia making their case. They don't. Neither one would cite it explicitly. It would be a little unusual. I've seen it before as a footnote or something, but not really. Search for Scalia Garner making your case. Yeah, that's probably one of the best books written on the subject, to be honest. Scalia's book, Making Your Case, is really, really good. Searching for a Scalia Garner just brought me up a PDF snippet. Mueller's petition content didn't help. Piecing together Rule 10 factors by scanning for specific terms. You have ChatGPT 4 as well as 4.0 mini and 4.0 mini high. I don't seem to have that. More models. Oh, yeah, 4.0. You have 4.0, but this is 0.3. Yeah, 4.0 is different than 0.3. That's a mistake I made too. Yeah, so we're using 0.3, not 4.0. What the difference is between 0.3 and 4.0, I'm not quite sure, but yeah. O1 is the newest. There's also 4.5. We're using 0.3 for advanced reasoning. It seems to be the one that the advanced reasoning is for, so we're using 0.3. We'll see how it goes. Yeah, 4.5 is also in beta, that too. It's still thinking. It's thinking about something. 4.0, it's much better. Yep. Reanalyzing Rule 10 would emphasize granting petitions only for compelling reasons. It certainly does. Yeah, grants that rarely grant for error correction or misapplication of law. Yep, it certainly does say that too. I'm not denying that's what Rule 10 says, that's for sure. I'm not really sure his circuit split is a real circuit split, but it's an argument I didn't make, so, fair enough. If I had thought to make it, maybe I would have made it. I probably should have said something about it, to be honest. Four O is better than 3.0 generally as the labels. It seems to be researching something. It seems to be researching the internet. It says it has two sources. It's reading from law.cornell.edu at the moment, apparently. It's doing something. It's thinking. Yeah, I've used 4.5 with deep research, but it's good, but no better than this. Yeah. I'm weighing Kurt Mueller's concise style with Meyer and Mueller's potentially awkward phrasing. Oh dear. Could Meyer's more targeted approach be superior? It thinks I have potentially awkward phrasing? Oh no. Oh no. I'm refining making your case for scanning ABA journals and notes to capture key insights. Didn't like my phrasing? Digging into how USERRA and ADA claims intersect, especially in case of service incurred disability, and mapping out strengths of each petition, considering their factual framing and legal arguments. I'm curious about quotes from justices or clerks on cert factors. Yep. I don't think it's going to be nice to me. I don't think it's going to be kind to me. I think it's going to be very critical of me. I'm scared. Reading Harvard Law Review, examining potential reasons for access. Reading Michigan Law Review. I'm scared. Hold me. Hold me, chat. I'm scared. Employing significance of circuit splits, emphasizing needs to confirm a Fifth Circuit case to explore the text argument. We still love you. Thank you. I'm doing a Google search with potential restrictions. Maher hints at a split in the Fifth Circuit while Mueller discusses statutory misinterpretation. Both rules highlight significant federal questions. Yeah. Search missed these numbers. Now search Mueller's for millions to pinpoint relevant data. I cited my sources. I cited my source. Large swaths, American populace does not like that. This is good TV, right? Just waiting for ChatGPT. This is good. We got 4 sources so far. We got Lar.Cornell, Harvard Law Review, Michigan Law Review, two at Cornell. Thinking how Meyer's story might align with Mueller's section on PTSD, give Meyer's narrative probable narrative relevance. Meyer highlights significant consequences for numerous USA plaintiffs. Mueller, with measured caution, unveils sobering reality PTSD effects. Mueller's petition underscores the widespread nature of PTSD among veterans, aiming to emphasize the significance. Meyer's method is more concise, potentially risking less focus on the legal issue at hand. Well, that sounds a little bit more promising for me. The legal issue at hand, I didn't really think was going to win the day. Yeah, I mean, it was the legal issue felt. Yeah, I didn't think the legal issue was really going to win the day. I had to find other ways to make it work. You know, it didn't really scream Supreme Court. So I had to find, you know, the flag waving might have been a bit much though, but yeah. Searching for essential functions not qualified Seventh Circuit. I'll be interested to see what it says. Kurt figuratively screaming Eagles might win. Yeah. Seventh Circuit evaluates ADA arguments highlighting that a missed proper rubric and emphasizes USA's broader protection requirements. If you impacted circuit splits are the most often way to get there by far. Looking in terms of Supreme Court docket numbers filed versus granted, differential between filed and granted cases, it's about 0.7%. ChatGPT. Considering mentioning Scottish law or similar states, court grants about 1%. Yeah, it's a little less than that, to be honest, but yep. It's unlikely. The odds do not favor it. We're invested. Yeah, we're all invested at this point. No joke. Mapping out IFP guides, potential insights on compelling reasons. Yeah, neither of our cases are particularly compelling. I mean, we can only work with what we have. So neither case was likely to be granted. It's like it's a difference between. It's a small distinction at the end. You know. It's almost done. It's looked at 8 sources. It's looked at stuff. What is it thinking about? What is it pondering? It's pondering something. Please be nice. Please be nice to me. If you say I'm better, I'll be very happy. If you say I'm worse, his is probably better. Although I still wouldn't necessarily have made Volvo's case for it. I don't know that that was the wise thing to do. But how did the watch building adventure turn out? It didn't. I ordered new parts. They're on the way. Hopefully they'll be here by this upcoming weekend. We'll give it another shot. I failed, but I ordered more parts and I ordered some other stuff to help me that hopefully will aid in the journey. So I'm excited for part 2. I also ordered 2 movements in case I screwed up the other movement. This is sad. I don't know if it's sad yet. It's something. I got close. Yeah, you know what happens. I did learn some things. I learned how to put the dial on the movement. I learned how to put the logo on the dial. I got the hour hand on the minute hand song and then hand on, and then it kind of went to hell after that. I wound up defacing the dial and destroying the hands and probably destroyed the movement too. Sorry, having issues. Please try again. If it says sorry, please try again. I'm giving up on this effort. I'm not asking twice. I also ordered myself a homage watch of a watch I'm interested in, the Zen U1. I found a company in China that makes an homage, so I ordered that. See if that sakes my thirst for that particular watch. Wait and we wait and we wait and we wait, wait and we wait and we wait, wait and we wait and we wait and we wait, wait and we wait and we wait. It's thinking about doing a deep search. It's doing something. What is it doing? Who knows? It's doing something behind the scenes. I asked it to evaluate my channel as a deep search. That was kind of interesting. I thought that was pretty interesting. Yeah, big day tomorrow with the crash test dummies. Yeah, no doubt. What did it conclude? It's still thinking, man. It's still thinking. This progress bar is not finished yet. It is still thinking. It's been like 8 minutes, but it's still thinking. Once there was a girl who had marks all over her body, and when finally made her, had marks all over her body. Couldn't quite explain it. They'd always just been there. Mm-hmm. 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 Interesting music video too, man. It's a weird little music video, but you know. Do I evaluate the chat? Evaluating the chat might be hilarious. Asking ChatGPT to evaluate my chat and how can I make it not suck as much? Lol. Yeah, evaluate chat. Try to figure out what their major malfunction is. What time does Karen Reed start? 9 o'clock Eastern, 8 Central. Be there. It's already posted on my channel. Be there, be square, baby. $1,500 of you currently watching. Yeah, man. We had like 4,000. We've lost some people along the way. This is not good for the metrics, probably. Oh, well. Still a 20-minute average view duration, which is not bad at all, actually. I think the view duration actually went up slightly. I think it was 18, now it's 20. Split personality? Have I asked about Karen Reed? No, I've not asked about Karen Reed. I don't need its opinion on that. I got that covered, thanks. How's it going for Karen Reed so far? I don't think it's going very well for her so far, to be honest. I think that the prosecution has been doing much better, in my opinion. I think they're winning at the moment. But there's a lot of game left to play, man. There's a lot of game left to play. State starting with some good witnesses that are really good for them. But then once they got to the police and the investigation, they're going to have more problems. So we'll see. Yeah, Video Killed the Radio Star was the first music video. You're right. Absolutely. Video killed the radio star. Video killed the radio star. You know what that movie, you know what that song is about, though? People make a mistake what that song is about. It's not about music video. It's not music video killed the radio star. It's not music video killed the music video star. The song is about the advent of TV killing the radio stars from back when radio was the only method of communication. The song is about how television, the advent of television killed the radio stars from like radio play days. That's what the song is about. So I'm happy to have informed you about this. Did I see Carrie Roberts as a good witness, even though she lied to grand jury? Well, lied is one hell of an assumption. But, I mean, I thought the state did pretty well with what it had, all things considered. Okay, boomer. I'm not a boomer. I'm technically a millennial. I'm just a very old millennial. In our minds, in our car, can't rewind, we've gone too far. Oh. Put you on my wireless back in 52, lying awake, feeling you. See, 52 is a clue, right? Because 52, yeah, what was happening in 52? Yeah. Took credit for your second symphony, rewritten by machine on new technology. I'm too old, though. I am too old. I'm no longer the young kid I once was. The fact I'm 44 is pretty depressing. Why am I not 24? Why am I 44? That's not fair. Excuse me. Rock me Amadeus. Rock me Amadeus. I'm actually a zillennial. Ooh, I've never heard that term, but it's a zillennial. That's interesting. Zillennial? That's interesting. I never heard that one. Did they reclassify what I am? That's fun. I look good rocking Gamecock collars. I will ban you. I will ban you, and you know that. Kurt Shore is gray? I don't know what that means. I don't feel gray. My beard looks gray. Well, that part maybe. What was the case on? I read the entire case, dealing with an employment issue relating to a military veteran. What color am I feeling? Yeah. I'm sure I'm feeling any color. I'm blue, ba da bee da da ba, ba da bee ba da bee da da ba. It looks like it's almost done. Then I think I have just enough time to make it to kickball. So I'm going to read this and sign off and see if I can make it to kickball, albeit slightly late, so that I can run around a little while and get in the sun. Kickball starts, I think, at 4:30. So if I leave like right now, I can basically make it slightly late. That's fine. They're not going to start on time anyway. It might be done. I might have to refresh the page. I am not refreshing anything. I am not refreshing anything. That is witchcraft. Just ask if it's done. I'll just wait. I'm not in a rush. You started playing pickleball? That's cool. Tom Petty waiting is the hardest part? Yeah, pretty much. Have fun kicking balls? Thanks, I will. It is thinking about something, man. It is saying it's thinking. I'm not sure what it's thinking about, but it says it's thinking. Don't Come Around Here No More. I always like that song. Don't Come Around Here No More. Probably my favorite Tom Petty song. Is it stuck? Let me open a new tab and see if I open a new tab if it like does anything different. Okay, it did finish. It just, yeah, okay. I opened a new tab and it apparently finished without telling me. Okay, sorry. This is a long ass analysis. This is incredibly long. All right, so it apparently finished in 19 minutes. Holy shit. All right. Anyways, comparative analysis of certiorari petitions. Introduction. In the case, a U.S. Army reservist sued her employer under both the Americans with Disability Act and the Uniform Service Employment and Reemployment Act. After a convoluted path, including a jury verdict for the client and a subsequent reversal of the verdict, the case reached the certiorari stage. Uniquely, two different petitions for cert were prepared. One drafted by attorney Kurt Mueller and a later petition filed by attorney John Meyer. Both petitions seek Supreme Court review of the same Seventh Circuit decision that upheld the exclusion of the PTSD-related elements and effectively rejecting her USERRA claim on the ground that USERRA doesn't protect against disability discrimination. Despite their common goal, the two petitions differ in focus, style, and strategy. This report compares and contrasts Mueller and Meyer cert petitions with respect to their strengths, weaknesses, likelihood of obtaining Supreme Court review, writing style, and overall effectiveness. In doing so, it analyzes how each petition frames the legal issues and facts and evaluates which petition better serves the interests under consideration of Supreme Court rules and prevailing scholarly guidance on certiorari practice. The strengths of Kurt Mueller's petition. Clear focus on a single question. Mueller's petition narrows the case to one fundamental question presented, honing in on whether a court must allow a veteran to present relevant disability evidence to support a USERRA claim. By limiting the petition to one issue, Mueller avoids overcomplicating the ask. This petition aligns with advice from experienced advocates to present only the strongest issue rather than diluting the petition with multiple questions. The single question is directly tied to the trial court's exclusion of PTSD evidence, a concrete case dispositive error. This clarity of focus is a strategic strength, making it easier for the court to grasp what the case is about in an instance. So far, so good. Emphasis on statutory purpose and veteran protections. The Mueller petition strongly invokes Congress's intent and longstanding U.S. Supreme Court precedent favoring veterans' rights. It argues the lower courts usurped the manifest intent of Congress by ignoring USERRA's reemployment protections to the severe detriment of veterans. Mueller cites the Supreme Court's own admonitions that the law protecting service members should be liberally construed for the benefit of those who were served. By grounding the argument in the pro-veteran purpose of USERRA and analogizing to iconic World War II era cases, the petition appeals to the court's respect for congressional intent and sui generis solicitude for veterans. This thematic framing imbues the petition with the strength of importance and purpose. Broad impact and policy consideration. A standout feature of the Mueller petition is its extensive discussion of PTSD and prevalence among veterans. In a dedicated section, the petition notes that post-traumatic stress disorder affects millions of veterans and can profoundly impact their ability to work. It cites medical research and the Department of Veteran Statistics, for example, noting that an estimated 29% of lifetime PTSD rate among Iraq and Afghani veterans, with an even higher risk for those deployed in war zones. By providing these factual insights, Mueller underscores the question presented is not an isolated technicality, but one of broad national significance affecting millions of veterans. Well, that's definitely what I was going for. This strengthens the case for certiorari under Rule 10c as an important question of federal law with far-reaching public impact. The petition effectively communicates that the Seventh Circuit's ruling, if left standing, could harm a large class of service members transitioning back to civilian employment. This policy-oriented approach can make the petition more compelling by appealing to justice's sense that the issue has substantial human and societal stakes. Good vehicle presentation. Mueller explicitly argues that the case is a good vehicle for resolving the issue of reemployment rights for wounded veterans. The petition points out that the facts are largely undisputed and were even stipulated to, meaning the legal question can be decided cleanly on the merits. By highlighting the clean factual posture, Mueller preempts concerns about vehicle problems, such as mootness or procedural obstacles, that might deter the court from granting cert. This is a practical strength. It reasserts that the court, if it grants review, it can reach the important issue without getting bogged down in case-specific snags. Yep, it certainly does that. Structured and comprehensive argument. The petition is well organized into subpoints, A through D, under reasons for granting section. Each subpoint hits a different angle in favor of certiorari, from suitability of the case to strength of purpose, statutory purpose, to interplay between the USERRA and ADA, to national importance of PTSD reemployment accommodation. This structure ensures no major argument is missed. For example, Mueller cognitively explains that USERRA scope exceeds the ADA, emphasizing Department of Labor Regulations statutory text that requires employers to accommodate a service incurred disability by reassigning or strengthening the veteran if needed. Here, that bias shows the Seventh Circuit failed to consider 4313 was a significant legal error, not just minor factual. Overall, the Mueller petition thoroughness in covering legal, practical, and policy justifications is a strength that can make the filing feel substantive and weighty. Well, it was reasonably complimentary to me. What does it say about my opposition? Strength of John N. Meyer's petition. Crisp identification of legal error. Meyer's petition directly identifies the core legal mistake made below. The lower courts applied the wrong provision of the law instead of the right one. This point is front and center in the question presented, which asks whether the Seventh Court erred in using 4311 and excluding PTSD evidence where 4313 specifically protects disability returning service members like the client. By explicitly naming the statute and the error, the petition makes the issue immediately clear to the reader. It could have been written better, in my opinion, but that's okay. The precision is effective. Any law-trained reader, especially Supreme Court clerks, can instantly see a potential statutory misapplication is at stake. The question practically answers itself. Of course, the court should apply the correct position, which is a powerful way to frame the cert petition. I mean, yeah, you want to make it seem inevitable. I don't disagree with that. Additional question highlighting consequence. Unlike Mueller's one-question approach, Myers includes a second question focused on how the Seventh Circuit conflated USERRA's disability framework with ADA, thereby causing injustice to veteran and disabled individuals broadly. The second question targets the appellate court's holding that the client was not a qualified individual under the ADA due to attendance issues, a holding that they argue improperly bleeds into the analysis into the client's detriment. The inclusion of question two is strategic strength in that it paints a fuller picture of the stakes. It shows how the lower court's approach not only misread USERRA, but also sets a harmful precedent of treating military service disabilities as if they were ordinary ADA issues. By mentioning large swaths of the American populace, both veterans and disabled, in question presented too, the petition strength suggests that the Seventh Circuit approach, if left intact, threatens significant harm beyond just the case. In essence, the second question amplifies the sense of urgency and breadth, signaling what could happen to the client could reoccur to many others if the court does not step in, demonstrating a conflict, inter-circuit divergence. The Myers petition makes a concrete effort to show the Seventh Circuit decision conflicts with how another decision would handle the issue. A classic cert word scenario. I mean, they're not wrong, and I probably should have said something about it. So I will give ChatGPT that. In particular, I mean, I probably would have still made it a major focus, but I should have mentioned it. In particular, the petition notes that what happened to the client would not have happened to district courts sitting in the Fifth Circuit. It later states explicitly, district courts throughout the Seventh Circuit will apply 4313 to deny admission of disability evidence, while district courts throughout the Fifth Circuit will allow evidence pursuant to 4313. This is a potential strength because the existence of a conflict between the lower courts is the most important determinant of Supreme Court review. It's not wrong. By drawing a contrast between the Seventh Circuit restrictive view of USERRA and the more veteran-friendly approach to the Fifth Circuit, Meyer invokes Rule 10's paradigm scenario, two courts reaching different outcomes on the same issue. Even if the Fifth Circuit precedent is implied rather than from directly contrary appellate petition, which, yeah, it's a lot more implied. So he's making, I mean, to be fair, he's not doing an invalid thing. It's like, it's not really there, but like, he's trying to make it there, which isn't an invalid thing to do. It's like he's trying to get more out of there than there and trying to make it sound better than it is, which, you know, attorneys do that, including me. So he's not wrong to do it. So, you know, fair enough. By drawing contrast to the respective true and the more veteran approach, even if the Fifth Circuit precedent is implied, rather than from directly contrary appellate petition, the petition references district courts in the Fifth Circuit. The point is made that there's geographic inconsistency in how federal law is applied. This signals to the Supreme Court the guidance need to ensure uniformity. Notably, by including the conflict argument, Meyer addresses a factor that Mueller's petition downplayed, giving the petition an edge on Rule 10 considerations. Maybe, if you think the conflict is really there, maybe. Strong exposition of statutory requirement. The Meyer petition excels in explaining statutory scheme in a way that underscores the error below. In the argument section, it systematically lays out what the rule mandates of employers when a returning service member has service-connected disability. It lists 3 steps: the escalator, reemployment of prior position if possible, or equivalent position or next position that the employer must take, citing statute text directly. It then points out that both the trial judge and Seventh Circuit missed the critical and dispositive analysis by failing to apply the position. This logical breakdown not only educates the court about how USERRA is supposed to work, but also makes the lower court mistakes seem more obvious and egregious. Meyer's ability to distill the case to a simple syllogism, if the veteran is disabled due to service, USERRA requires X, Y, and Z, and that didn't happen, is a persuasive strength. It shows the court exactly in how the Seventh Circuit went off track. This writing in this portion is notably clear and authoritative, which enhances the petition's credibility. Okay, fair enough. Balanced tone and credibility. Meyer's petition strikes professional and measured tone that adheres to the Supreme Court's normal rules of ethics. He uses firm but respectful language to describe the lower court's error, saying the Seventh Circuit perhaps unwillingly endorsed incorrect analysis, and the misstep must be reversible error. By avoiding overly emotive or contemplative language, the petition maintains credibility. This tone is a strength because it aligns with the advice of Stephen advocates like Justice Scalia and Breyer Garner to maintain an even keel and not alienate the reader with bombast. Fair enough. I mean, you definitely want to keep bombast to controlled, and perhaps mine is not controlled enough. I mean, that's a reasonable critique. His is a lot more dry and necessarily less bombastic. So whether or not I went too far is, I suppose, in the eye of the reader, but it's a reasonable critique. The Meyer petition reads as a serious plea for correction of important legal issues not on attack on lower courts. Such a tone can make the justice censor clerk more inclined to view the petition as trustworthy. Alignment with Supreme Court rules. Meyer's petition is neatly formatted according to Supreme Court rules with all requisite sections. The question presented is labeled question presented for review and immediately gives 2 numbered questions. This faithful clients with the format has somewhat subtle strengths. It means the petition will feel familiar on the court. Even if it lacks small details like listing lower court citations and dates and related proceedings, demonstrates professionalism. In contrast, as will be discussed, Mueller's draft has some minor deviations, titling the argument section reasons for granting versus arguments. Well, no, it was argument and then like a subsection, but whatever. Meyer's scrupulous adherence to form likely reflects input from Supreme Court specialist printer and contributes to overall presentation. In some, Meyer's petition plays the Supreme Court's interest by vividly pointing out conflict, articulating the legal issue with precision, and framing the stakes as broadly as possible, all while keeping a respectful and clear tone. This strengthens the position for court's attention. Weaknesses of Kurt Mueller's petition: lack of explicit circuit split. A notable weakness in the Mueller petition is it does not clearly identify a split of authority. While argues the lower court misapplied USERRA, it stops short of saying other courts have decided the issue differently. The petition focuses on a Seventh Circuit error in isolation, without citing a contrary circuit or state Supreme Court decision that conflicts with it, namely because I couldn't really find one, to be quite honest. Under Supreme Court Rule 10, conflicts with different courts are a primary reason to grant certiorari. Mueller's petition does, quote, general pro-veteran language from Supreme Court, emphasize decision below defies congressional intent, but does not mention concretely another appellate court that would have ruled otherwise. In fact, the petition doesn't mention the Fifth Circuit or any other circuit by name. This commission could lead circuit pool justices to view the case as a one-off error rather than broad jurisprudential problem in need of resolution. Fair. Given this is a petition for a writ rarely granted just to correct misapplication of law of one case, found to present a conflict weakens the bid. Fair. Question presented, wording, clarity. Although Mueller's single question targets the right issue, its phrasing is somewhat awkward and unclear in place. The question reads, where there's a claim under USERRA, must the trial court permit a veteran to submit essential, logical, and reasonably relevant disability evidence to support a claim of employer's failure regarding required reasonable efforts? The wording is convoluted. A claim of an employer's failure regarding required reasonable efforts relating to the claim. It appears to be missing a noun, such as disability or obligation. Such irregular phrasing might be due to a drafting error or OCR error, but in any event makes the question presented less punchy than it could be. By contrast, Meyer's first question, while longer, explicitly identifies the statute and error. Mueller's question presented as written might force the reader to mentally edit or interpret to catch the mean. This lack of razor-sharp clarity in the question presented is a weakness because the question presented is arguably the most crucial position. That is true as shit, man. The question presented is huge. So if you think the question presented is bad, like if you don't think it's as good as it could be, man, that is a very, very fair point of criticism. It's like I tried to make it clean and easy and all the rest of it, but if you think it's convoluted, man, that is a very fair criticism. So the first thing the justices see and should be ideally frame the issue in a crisp, digestible way. A cert petition runs the risk of losing reader engagement if the question presenting is confusing or contains a grammatical slip. So it thinks I should have rewritten the question presented. Okay, fair enough. Over-reliance on policy and factual background. Mueller's petition devotes significant space to describing PTSD symptoms, medical studies, and veteran statistics. While the context understands importance, it could be seen as distracting from the legal issue. Supreme Court petitions typically focus on legal arguments with factual policy backgrounds kept distinct. They're not wrong. Mueller's extensive medical discussion, scanning from page 3233 of the petition, may come off as a mini research article on PTSD. Well, I was trying to get them to feel something and care. So, I mean, it was written deliberately, but just because it's deliberately doesn't mean that there isn't a better way to do it. So it was written with a purpose in mind. But, a justice or clerk might question how it's necessary for deciding the legal question. It's not. It was trying to serve a different purpose. There's a subtle risk this emphasis on PTSD's nature rather than strictly on what the law requires could dilute the force of the legal argument. For example, describing PTSD symptoms, such as intrusive thoughts, hyperarousal, does drive home why the accommodation matters, but does not directly address why certiorari criteria are met. In a tight page limit, cert petitions are normally 9,000 words. Every paragraph spent on general backgrounds, paragraph not spent on persuading why the court must take the case. Thus, Mueller's heavy factual exposition, while well-intentioned, is a double-edged sword. It adds context what might be seen as padding, or an attempt to invoke sympathy, definitely could be seen as that, rather than focusing on clear legal conflict or ambiguity. Some readers might interpret this petition as trying too hard to make the case seem important, which might inadvertently signal the legal issue itself needs bolstering. Well, to be fair to me, it's like, yeah, I kind of was trying to do exactly that because, like, to me, the markers weren't really there. And I didn't think I could really make the Fifth Circuit case. I didn't think I could make it work. So I had to try to do something else. So, yeah, I mean, it was very deliberately done that way. It was a little flag waving, as I said earlier, a little off point, perhaps, not directly devoted to legal issues. But, you know, to be fair to me, I was put into a box, not by the least of things my own client and what happened below. You know, I'm put into a box that I have to work from. And so I made strategic choices. Maybe those strategic choices were a mistake, though. You know, but it was done for a reason. But maybe those reasons weren't correct. You know, just because it was done deliberately and with purpose doesn't mean that, you know, that ChatGPT isn't wrong. Tone and language choices. In places, Mueller's petition uses strong, even harsh language that might be off-putting to the very audience it intends to persuade. For example, the petition accused the trial court of egregious abuse of discretion and manifest error with complete disregard. It calls the trial court reasoning inexplicable. While these characterizations convey passion, they risk undermining the tone and measure of respect. That's fair. The justice no petitions believe lower court error. They do not need hyperbolic adjectives to make the point. In fact, Justice Scalia and Brian Garner caution against vitriolic attacks. I don't know if I'd go so far as to say vitriolic, but knowing that overstatement can hurt the advocate's credibility. Mueller's petition, by venting about the lower court's complete disregard for enhanced rights as a veteran, could be seen as crossing into advocacy that's a bit too zealous. A justice might bristle at language suggesting the Seventh Circuit usurped Congress's intent, or the error was manifest, terms that imply a level of obviousness that if were so truly obvious, the Seventh Circuit would hardly rule as it did. Well, I'm not sure that's necessarily true. Of course, appeals screw up sometimes too, but, you know, fair. In short, a more restrained tone might serve the petition better. The relatively aggressive phrasing is a weakness because it could make the petition seem less objective and less compelling. Meyer's petition, in contrast, sounds more temperate by using phrases must be reversible error instead of egregious abuse, and this difference could affect how it's perceived. Fair critique. The language choice is sometimes aggressive, not invalid. Omission of the ADA issue entirely. Yeah, that is very deliberate. Yeah, I very, very deliberately chose to not ask the court to review the ADA petition. So, like, this gets into, before I read its critique of me on this point, like, this goes deep into the heart of as clear a strategic consideration as a lawyer can possibly make, right? You have multiple issues that you can raise. Which issues do you raise? And which issues don't you? Right? And this is like, there's no like clearly right answer to these questions. It's a call. It's a judgment call. And like, you don't necessarily know. And different lawyers are going to make different decisions. Like, so my case was all focused on USERRA. I noted how USERRA was different than the ADA. But I didn't ask the Supreme Court to consider ADA. I only asked them to consider USERRA. That was very, very deliberate on my part. You know, another lawyer could very reasonably argue that they should have brought both issues. And like, who's right and who's wrong? You know, who knows? Who knows, right? All I can tell you for sure is, you know, if you hypothetically have 10 issues you could raise, it doesn't mean you should raise all 10. You know, you got to choose which ones to care about. You got to choose which ones to raise. Maybe you should raise maybe all 10. Maybe you shouldn't. Maybe you should only raise one. Like, these are strategic calls, and like, you sweat over it and you make a decision. And I made a decision, man. It's like, I'm going to focus on USERRA and not the ADA. I didn't really think I could win with the ADA. The ADA didn't really get me to where I wanted to be. The ADA ultimately was not a winning issue for my client, in my humble opinion, because the ADA protections are much less than USERRA. We talked about what the ADA covers. It's much less. It's like, it only has to provide reasonable accommodation, and only with respect to the job you had. It's a much, much less requirement. USERRA was like where I want to be. I'm like, and I'm focusing on the veteran because veteran. Like, I'm focusing. So, you know, it can criticize me all I want, but I made my choices, damn it, and I stick by it. So ChatGPT can bite my ass on this one. Omission of the ADA issue. Mueller's petition pointedly does not ask the court to review the ADA aspect of the case. On the one hand, this could be seen as a strength, but it's also potential weakness because it leaves part of the case unaddressed. Yeah, it gives and it takes away. It gives and it takes away. Like, yeah, by not mentioning it, like they obviously can't rule in my favor for that reason, but it then forces them to focus on where I want them to focus on. So where's the shiny ball? Where is the shiny ball? Where do I want them to look? And I made a decision, man. So it is what it is. The Seventh Circuit decision had two components. It affirmed judgment as a matter of law on the ADA claim and it rejected the USERRA claim. Mueller's question only targets the latter. The risk here is the Supreme Court might find it awkward to take the USERRA issue in isolation if the ADA ruling is intertwined. I disagree because they're two separate laws with two separate things. I don't think they have to, I don't think they necessarily have to address the ADA at all. They're related, but they're distinct legal claims, and I made my decision. I'm sticking by it. ChatGPT, suck my balls. Indeed, the facts about the attendance central to the ADA ruling, which is one of the reasons, incidentally, I don't want to talk about it, because I don't want to talk about her attendance issues, because that's a problem for my client. Right? I don't want to talk about issues relating to her attendance. I don't want to talk about that. I want to talk about the fact they didn't accommodate her relating to her military PTSD. I don't want to talk about the ADA. I don't want to talk about her. I want to talk about those things. I made my decision, ChatGPT, suck my balls. Indeed, the facts about the attendance central to the ADA ruling are the same facts that relate to whether she could perform her job or reasonably be accommodated under USERRA's reemployment provisions. No, I don't think they're necessarily one and the same. I made a point of saying there's a distinction between the two. It's like reasonable accommodation versus reasonable whatever the other phrase was. It's not the same in the two statutes. It's different phrases. And I disagree with you. By ignoring the ADA question, Mueller's petition might leave the court wondering if a grant would fully dispose of the case. Yeah. If the court grants cert and ruled for the client on USERRA evidentiary, the ADA judgment finding her unqualified will still stand unless implicitly undone. Yeah, I wasn't going to win on the ADA. I can win under USERRA. USERRA is where it's at, baby. Okay. Meyer's petition avoids this by expressly raising the ADA issue in Q2, which at least flags the court the ADA ruling as part of the problem. Mueller's silence on the ADA could signal to the court he's effectively conceding that part of the case, which might make the overall position less attractive. Well, I am implicitly conceding it. I am implicitly conceding the ADA argument, but it's a strategic call. I made a decision, damn it. In the worst case, the court would worry that even if it sided with the USERRA, they might argue any error was harmless because it wasn't qualified anyway per the ADA. Well, let them make that argument. First of all, Volvo can't argue that because the ADA is gone. So Volvo wouldn't be able to argue the ADA. They can't argue ADA because the ADA issue is gone because I killed it. I killed it with my bare hands with a knife. Thus, by not addressing the ADA ruling may weaken Mueller's petition by not offering the court a complete fix. That said, reasonable minds can differ on whether raising the ADA issue is here. We're noting the downside of not raising it. Yeah, I stick by my decision, suck my balls. Minor formatting processing quirks. As a draft, Mueller's petition has a few minor irregularities that will not favor or noting a weakness. For example, table of contents lists an introduction and placed the statement of the case after reasons for granting, which is unusual. But some content suggests an introduction with an argument appeared before the full factual statement. These quirks lightly reflect drafting choices and might have been ironed out as the petition was finalized. Nonetheless, when compared to Meyer's impeccably formatted submission, fancy, Mueller's draft has a slightly less polished feel. This could subtly affect how the petition is perceived. Supreme Court sift through 100 petitions, and any deviation from the norm might draw unwanted attention. Fair. This is a minor point, but in a close comparison, it stands out as a relative weakness. All right, the weaknesses of my competitor's position. What is the weaknesses of him? Weaknesses of my competitor's petition. The length and compound question presented. Oh my God, was that a problem? Meyer's question presented are detailed, arguably to a fault. Question 1 is one long sentence spanning nearly 15 lines, you tell them, and it packs quite a lot. It cites the statutes, 4311, describes the PTS evidence, notes the ADA, and concludes with prejudice to the client and similarly situated veterans. While thorough, this presentation verges on advocacy-laden question presented, which some justices disfavor. Also, it's just literally hard to read. The Supreme Court clerk's guidance suggests the question presented should be short and non-argumentative. Meyer's question presented reads almost like mini argumentative paragraphs. For instance, the phrase the wrong provision rather than the right provision, and ADA to trump USERRA's protections to substantial prejudice of the client, while accurate from the client's perspective, interject a clear argument slant into the question presented itself. Likewise, question 2 concludes with conflating the statutory frameworks and working in injustice for large swath of the American populace, which is strong value-laden language. The risk is such loaded phrasing could come off as biased or overstating in the question presented, which is traditionally supposed to be objective as possible. Some members of the court or the clerks might prefer the question presented to simply state the issue in neutral terms. Thus, the very length and polemic nature of the questions may be viewed as a weakness. It could be perceived as a sign the petition is trying too hard to argue its case in the question presented, rather than leaving to the argument section to do its work. In contrast, a crisp, neutral question presented can be more effective. Also, literally, it was just literally hard to read because it was one long, incredibly unbroken sentence, moving from topic to topic, so no one could interrupt it. It was really quite hypnotic. Questions presented. Risk diluting focus. By presenting 2 questions for review, Meyer's petition potentially dilutes its focus. Making Your Case, a well-regarded advocacy guide, which is, basically the best thing ever written on the subject, so get that for sure, notes that including multiple issues can water down the impact of each, and to overwhelm the court might throw its hands if a petition seems too complex. Here, question 2, the ADA qualified individual issue, is arguably a secondary concern next to the main USERRA question. It is to my mind, we're not going to win under the ADA. We're not going to win under the ADA. We have a shot with USERRA. We have a chance, Plus, with USERRA, we get to literally wave, well, not literally, but figuratively, we get to figuratively wave the flag in front of the jury's face, and they're going to eat that shit up. We get to make speeches like, America is great. Look at our flag, 50 stars, red, white, and blue, We get to do all that shit. And also, Volvo is a foreign company. They're foreign. They're a bunch of Swedish bastards. Fucking Volvo. American flag. USA. 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 Yeah, that's where it's at, baby. That's where it's at. Including it might signal the case is multifaceted, which the court generally prefers cases that allow a single career rule to be developed. The justices could worry they have to address both the niche USERRA statutory issue and a fact-bound ADA issue if they take the case. Indeed, the ADA issue in Q2 could be seen as very case-specific. It essentially asks where the Seventh Circuit was wrong in concluding they couldn't perform a central job. This sounds close to error correction. Yeah, that wasn't going to work. Yeah, that's not happening. In presence of Q2, leads the court to perceive the petition as partially an attempt at single error correction on the ADA filing that could undermine overall chances. In short, the breadth of the petition, covering 2 questions and interaction of 2 statutes, is a weakness to the extent it complicates the pitch. My pitch was simpler. It was more focused, perhaps awkwardly written, but still. In the presence of 2, the court might have preferred a laser focus on USERRA statutory interpretation. While Meyer doubtlessly included 2Q to ensure the court addresses the whole problem, he runs the risk the court might view the second issue as distracting from the strength. Yeah. Also, I don't really want the Supreme Court to get into an ADA analysis. That seems like a problem for me. If they get lost in an ADA analysis, that sort of weakens my petition. I don't want them to do that. I want them to focus on USERRA. And I determined the shiny ball was USERRA, and God damn it, that's where I want the Supreme Court to look. I don't want to give them the ADA. They might if I give them the ADA, they might choose to look at the ADA. I don't want them to look at the ADA. I want them to look where I want to look. Damn it, I'm a damn magician. I'm doing some redirect. Fuck. Less emphasis on veteran policy and emotional hooks. Unlike Mueller's petition, Meyer's contains relatively little in the way of emotional or policy-driven narrative. Other than brief mention the Seventh Circuit ruling works as an injustice on veterans broadly, Meyer doesn't supply data or vivid examples about how many people it could affect. There are no statistics about PTSD prevalence, no quotes from legislative history about protecting wounded warriors. I felt like that was a good thing to do. While this keeps the petition legally focused, it also means the petition might miss some of the heartstrong tugging appeal that Mueller had. Something is wrong. Something is wrong when ChatGPT finds that my petition was the one pulling at the heartstrings, right? Like, holy shit, the Mueller petition was the one that was tugging at the heartstrings? Like, who is writing this, right? Who is writing this? Was it Kurt Mueller who wrote this shit? Yeah, Mueller's the one pulling at the heartstrings. What the fuck, right? Give me, it's like, okay. The Supreme Court's not driven by emotion, of course, but highlighting sympathetic effects can still play a role in certiorari, especially in borderline cases where justices are looking for reasons to care about an abstract issue. I will make any argument in service of my client, man. Emotional, Chevron is great, have the feels, USA. If it's in service to the client, I will make any argument. I will do it all for you. I'm just representing you, man. Whatever seems like the best argument, that's what we're doing, man. Emotional appeals, no problem. We got veterans for days. Please look at the veterans. Please look at their sad faces. You better believe it. You got it, man. Okay. In this case, the client is a decorated veteran who returned from combat with PTSD, a highly sympathetic profile. Mueller's petition leaned into that narrative, implicitly asking, is that how we treat veterans in their court? Yeah, I definitely did that. Meyer's petition is more clinical. One can view that as a weakness in terms of persuading that the court is compelling. By not elaborating on moral or practical consequences beyond general phrases, Meyer foregoes a chance to move the rear's conscience, which, definitely might help me swing a few of those left-wing votes too, right? I gotta give them something to vote for. I gotta get some of my left-hand friends to vote for it. So making them think about the poor veteran, I'll appeal to the left-hand side of the aisle, whatever works, man. I got some statute for the right. I've got some originalism for the right. I got some feelings for the left. It's a broad-based petition, man. I got it all. Thus, for readers who respond to a broader context, Meyer's position might seem a bit dry or underdeveloped in framing real-world importance. Argument section labeling. Meyer labels the main body of his petition argument with subsections 1 and presumably 2. This is a minor technical point, but usually cert petitions use the heading reasons for granting the petition. The Supreme Court implicitly expects a statement of reasons this should be granted. By using arguments, a term more common in merit briefs, Meyer's petition slightly departs from convention. This likely has no substantive effect, but it could give a perceptive reader pause. One of the petitioners fully attuned to Supreme Court practice. It's a quibble, yet in side-by-side comparison with Mueller's petition, which did use reasons for granting. Thank you. I did actually follow the Supreme Court rules. It's a small weakness in terms of adherence to Noor. It might suggest a less experienced touch, even though the content itself is on point. Again, this is subtle and probably insignificant, but is a difference. I'll take it. Potential perception of hyperbole in question 2. The phrasing working an injustice for large swaths of our American populace in question 2 could raise an eyebrow. It asserts a broad impact on large swaths of Americans, both veterans and disabled. This is a strong claim, however, one might question if the petition backs it up concretely. The case in hand involves a veteran with a disability. Yeah, that's the focus, man. I'm not trying to solve all the disabled people's problems. I'm sorry for all the disabled people's problems, but I'm here representing the client. She's a veteran. She's disabled. I'm representing disabled veterans. The disabled non-veterans can wait for a different case. If they want me to take their case, let me know. I'll help them out too, but not here. It's clear how this affects service-disabled veterans, but to say it affects disabled at large might be a stretch. Since non-disabled disabled veterans have ADA, and the issue here is about the interplay with military service, not for the least of reasons, by the way, that, Volvo's own statements relating to the military, right? Because Volvo had statements in their emails and stuff relating to military service. So focusing on the military service, seems like the way to go. Thus, a critical reader could see a bit of an overreach in the language, as if the petition is sweeping in generic disability rights to inflate the issue. If justices suspect hyperbole, that can hurt credibility. Without data or citations in the petition to quantify those large swaths, the claim might come off as unsupported rhetoric. This is a mild weakness, likely a conscious rhetorical flirt by Meyer, but one that could make a skeptic think the petition is casting a net too wide. Typographical and proofreading issues. There's at least one apparent typo in the petition, because he wrote the word in twice. That's okay, I had other minor things because it was a draft. Such small errors can occur in any brief, but a interpretive profession is the goal. A typo in the opening line can give a negative impression. This is a Meyer weakness, and likely the actual print petition didn't include the typo. It did, I'm pretty sure. Nonetheless, it's worth noting that Mueller's petition, being a draft, also has some rough edges. Both have minor proofreading imperfections. But Meyer's high-profile filing ideally should have none. It's a trivial point, but demonstrates that even Meyer's professional product was entirely free of blemish. You tell them. In summary, Meyer's petition, while strong on the merits, carries the potential weakness of complexity and perhaps overly advocacy-toned question presented along with relative paucity of emotive storytelling. And you know what I think about storytelling. You know what I think about storytelling and the importance of storytelling. I mean, less important in a Supreme Court brief, to be sure, much more important at trial. But, you know, again, at least in my humble opinion, I didn't have as much to work with as I ideally like in pure law. So guess what we're doing? Guess what we're doing? It's story time. It's story time. Yeah, we're doing story time over here with Uncivil Law. Everyone likes stories. These factors might make the petition marginally less accessible or compelling to the court than it could have been. Likelihood of Supreme Court granting cert. Under Supreme Court Rule 10, the justices vote to grant cert only for compelling reasons such as we discussed. With that in mind, we can evaluate how each petition positions the case with respect to criteria that could influence and thus likelihood of petition. Conflicts with other courts. This is often the single most important factor. It sure is. Meyer's petition clearly asserts a conflict. It suggests the courts in the Fifth Circuit would handle the situation differently than the Seventh Circuit. By effectively saying Seventh Circuit versus Fifth on the treatment of disability evidence, Meyer hits Rule 10's core. A court of appeals has decided an important question of where that conflicts. He's making more of what's there than that's there, but, you know, fair enough. I mean, he's dressing it up. He's dressing it up. He's making more than what's really there, but, you know, still fair play. Fair play. He's not wrong for doing so. But I think the Supreme Court might have noticed. So I'm not sure how, you know, but, you know, and it's a strategic call, right? So Meyer's not wrong for doing this. You know, he's not wrong, and it would be worthy for me to reconsider. If I were writing it, it would be worthy for me to spend time reconsidering whether or not I want to bring this point, because the ChatGPT is right. Circuit splits are by far and away the most likely way to get this. Now, it's a one circuit split, so still not great, but, you know, it's better than the 0 I presented. So it's worthy of reconsideration and see if I can make more out of it than I initially thought. So it's not wrong. This framing significantly boosts the likelihood for the cert petition. If justices or clerk verify and agree such a split exists, which not so sure about that gives them a concrete jurisprudential reason to intervene. Mueller's petition, on the other hand, does not emphasize any inter-circuit split because I didn't really think there was one. It frames the issue on a more serious error that needs correcting. More of a serious error. Rule 10 does allow grants when the Court of Appeal has decided an important federal question, but should not be granted. Yeah, I mean, it definitely was weak on the markers. I know it was weak on the markers. I was trying to make what I had work, but it's not wrong. Importance of the question. Both petitions claim the issue is important, but they do so differently. Mueller uses statistics and policy narrative to show ruling below undermines protections for countless veterans with service disabilities. Meyer uses strong language in questions and conclusions to assert every USERRA plaintiff disabled by service, and even the broader community are effectively affected. In terms of likelihood of assert, either approach can flag importance. The Supreme Court likely recognized on its own that protecting veterans is a weighty matter, and again, at least at the time I wrote this, the Supreme Court was taking up more veterans petitions. So that's one of the reasons I wrote the way I did, because at the time I wrote this, the Supreme Court seemed to be taking a disproportionate number of veterans cases. So one of the reasons I made the decisions about dropping the ADA, one of the reasons I made this about USERRA was because I was trying to lean into what seemed to be a slight trend. I mean, it wasn't a lot, but it was something. And so I made a very deliberate decision to try to lean into that strength. ChatGPT wouldn't know that, but I knew it. So that's one of the reasons I did what I did, because, you know, all those things. Plus, you know, flag and veterans and troops and eagles and all the rest of it. Mueller's detailed evidence of prevalence might resonate with some justices, for those attuned to veterans' issues or social impact. Meyer's broad-based assertions might suffice for others. Notably, the two cases touch on two different federal statutes, USERRA and ADA, and their intersection, which is inherently a matter of federal law. This can elevate the importance. On balance, both petitions succeed in portraying the case's importance, though Mueller perhaps does so more concretely with data. The court might find Mueller's demonstration the Seventh Circuit rule could disadvantage a large population returning veterans compelling. That said, importance alone without a split is often not enough unless the issue is pressing. You're not wrong. You're not wrong, ChatGPT. I mean, we were going on a wing and a prayer. You're not wrong. One might analogize during war or immediate massive impact, the court sometimes steps in, for example, the Hamdi case. But for statutory interpretation, they often prefer more percolation. They sure do. Here, the issue has existed under USERRA for years with few cases, and they're not kidding. I mean, there's not a lot of case law. I kind of had to stretch what was there. To be honest, the court may not see urgency. Meyer's conflicted claim, combined with importance, gives the coast both a law uniform rationale and a public importance rationale, a powerful combination. Mueller offers mostly the latter, which is slightly weaker by itself. It's not wrong. If, Meyer might be correct here for trying to make more out of this split than I did. So I might have to give Meyer the point on this one. I definitely have to go back and rethink about it. I definitely have to go back and reconsider it and see what I can do with it. Because, yeah. Thus, Meyer's petition likely edges out Mueller in persuading the court that compelling reasons are present. Lower court error in vehicle. The court must also consider how cleanly the case is presented here. Both petitions assert the Seventh Circuit and trial court erred in Meyer's law by misinterpreting USERRA. On this, there's little daylight between them. Neither suggests any procedural back barriers. Mueller explicitly touts both the stipulated facts and clear record as a good vehicle, which is a plus. Meyer implicitly shows a good vehicle by detailing the history and how the issue arose with motions to eliminate the appeal by making clear the question was preserved and squarely decided below. Because both petitions indicate the case is a suitable vehicle, the court likely won't reject one on the other or over vehicle grounds. However, the court were concerned about the scope of review, needing to fix also the ADA ruling. Meyer's petitioning addressing both questions makes it one stop, which arguably is a detriment as much as it is a positive, right? So that kind of cuts both ways. And there's really no answer to this question. You just have to make the decision. On the one hand, you're giving the court two things, but on the other hand, you're giving the court two things. You're giving them two ways to fix it, but on the alternative, you're giving them two ways to fix it. And if they decide one of the two ways isn't very good and they get lost there, then, you kind of screw yourself. There's no right answer to this question. I think my answer is superior because, veterans and all the rest of it, but a different attorney could very reasonably disagree. It's just like, what do you think is important? What don't you think is important? What are you willing to drop? What are you not willing to drop? Where do you want the shiny ball? This might make the court prefer Meyer's framing to avoid piecemeal. On error correction, the court generally doesn't grant just to fix an error. They don't. But the error for is manifest important, especially if multiple issues were wrongly handled. It can tip the scales. It could. Meyer enumerates two errors, wrong statute in USERRA and wrong outcome on ADA, perhaps making the case look more egregious overall. Yet, ironically, highlighting two errors can also make it look like the lower court's decision was uniquely problematic and thus may not be broadly relevant beyond the case. Mueller's approach makes it about a singular legal issue, which could be applicable beyond this case. The likelihood of cert thus could then depend on how the court views the breadth. Do they want to clarify just USERRA's reach, favoring Mueller's singular focus, or do they feel compelled to correct a multi-pronged injustice favoring Meyer's dual issues? Historically, the court might prefer a narrow question if it's truly impactful and leave the ABA fact issues alone. This is somewhat counterintuitive dynamic, means Mueller's one-question petition might have a shot if a justice was particularly moved by the USERRA issue alone and wanted to avoid the ADA muddle. But any justice who believes the USERRA question is cert-worthy could simply grant question 1 of the petition and deny question 2. That is true. They could, but you're asking the Supreme Court to make the choice for you. You're asking the Supreme Court to make the choice for you. The Supreme Court can rewrite the question presented. The Supreme Court can grant only part of the question presented. But you're letting them make the choice. I'm not letting them make a choice. Either accept it or deny it. Those are your choices, right? So, thus, Meyer's petition gives the court options, which is advantage, can be. Depends what you're trying to do. They could take the question on just the statutory question and ignore the rest. In contrast, Mueller's petition does not even present the ADA as an option. Yeah, I wasn't trying to present it as an option. I was deliberately trying to not present it as an option, based, of course, on the factors relevant to this case. That isn't to say that in a different case involving a different veteran, I might not make a different choice, because a different case would be fact-bound by its own terms, right? Of course, I had to make the decision based on this case. In a different case, I might very well raise both questions. In a different case, I might even choose to lean on the ADA, and the USERRA might be a secondary thought. Or maybe I just focus on ADA completely and drop USERRA. I don't know. But it's going to be bound by its own terms. So Did I make the right decision here is the real question. Did I make the right decision for this client and this case? That's the question. But, yeah. Supreme Court's interest in trends. Another subtle factor is where the case aligns with issues the Supreme Court currently cares about. The Robert Courts has not taken many USERRA or veterans cases in recent years. That's not really fully accurate. Well, depends what you mean by many. But there's been slightly more than you might otherwise expect. The most notable case was Staub versus Proctor Hospital, dealing with cat's paw liability in USERRA, which Mueller petition actually cites. Of course I did. That shows the court has weighed in USERRA when it involves a broader principle. Here the issue is more niche: accommodation obligations for service incurred veterans, essentially a hybrid of veterans law and disability law. It's certainly important to veterans and employers, but it's not a highlight-grabbing issue like immigration or religious liberty. Well, I mean, USA does go a far way. Both petitions try to elevate it. Mueller by connecting it to how we treat combat veterans with PTSD, Meyer by saying the Seventh Circuit approach undermines Congress's intent and hurts many people. Whether the court finds it sufficiently pressing is hard to predict. If anything tilts them, it might be the sense the Seventh Circuit sets bad precedent which could mislead other courts. On that front, Meyer's conflict angle and explicit mention of the Seventh Circuit endorsed the wrong framework might make a justice think we should stop it in before it spreads. Mueller's petition, while passionate, may make a justice think it sounds bad, but is any court doing this? Maybe we should wait. Yeah, that's fair. In summary, Meyer's petition likely has a higher chance of earning grant because it aligns more directly with the court's criteria. I mean, yeah, if you think you can make this Fifth Circuit, Seventh Circuit split work, if you can think you can make this work, but I'm not so sure. But, you make what you can out of what you have. So maybe he was able to take some, not great ingredients and make it look better than it was. Not invalid criticism. Not invalid criticism. I will absolutely 100% agree, as I've said before, that circuit splits are the number one way to get there. So you are strongly incentivized to try to find a way to make it work. So there is that, Mueller relies on importance in court sense of justice for veterans, which, though real, are less concrete. Yeah. Statistically, the odds of any cert petition being granted are quite low in the order of 1% to 2%. It's a little bit worse than that. Both the petitions face the steep uphill battle. But if one were to be granted, the analysis suggests it could be Myers. Fair. His petition checks the boxes Supreme Court texts like Stern and Grossman say you want to check. A clear spit or inconsistency. Nice. A clear error of law and broad ramifications. Mueller's petitions, while compelling, may leave the court unconvinced they need to step in now as opposed to letting the issues percolate. Fair. Therefore, Meyer's petition has a higher likelihood. Mueller could still appeal to justice's empathy and interest in veterans issues, but Supreme Court standards, it falls a bit more into a single court collection crest, which the court often denies. They aren't wrong. They aren't wrong. Yeah, if you can make the split work, yeah. Writing style and effectiveness comparison. Both petitions advocate for the same outcome. They differ markedly in writing style and rhetorical approach. A side-by-side comparison illuminates how stylistic choices impact clarity, persuasiveness, and adherence. Clarity and organization. Meyer's petition is organized in a straightforward, formal manner. Perhaps a little overly so, but fair. It opens with two numbered question presents that map onto two argument sections. Fair. Each argument section has a descriptive heading telegraphing the point. This one-to-one mapping between question presented argument makes the petition easy to navigate. Not incorrect. Mueller's petition also has a logical structure but of a different kind. It features a separate introduction, then statement of the case, then a multi-part reason for granting with subsections A, B, D, and C, and D. The subheadings in Mueller's brief are phrased as persuasive statements. The stipulated facts make a good vehicle. The manifest intent of Congress was usurped, which conveys his point as a glance. Both approaches have merits. Mueller's granular breakdown might be slightly more complex to follow. One has to synthesize A to D to get the picture, whereas Meyer's is more linear. In terms of clarity, Meyer's style is somewhat more direct. The reader knows there are two big issues and each is handled in turn. Mueller's style provides signposts that breaks the issues into facets, which can aid comprehension of each facets, demand the reader integrate them. That's, pick your poison on that. Which one do you like better? For a time-pressure reader like a justice's clerk, Meyer's clarity in saying, here's issue 1, here's issue 2, could be more immediately graspable. Mueller's introduction separate points, however, might make for a more interesting narrative, particularly engaging a reader who might have time to delve. Ultimately, Meyer's organizational hues more to strictly cert brand formula, which might make it easier. Conciseness and detail. In terms of conciseness, Mueller's writing sometimes leads to verbose and detailed, as explained in his PTSD section. He includes lengthy quotations from studies and even block quotes of email evidence and trial findings. Meyer's writing, which has long sentences and question presented, is actually fairly tight in the argument. He explained legal issues without digressing into evidence minutiae. Yeah, but the evidence minutiae I brought up was like all for a purpose, obviously, but because I want to make Vala look like dicks and make PTSD look really important, but fair. For example, Myers mentioned Valva's strict policy and how the client failed to meet it in order to explain the ADA ruling, which I think is a mistake stylistically, but he doesn't quote the policy verbatim or dwell too long on it. This difference reflects stylistic choice. Mueller seems to be building a record and atmosphere, almost as one would in a merits brief, while Myers is later focused on the legal principle. Many experts, including in making your case, advise that brevity and focus are the key to persuasive legal writing, eliminating extraneous detail that doesn't serve the immediate argument. By that measure, Myers' style is more effective. He includes only those facts necessary to set up the legal issue. Mueller's richer detail might give a fuller story, but the risk of testing a reader's patience or obstructing the core argument, or obscuring the core argument. For a Supreme Court where cert stage cares more about questions of law, Myers' economy with factual detail makes it more persuasive. You're not wrong. You're not wrong for saying that. And what I wrote is more like a merits brief than a strict writ brief. Includes definitely more elements that are more merit warranted or more to the merits warranted, as opposed to hyper focusing on a legal issue. But it's like you have to make a decision, and Myers' decision might make more logical sense. He has better segregation between the petition and an eventual merit stage. So whether that's a strength or not, I suppose, is in the eye of the beholder. But his is more traditionally focused on strictly the legal issue for the cert petition. So you're not wrong. Use of headings and tone in headings. Both petitions use argumentative headings, but Mueller's are slightly more traditional in a cert petition, shorter and focused on the reason to grant. Myers' heading for argument 1 is extraordinarily long. Such a long heading is unusual and can be cumbersome. It packs in a comparison. Yeah, the heading isn't supposed to be short or isn't supposed to be long. The heading is just like basically 5 words or so. And you just keep it short, man. It's just a heading. Like 5-10 words. Damn. I mean, yeah. Such a long heading is unusual and cumbersome. It packs in a comparison of USERRA and ADA and essentially states the conclusion that a employer should be held to USERRA standards. While it's good the heading is informative, it might be too much information all at once. I mean, it's just the label, man. Headings are meant to guide the reader. If they're too lengthy, the reader might skip them or find them hard to parse. Mueller's headings is an example of sharp, impactful heading. It conveys fact and relevance in a terse way. In general, Mueller's headings are punctured, while Myers are heavier. This reflects in writing style. Mueller often makes his point with emphatic short statements, sometimes even with a bit of flourish or emotional weight, whereas Myers tends to make points through logically dense statements. Depending on the reader, one or the other might be preferable. A justice who likes quick bullet points might favor Mueller style. One who likes step-by-step legal reasoning might favor Myers. Legal citations and authority. Myers' petition cites many legal authorities, cases, and statutes. For example, he cites Staub, a Supreme Court case on USERRA motivating factor causation, and the text of the law. Mueller's petition also cites cases, but where it stands out is the citation to secondary sources and facts, such as medical journals and VA statistics. In terms of Supreme Court norms, petitioners typically lean on legal authorities to show conflicts or errors, rather than bringing in lots of outside data. Mueller's law review article or trial brief rather than Supreme Court filing. It might give a impression of a law review article or trial brief. Well, not forbidden, this could be stylistically off key. Conversely, Myers' reliance on statutory text and precedent is exactly what the court expects. A demonstration lower court's decision cannot be squared with statutory language or how courts traditionally handle effectiveness. In effectiveness, Myers' use of authority is tightly tied to the argument. Mueller's use of authority has dual nature, part legal cases and part factual. Legal parts are effective. No one can dispute the Supreme Court's own guidance that veterans' laws be liberally construed. The factual parts, while informative, may be less persuasive to a court that deals in law. After all, justices might think it's Congress's job to consider such data and interpret the laws as written. On balance, Myers' more orthodox story lies where weight and failure. Yeah, I mean, not invalid. I mean, that's a reasonable take, and it is what it is, and it's not an invalid argument. So persuasiveness and emotional appeal. Persuasion can be logical or emotional, or ideally both. Mueller's writing is more emotionally charged. He uses phrases that invoke fairness and moral duty, complete disregard to service for her country, severe detriment of veterans. He paints Volvo's actions of the court's rulings as a stark injustice to a veteran who answered the call of duty. This pathos can be persuasive by creating a sense of outrage or sympathy. Meyer's writing is more clinical. He certainly implies unfairness, calling it injustice, and noting substantial prejudice, but most of these arguments proceed in a dispassionate, lawyerly tone. For example, he states both the District Court and the Seventh Circuit decide this case both based on the ADA, not USERRA, which must be reversible error. This is calm and declarative. It appeals to logic. If they use the wrong law, the decision might be wrong. Mueller might have phrased it that more vehemently. In fact, he used terms like erroneously, inexplicably limited, reversible error in a more charged manner. The effectiveness of these styles can depend on the justice. Some justices appreciate a passionate advocate, others prefer a more restrained approach and let the facts speak for themselves. Generally, at the search stage, showing such passion can help signal a case is important, but too much might seem like manipulative. That's not wrong. Meyer likely judged the gravity of the veteran losing her job due to service-incurred PTSD speaks for itself once legal error is shown, hence he didn't amplify the emotion. Mueller didn't leave it to chance. He made the emotional case explicitly. In the written style, Mueller's petition might grab a reader's heart, while Meyer grabs the reader's head. Ideally, he wants to do both. On that score, Mueller might actually be more memorable. A clerk might remember the vivid statistics or a sense of injury conveyed. Meyer's argument might be more convincing on a strictly intellectual level, leaving less room for counter-argument. But, I need them to care. I need them to care to grant the case. So, like, intellectual can be fine, but it is. I find it funny that I'm the more emotional one between the two of us. That strikes me as very funny. Adherence to Supreme Court norms. Meyer's style is more in line with Supreme Court decorum. His petition reads like a professional appellate brief aimed at the high courts. Respectful, sticks to the record and law, and doesn't use gimmicks. Mueller's, being a bit more rhetorical and innovative with its heavy PTSD court, takes more stylistic risks. Some norm issues were noted. Meyer's labeling arguments instead of reasons, Mueller including introduction and motive language, unusual but not unheard of. Neither crosses any line of propriety, but Mueller pushes the envelope slightly more. Fair. On balance, Meyer likely left the petition impression of a seasoned Supreme Court petitioner's work, while Mueller felt more like a passionate trial or circuit brief adapted for the Supreme Court. Not an invalid point. I mean, not invalid. I mean, that's fair. Persuading the Supreme Court often requires a certain elegant understatement. Fair enough. Make your case confidently without appearing desperate. Meyer's tone largely achieves that, aside from possibly overwrought wording. Mueller's intensity could have skeptical come off as pleading. Fair. In summary, Meyer's writing is more methodical, legally rigorous, and measured. I don't think it's necessarily more legally rigorous. I think I have lots of citations, although I do focus on things other than strict law. I do focus on other issues relating to, the veterans and stuff. So I think my argument is plenty legally rigorous. Thank you very much, ChatGPT, which aligns well with the expectations of Supreme Court review. Mueller's style is impassioned, comprehensive, and advocacy forward, which can be seen as compelling, but runs a risk of seeming less objective. Fair enough. Meyer's petition might be seen as more effective in a technical sense, clear issue presentation, rule-based arguments, professional tone, while Mueller is effective in a narrative sense, driving home why the court should care deeply about injustice. Each has its persuasive strengths. However, if the goal is to maximize the chance of a cert grant, the conventional wisdom favors Meyer's more restrained and conflict-focused style. As one scholarly commentary put, the Supreme Court looks for splits and values clear legal questions. An advocate's job is to make the justice's decision to care about the case as easy as possible. Meyer's stylistic choices more directly serve that end. Fair. After examining both petitions and gents, the overall recommendation is that the Meyer petition is better suited to address the interests. While both petitions have admirable qualities, Meyer's version is more likely to secure a grant ultimately and vindicate the client's position. Meyer's petition more closely aligns with Supreme Court criteria. It explicitly identifies a conflict. Again, they're making a lot out of this. I mean, I think there's a lot more. I think there's not as much there as he thinks there is there. But, and ChatGPT wouldn't know. ChatGPT doesn't know how much is or is not there. ChatGPT just knows the person is saying there's a lot there. But how much is actually there? How much can you actually make of this? And I know, again, it's not wrong to try to make more out of it than what it is, but, that comes with its own downsides too. Because, if they catch you doing that, that can be a problem too when it comes to credibility. So, there's a lot of strategic and tactical decisions you have to make, and there aren't necessarily right answers. There's just trade-offs. There are no answers. There are only trade-offs. Mueller's petition, in contrast, pitches the case mainly as important single-circuit error, a harder sell. For the client, the paramount objective is to gain the Supreme Court hear the case. Meyer's approach maximizes the chance by checking the circuit split bot and underscoring national importance. The strategic positioning could be the difference between the court reviewing the case or not. No matter how meritorious the petitioner's argument, they can only help the client if they first agree to review the case. And that was always going to be our weakest problem. Getting the Supreme Court to say yes was always the big problem. It's like, even if you can manufacture a split here, yeah. Meyer's petition simply does a better job of overseeing why I should hear the case. Meyer's handling of the issue presents a potential pitfall and prevents potential pitfalls and preserves all the arguments. By including the ADA question, the petition ensures that the court does take the case, it can fully remedy the situation. As discussed, Mueller's admission of the ADA issue could live with a partial win, with the error corrected but the ADA loss intact. Yeah, I am sacrificing the ADA issue. I am sacrificing the issue. And then you have to just decide, is that the right decision or not? Is it the right decision to sacrifice it or not? Ask 5 lawyers, get 7 opinions. You know what I'm saying? From the client's perspective, Meyer's petition is more protective of her victory and invites the court to reconsider everything that cost them to lose the Seventh Circuit. Even if the court were only to grant the USERRA question, having the ADA on the table gives them more flexibility. For instance, the court could decide to summarily reverse. There is no chance in this world that's going to happen. You are dreaming, ChatGPT. And remand on the ADA issue for reconsideration. Mueller's position would not have allowed for that. In essence, Meyer's position leaves no aspect of the case behind, which is advantageous for the client. Well, it might be. It might be advantageous. You have to decide. You have to make a decision. You have 10 issues. How many do you raise? There are no right answers. There are only trade-offs. If you have weaknesses, it can pollute the entire thing. Weak things tend to make strong things weaker, not the other way around. Weak arguments make strong arguments weaker. Kill your darlings, and so forth and so on. So you got to make choices, baby. You got to make choices. And the ADA feels like, and the USERRA feels like the better thing to do. Because the USERRA gets me everything ADA does, right? Because I can do everything in ADA. I can do everything in USERRA that ADA does. Having the ADA as a separate cause of action doesn't really do me anything. I'm not really losing anything. I mean, because I can kind of do anything that the ADA would allow me to do inside USERRA. The ADA doesn't really get me anything. The only thing the ADA arguably gets me is more case law, because there's a lot more case law interpreting the ADA, but I can import that into the USERRA context because I can just kind of borrow it. So I don't really feel like I was losing very much, but different lawyers would disagree and so forth and so on. The writing and tone of the petition, of Meyer's petition, likely inspires greater confidence. The Supreme Court, and particularly the clerks, must often sit through the chaff through thousands of petitions. A polished, well-reasoned petition like Meyer stands out positively. It established credibility from the cover page through conclusion. The inclusion of experienced counsel details and the use of a DC printer signals it's a more serious effort. That's fair. The fact that they used a printer, and I wouldn't have used the printer because I wanted to save my client like $5,000, I wouldn't have used a printer. I wouldn't have used the traditional printers. I'm not required to. But would that alone have presented a problem? I mean, is it worth the $5,000 in order to have that stamp on the bottom of the page? I don't know, man. Signals this petition is a serious effort, not a pro se or fly-by-night request. This matters for client because a credible position means the court will treat the case with attention it deserves. Mueller's petition, while heartfelt, has the hallmarks of a draft and some unconventional elements. There is perhaps unfairly reality. The style and presentation can affect how petition is perceived. That much is 100% true. That part cannot be denied. How it's presented will absolutely influence how it's perceived. No doubt. Perception is reality, my friends. By choosing Meyer's approach, the client puts the best foot forward in terms of judicial receptions. As an analogy, Mueller's petition is like a passionate oral argument, while Meyer's is like a concise bench mover. The latter similarly likely move decision makers in this case. Meyer's petition still captures the essential justice of the cause, but in a way the court finds palatable. It's ultimately better for the client that the petition not only make an emotional plea, but on the grounds of the plea as solid reasoning. Meyer does invoke injustice in the plight of veterans. He does so by closing references to a large swath of veterans. So he's not ignored the human element. He merely balances it with strong legal foundation. This balance is likely to be more persuasive. Some justices might be inclined to take the case out of concern for service members' rights. Others might do so for legal misinterpretation. Meyer's petition caters to both. Mueller arguably is tilted more towards the former. To best serve the client, you want every possible vote among the 9. Meyer's petition is better positioned. It may well be. It may well be. If granted, Meyer's petition provides a clear roadmap for writing on the merits. Looking beyond the cert stage, suppose the court takes the case. Meyer's framing of the question is such that a ruling in their favor would likely be broad and unequivocal. That the law must be applied when the service member has a service-related disability, and excluding evidence of such disability was error. This could set precedent that directly benefits the client and similarly situated plaintiffs. Mueller's question, while aiming for the same end, is phrased a bit less elegantly, which could lead to a narrow decision or some ambiguity. I mean, a narrow win for my client is still a win. Anything to win, man. And also, I'm not asking the Supreme Court to do as much, which is also at least a benefit. Like, I'm asking the Supreme Court arguably to do less, and that might make it more appealing than asking them to do more. Like, a narrow win for my client is still a narrow win, man. A narrow win at the Supreme Court's a win, baby. You know what I'm saying? So by narrowing it down and keeping it simple and focused and tight, I keep their eye focused on the ball and arguably don't ask them to do as much at the end of the day. So, this is easy. This is easy. This is a layup. This is simple. Just a little win. Just a little tiny win. Little tiny win. If you don't mind, for uncivil would be nice. For example, his focus on evidence, which if theory, could allow the court to simply say PTSD evidence should be considered without fully addressing statutory interpretation, which, it's still a win. I'll take it. Meyer's presentation makes it clear the law itself, which the provision applies at stake, which sets better for strong precedent. And serving the long-term interest, not just getting cert, but winning the case, the petition sets the stage more effectively for a robust decision. In conclusion, Meyer's petition is recommended as a superior choice. It's more likely to be granted, comprehensively covers the claims, does so in a polished, authoritative manner that adheres to Supreme Court norms. Meyer's approach strikes an appropriate balance between legal argument and highlighting real-world stakes, thus maximizing appeal to the law's sense of justice. In contrast, while Mueller's petition admirably covers passion and poor of the case, it falls short on technical criteria, like the inter-court conflict. I mean, the ChatGPT is giving a lot of weight to this conflict, man. The ChatGPT is really latching onto this conflict, man. They are really man, this is the thing, man. It's okay, if only Mueller's petition were available, the case might still have a chance. The fundamental issue is strong, the story is compelling, but with Meyer's enhancement, the case for certiorari is made stronger. Therefore, to benefit the client, the petition is the best vehicle for seeking redress. Adopting the strategy gives the best shot at securing the Supreme Court's attention, ultimately a favorable resolution. So, how much do you really think there's a Fifth Circuit split? So I guess we can read it and see what he said for the circuit split. What is he trying to do to get to the circuit split? Because that is sort of where the thing is where is this circuit split really happening? What are you trying to make? What split are you trying to make happen? Let's see if we can make this. Let's see if he makes this circuit split happen. So let me find the right part of the decision. Oh, he doesn't really talk about it. Oh, that's weird. Hold on. Let me put it on screen. Let's see where he talks about this split. So he talks about the statute, talks about the Seventh Circuit, requires employee compensate, employee blah, 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 district court below, Seventh Circuit, blah, blah, blah. Trial court overlooked plain language, more specifically to statutes, servicemen enabled. By contrast, the statute, blah, blah, blah. District court read out the thing, 7-point part of the error, allowed to refuse in the then. Put differently, does not mandatory training, stay in our way, it does not require. Moreover, 7th Circuit in this case conflicts with the court's decision in Torres. Okay. Okay. I'm not sure that it does, but yeah, all right. And I believe I cited that case. 7th Circuit shuttered the federal circuit courthouse doors to claim for, by contrast to Torres, this court reversed and remanded reopening of federal courthouse doors to bring a claim should be afforded the same protection. A split between the 5th and 7th Circuits, but you just cited the U.S. Supreme Court. So is there a circuit split, or do you think that the Supreme Court mandates this? So where's the 5th Circuit case that you think there's a conflict? You don't actually cite the 5th Circuit case that you think there's even a conflict with. If you think it's Torres, you think the Supreme Court spoke to that. So, like, what are you talking about? Blah, 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 blah. 7th Circuit adopted, 7th Circuit decision. Lower courts have recognized this. Substantial protections. Claim must adversely impacted. Veteran during tenure. Employees are subject to attendance. I wouldn't talk about that. Ultimately, they filed. Initially, district court. Did some 7th stuff. 7th Circuit. Blah, blah, blah. Then moved for judgment. District court held a second trial. Motion to reconsider. 7th Circuit afforded. Also notably with respect to a new trial, contested district court refusal, 7th Circuit, some other stuff. Specifically, district court didn't evaluate 4313. Both trial judge and 7th Circuit missed the dispositive analysis. 4313, both district court and 7th Circuit. While district courts throughout the 5th Circuit allow evidence of disability pursuant to 53 under 3. You don't actually cite any cases. You just say it's true. You just say district courts do, and you don't actually. Are you trying to create a circuit split between like one 5th Circuit district level case and the 7th Circuit case? Is that where you're trying to create a circuit split? Because you don't actually cite the case. You just say district courts throughout, and you don't actually cite which district courts. You don't even cite the district courts. Are you trying to create a circuit split between the 7th Circuit and random district courts in the 5th Circuit? That doesn't work. I mean, you can try, but it's not the same thing, man. You know? It's not the same thing. The ADA prohibits some bullshit. Okay, now they're going to talk about the ADA, which I completely ignored for tactical reasons. So, yeah, he's going to spend part 2 of his brief talking about the ADA, which I didn't talk about for strategic reasons. And then he says this, and then, like, he talks about the ADA, some stuff, and talks about nearest approximation, any disabling condition, disability, not necessary, disability, what happens, noted, La Usera, blah, 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 blah. And then there's nothing. There is no circuit split. There's no circuit split. He's just making it up. He's just making it up. And he doesn't even cite, he just says, oh, district courts throughout the 5th Circuit would say this, but he doesn't actually cite any 5th Circuit case at all. There's no 5th Circuit citation. How do you create a split with the 5th Circuit without a 5th Circuit citation? Even if you're going to try to cobble some district court decisions and say that's the same thing, where's your citations to the case? Where's your citations? There's no citations. You're just saying there's a split and you don't actually say it. You cite a case from Pennsylvania talking about the 5th Circuit. Okay, that's nice. You talk about fish gold. I talked about fish gold. You talked about this escalator position. That's fine. You cite Torres. You cite Torres, but Torres is a Supreme Court case. What are you doing? Are you trying to create like a split? What are you doing here? His brief is a lot shorter. So his brief is a lot more focused and just in pure law, whereas mine is definitely more emotional appeal. So I'll give him that credit. But this 5th Circuit, what? this is weird. Torres v. Department of Public Safety. And then Torres is your Fifth Circuit case. All right, did I even cite Torres? I didn't cite Torres. That's interesting. So yeah, okay. So he at least cited a case that I should have cited, so I'll give him that point. But I think he's creating more of a split than is there. So yeah, all right, fair enough. What is this Torres case, incidentally? That he's even, what is this case? Let me take a look at this. Go to Scholar and take a look at this. Okay. 597 US 580. What is this thing? No, go fuck yourself. Go fuck yourself. Torres deals with a completely different issue. Fuck off. And if you think the distinctions in the Fifth Circuit case, what is the Fifth Circuit case that this is a case of? Yeah, this deals with sovereign immunity. This is some bullshit. This case, I didn't cite this. No wonder I didn't cite this. This case is some bullshit. I wouldn't have been wrong for me to cite it, but I'm not going to base an entire brief off of it. At best, it's a throwaway citation. It's a see also, this case, I wouldn't have based anything off this bullshit. What the fuck is this? And if you're basing it off the Fifth Circuit's decision, they ruled on sovereign immunity grounds. They didn't raise this issue. I don't like any of this bullshit. This is some bullshit. Let me show you what's going on in this bullshit case. All right, let me just show you what's going on in this bullshit, because I don't agree with ChatGPT, and I don't agree that there's a split, and I don't agree with any of this bullshit. There is no split, and it's bullshit to argue there's a split. All right, so let's talk about what's going on in this case. Okay, we turn our attention to the U.S. Supreme Court of Leroy Torres versus Texas. Supreme Court decided 2022. Okay, this is the case he wants to use and be like the Supreme Court's. He wants to say this: the Seventh Circuit is disobeying the Supreme Court and Fifth Circuit and blah blah blah. Ooh, exciting! I mean, oh, that's fun. Okay, and incidentally, by the way, for what it's worth, this is on a writ of certiorari to the Court of Appeals of Texas. It isn't even out of federal law. So it's not even a what Fifth Circuit case are you It's not even a Fifth Circuit case. It's a case out of Texas State. It's a case out of a Texas State decision. It wasn't a Fifth Circuit case that was appealed. It's not a Fifth Circuit case. There is no Fifth Circuit case. You're trying to manufacture a circuit split based on a state court level decision. What the fuck are you doing? You're trying to manufacture a circuit split based on what a state court in Texas did? What the fuck? What the fuck? All right. So anyways, this isn't a Fifth Circuit case. It says so right here. This is a writ of cert to the Court of Appeals of Texas, not a writ of cert to the Fifth Circuit. What the fuck? All right. So anyways, okay. So our friend over here, petitioner, enlisted in the Army. He was called to active duty and deployed. He was exposed to toxic burn pits and garbage and shit. Okay. Then he returned home and it left him unable to do his job as a state trooper. So he asked his former employer to accommodate him. Texas said, go to hell. So he sued under 4313, Texas dismissed, tried to invoke sovereign immunity. They said, you can't sue us, right? You can't sue us. He's a state trooper. He's a state trooper, and he's suing Texas for under USERRA, but he's suing him in state law. You can do that. You can sue under federal statute and state law. You can do that. So he's suing in state law, say, give me a job. Texas says, I can't be sued. Texas doesn't say, Texas doesn't say we didn't discriminate against you. Texas doesn't say you weren't disabled. Texas simply says, I can't be sued. Go to hell. Okay? Texas invokes sovereign immunity. So then, there's some discussion about that, about waiving a sovereign immunity. And the Supreme Court says, basically, go to hell. By ratifying the Constitution, the states agreed sovereignty would yield to national power to raise and support armed forces. Congress may exercise the power to authorize private damages against non-consenting states. And so basically, this all boils down to sovereign immunity. This is a sovereign immunity decision. Can I sue the state of Texas for not accommodating me? And they're like, yeah, you can. This has nothing to do with 4313 or 4311. This has to do with, can I sue Texas at all? Under 4311 or 4313. Now, whether or not he has a good cause of action under 4311 or 4313, yet to be decided. Also, incidentally, by the way, the Supreme Court didn't decide more than that. They didn't say, oh, he has a good cause of action. They simply said, yeah, you can sue. You can sue Texas. Whether or not you have a good cause of action, who knows? But, you can sue. And so then okay, then they're dealing with, whether or not I can sue and armed forces and the power of the armed forces. And we have the power to maintain the military and blah, blah, blah. And, USERRA overrides the states. So you can sue the state of Texas or Volvo, reverse and remanded, end of discussion. Why do you think I didn't cite it? Why didn't I cite this decision? It's Supreme Court. Why ever didn't I cite it? Because it has fuck all to do with anything I'm talking about. It has fuck all to do with anything. I'm suing Volvo. They're a private entity. I don't need to talk about sovereign immunity. Volvo isn't sovereign last time I checked. This isn't from the Fifth Circuit. This is from state level courts in Texas. He sued in state courts using federal law. This isn't a federal court decision. There weren't federal courts before the Supreme Court got involved. There's no federal court involved. There's no Fifth Circuit split. There's no split in this case. There's no split. No wonder I didn't cite it. This is some bullshit. Your brief is bullshit and full of lies. Your brief is full of bullshit and full of lies. Where else did you talk about the Fifth Circuit in your bullshit brief? Okay, yeah, you say the district courts in the Eighth Circuit appear to apply 23 consistently with district courts in the Fifth Circuit. You cite Torres. That's the case we just read. You say district courts in the Eighth Circuit appear to apply 2313 consistently with courts in the Fifth Circuit. You cite Torres. Torres wasn't a Fifth Circuit case. It wasn't even a federal case, you fucking idiot. It wasn't a federal case. Then it went to the Supreme Court, but it wasn't a federal case. Fuck you. All right. Goddamn. And then it's district courts throughout the Fifth Circuit. You know what? There's not one goddamn citation. He says district courts throughout the Fifth Circuit will allow evidence of disability. You know what I'd really like at the end of that sentence? You know what I'd really like? I'd like some citations. If he has some citations to some Fifth Circuit cases, even district level cases, I'll take them. Where are my Fifth Circuit district cases? Are there any? Are there any Fifth Circuit district cases, or are you just making up shit? There's not one goddamn citation. So I think you're just making up shit. I don't think there are any cases. Fuck you. It wouldn't happen in district cases with the Fifth Circuit. Why? Because you say so? Because you say so? Because of all those Fifth Circuit cases you cited? Where are your Fifth Circuit cases? It wouldn't happen in the Fifth Circuit? How do you know? Your Fifth Circuit, where are your citations? Do you even cite any Fifth Circuit cases at all? How many cases do you have that are in the Fifth Circuit? I'm going to go to your citations. How many cases do you actually cite that are in the Fifth Circuit with this magic split that you'd like to manufacture out of fucking nowhere, you fucking asshole? Let's see. Torres, well, that was U.S. Supreme Court. We read that, wasn't federal. 7th Circuit, U.S. Supreme Court, no. 8th Circuit, no. Eastern District of Pennsylvania, not in the 5th Circuit. District of Nebraska, not in the 5th Circuit. U.S. Supreme Court, Fishgold, I cited that. 7th Circuit, 7th Circuit. He doesn't have one goddamn citation. He doesn't have one goddamn citation in his entire brief to anything in the 5th Circuit. There isn't one goddamn citation. Not one. Not one. There's not a district court. There's not one goddamn district court in the. He doesn't have any citation. And he wants to manufacture a fucking circuit split off of what? Fucking wishes? Because of some state level court. In one case, the Supreme Court said, oh yeah, sovereign immunity, which has nothing to do with the substantive issues at hand. Fuck you. Fuck you in your brief. And fuck you, Chappie TT. There's no fucking circuit split. Fuck off. God fucking damn, I'm competent. I know what the fuck I'm reading. This is a fucking bullshit. Fuck off. Not one goddamn citation to any decision in the 5th Circuit. Not one and he cites what? 1, 2, and by the way, he cites his own case, which is fine. So we don't count that one because that's just the case that we're talking about. So in terms of actual cases, he's got 1, 2, 3, 4, 5, 6, 7. He's got 8 citations, one of which is what's wildly off point. And most of the, I fishfold in some other bullshit and not one 5th Circuit case to be found anywhere. Fuck you. Not even one citation. Not one. Not one. What circuit split? Fuck you. Fuck you. So as I was saying earlier, I lacked some of the traditional factors that you look for from a U.S. Supreme Court case. I couldn't really find any circuit splits. That wasn't really good. And there weren't really a lot of cases that talked about it at all. So I kind of had to cobble together what little I could to try to make the issue with some authority that I could have and try to make what I had work with the citations I had. And then, because I didn't really have the circuit split thing, this case isn't really a case of unique national importance. It's really not, nor is it a case of anything else. So I sort of had to, do my best to kind of manufacture a grounds. I had to sort of manufacture grounds to make it seem more important than, it otherwise would be. So seeing as I couldn't do that in pure legal analysis because I didn't really have it, I didn't have it in the pure legal analysis. It simply wasn't there. There are just not a lot of cases. And I read, I think, everything that's ever been written about this. I think I read all of them, like all the citations. There's some veterans groups out there. I went to some veterans groups and some of them write law reviews. I read every single one of them. I read lots of shit. And I read dozens and dozens and dozens and dozens of things trying to find anything. So I cobbled together what little I could. And then, I tried to basically elevate the case by trying to, first of all, what I did is twofold. First of all, I tried to show that it was in conflict with prior U.S. Supreme Court decisions to the best I could by citing a lot of decisions basically saying, veterans are great and all the veterans are wonderful, and trying to show that Congress and the courts have been trying to do this for a long time, and trying to show that, that they weren't liberally interpreting it. So I tried to show conflict with the U.S. Supreme Court, and at least I was able to show conflict with the U.S. Supreme Court because my decisions were fucking talking about veterans and liberally interpreting statutes and stuff rather than some sovereign immunity bullshit. So I didn't cite the sovereign immunity bullshit, but I did cite some cases dealing with, the fact that, it's to be liberally instrued and we're supposed to protect veterans and stuff. And so I cited all that. And I cited the congressional record and cited, statements from members of Congress. And I cited, the CFR, cited Department of Labor, or Department of Labor, Department of Veterans Affairs. I cited basically every authority that I could, trying to cobble things together. And it basically still wasn't enough on top of that. So then on top of that, it's like, well, what am I going to do? On top of that, I guess what I'm going to do is just try to lean into the fact that this affects millions and millions of veterans. And it's not just about my one client. And I'm going to talk about veterans, and I'm going to talk about PTSD, and I'm going to talk about how this is a major issue and talk about that and try to fill out, my brief a little bit with some of that other discussions so I can appeal to, the veterans. And, and also I'm going to drop the ADA thing because I can't really get anywhere with the ADA. And to the extent I could get anywhere with the ADA, I can get everywhere I need to be with USERRA anyway, because USERRA at least gives me as much protection as the ADA, so I don't really need the ADA. So I'm sacrificing, at least in my humble opinion, not much, and forcing the Supreme Court arguably to focus on the veterans issue, which is where I want them to focus, in what I think, although perhaps awkwardly worded, is a cleaner presentation of the case. And, trying to make, I think, a thorough, logical, reasoned legal argument, albeit with perhaps slightly more inflamed language than perhaps strictly would be advisable. So perhaps I should have written with slightly less aggressive, slightly more tame language. Perhaps I should have filtered a little bit more, should have toned down some of the language, but that's an easy fix, right? Just to tone down some of the language and make slightly less aggressive word choices. It's just an edit here, edit there to make it slightly less aggressive. And, other than that, I think I did good. So, and I think this guy can suck my balls. That's what I think. Thank you for coming to my TED Talk. This guy can suck my balls. Thank you for coming to my TED Talk. The worst that could be said for my brief is that I leaned on the flag too much. And I could have toned it down, but I kind of, yeah. And it's not as dry as his. That's sure. His is definitely written more white shoe. I could have toned down my language, but he can fuck off right with this. Yeah, you think there's a circuit split? There's no fucking circuit split. Fuck off. Fuck you, ChatGPT. Fuck you for thinking there's no circuit split. Fuck off. One of the many reasons ChatGPT is not a substitute for a lawyer. I'm proud of my work, God damn it. I'm proud of it. And, yeah. Anyone else want to talk about anything else? Should I measure my blood pressure now? Probably not a real good time to measure my blood pressure. But it's probably a little high right now, could be a little higher. Yeah, we can, the tone is easy to fix. S-home, the tone is easy to fix because you're just talking about fixing a word choice here or there. You're just talking about some very subtle edits to tone it down. It's very easy to tone it down. You're just talking about changing a word choice here or there. So if you want to tone this down, no problem. You can do this easily. But he's like, oh, there's a Fifth Circuit split. And I'm like, you can suck my ass. No, there's not. Fuck you. Please read your question. Okay. What was your question? AI makeup steps. I fight with ChatGPT. Yeah, well, it's not just ChatGPT that makes up stuff. The attorney that wrote the brief made up stuff. He made up a circuit split that doesn't exist. I think I want to go work out now. I want to go lift some heavy weights and make the pain stop. I'm a good attorney. He fooled ChatGPT. He certainly did. He certainly did. He fooled ChatGPT. Yeah. Be careful you don't try and lift more than you should. Fair enough. Well, my friends, I'm going to go ahead and end this stream. What do I think of Brennan making a big deal of ARCA payments? I mean, come on. I mean, I think the whole thing is some bullshit. With respect to the Commonwealth being accused of paying off people, I don't know what's true about that, but the whole ARCA thing is dumb, and we'll have the dumb. The dumb is tomorrow. Yeah, what about the Fifth Circuit? What about the Fifth Circuit split? Casual, you can fuck right off. You can fuck right off. What about the Fifth Circuit? You can fuck right off. There's no split. Fuck off. It doesn't exist. It doesn't exist. All right. Thank you. You sent 2 Ko-Fi messages. Well, thank you, Anne, for your 2 Ko-Fi messages. I do appreciate it. Thank you for your Ko-Fi stuff. I do appreciate that. You just want to retype what you said because I don't want to pull it up in Ko-Fi. But what were your messages, and I'll respond to them to make sure I give them their due. Yeah, This guy can suck my legal balls, and the Fifth Circuit and ChatGPT can suck my legal balls too. Yeah, fake split. Yeah, fake split. Miss kickball? I did miss kickball. I missed kickball for you guys. That's okay. I'm gonna lift something instead and call it a day. I like my writing. Did you want to type what you typed before, Anne, or no? Because I'm just waiting on you at this point. If you don't know what you typed or you didn't want a response, that's fine. I'm just trying to give you the due. Your writing is far superior than the dry toast crap of that other attorney. I'm writing. It's fiction. Fair. I'm a good attorney. It's not quite white shoe, but then again, I don't like a lot of white shoe writing. I find it overly dry and overly banal. So yeah, the white shoe writing. There are points of critique, and perhaps I could use some more of it. But the white shoe upper crust law firm stuff can be okay sometimes, but sometimes it just comes off as really, really dry. And there's a line to be had, and you could argue that I'm too far the other way. You could argue that I'm too extreme, but whatever. All right, I'm gonna go ahead and sign off. I've been Uncivil Law. I will see you tomorrow. Go ahead and like tomorrow's stream. I will see you tomorrow. Have a good day. Bye. Lame.